ಕೋರ್ಟ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದೀನಿ. ನಾನು ಇರ್ಬೇಕಾ ಬೇಡವಾ ಅಂತ ಅಷ್ಟೇ. ಹೌದಾ? ಅಲ್ಲ, ನಾನು ಕೋರ್ಟ್ ಕಮಿಷನರು, ನಾನು ಹಾಕಿದ್ದು ರಿಪೋರ್ಟು. ಪಿಟಿಷನರು ಅಡ್ವೊಕೇಟ್ಸು ಅಲ್ಲ, ಆ ಥರ ಏನಿಲ್ಲ. ಹಂಗಾಗಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಅದಕ್ಕೆ ನಾನು ನಿಮ್ಮನ್ನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಇರ್ಬೇಕಾ ಬೇಡವಾ ಅಷ್ಟೇ. ಕಾಪಿನೂ ಸರ್ ಓಕೆ. ಕಾಪಿ ಇಬ್ಬರಿಗೂ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ. ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಫಸ್ಟ್ ತಗೊಂತಾರ, ಲಿಸ್ಟ್ 1 ತಗೊಂತಾರ? ಒಂದೇನಾ?
ಯು ವೇಟ್ ಫಾರ್ 1 ವೀಕ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. 1 ವಾರ ವೇಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಯು ವೇಟ್ ಫಾರ್ 1 ವೀಕ್, ಮಂಡೆಯಿಂದ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಐ ವಿಲ್ ಸ್ಟ್ರೀಮ್ ಲೈನ್ ಇಟ್ ಅಂತ ಮೇಡಮ್ ಹೇಳಿದ್ದಾರೆ. ಅದು ನೀವು ಮಂಡೆಯಿಂದ ಸಬ್ಮಿಟ್ ಮಾಡಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಲಿಸ್ಟ್ 1 ತಗೊಳ್ತೀರಾ ಫಸ್ಟ್, ಲಿಸ್ಟ್ 2ನ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್, ಹಲೋ ಕೇಳಿಸ್ತಿದೆಯಾ ಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್. ಮೇಡಮ್ ಲಿಸ್ಟ್ 1 ಲಿಸ್ಟ್ 2 ಫಸ್ಟ್? ರೆಡಿ ಮಾಡಬೇಕು. ಮನೋಜ್ ಇಲ್ಲೇ ಇದ್ದಾರೆ ಸರ್, ಎತ್ಕೊಳ್ಳೋದು. ಒಂದು ನಿಮಿಷ ಏನು ಕೇಳಿಸ್ತಾನಿಲ್ಲ ಇಲ್ಲಿ.
Any order in.
That's fresh.
Kind leave your lordships. Respondents are not taking advantage.
This Honorable Court had ordered for posting the matter yesterday, but due to some confusion in the office, they are not listed yesterday. I am enclosing the copy of the order sheet also.
Tomorrow, yes. Respondent taking advantage of the interim order of
When was
injunction
the interim order granted?
2025, my lords. Now they have obtained police protection order and trying to dispose of the petitioner, my lords. We are in possession.
So how many matters of that nature where 50, 60 a day or the interim orders are granted, how many matters the court can vacate the stay immediately? There should be some procedure for that. That's what I was requesting the advocates, but every day this is happening. Every day memos for 22 matters stay, there it is a 23 matter, it will be there. 26 matter, last week the stay is granted, this week to be vacated. You have to understand the difficulties of the court also. Yes.
My lords, it's one matter date given for first of June date is fixed, but it's not listed now.
What is the urgency now to take up?
But this is a matter wherein your lordships were pleased to dispose of the matter. Settlement was arrived at and 6 months time was granted. I deposited 2 months installment. And at that juncture, my one loan was cleared. And your lordships directed them to consider discharging one property because 3 property were secured. And your lordships, in fact, my lord, if your lordships could kindly recollect, the matter was supposed to be listed during vacation.
Is it a parted matter?
Not parted matter, disposed of matter wherein IA has been filed and your lordship asked some orders on that also. So for that reason, my lord, your lordships were pleased to direct this matter to be listed on 1st of June. So it is not listed for that reason.
So why will it come before me?
Because your lordships disposed of the matter. So
You are seeking modification of the order.
the modification IA has been filed, there is a order also that has been passed. And for consideration, my lord, this is listed for on the 1st of June.
Next Monday. No, everybody can't join here. When I'm hearing from here, I'll hear from the next advocate. Yes.
Lords, one pending matter. Lords, March the.
Please don't make any mention about any matter which can wait.
No. What has happened is, my lords, it has come before the previous bench, my lords, before vacation.
No, can't wait. Can't wait.
My lords, matter is posted on 8th, my lords, and the jurisdiction has been challenged. Commercial transaction is being litigated in a civil court, my lords.
Which year is the writ petition?
Writ petition 2026, my lords. March.
It has to be finally heard.
No, my lords. No, it's the evidence is going on before the trial
I'm saying
court.
it should be finally heard now. It's
No, my lords. For fresh matter, my lords, what has happened is the previous bench has referred the matter to mediation, my lords. Unfortunately, mediation failed during the vacation, my lords. There was an interim order till 25th of, my lords.
Sunday next week.
My lords, one date may kindly be given, my lords.
As it is convenient to the court. Yes.
My lords, in this matter, we have filed an IA for police protection, my lords. So,
And I'm requesting advocates, please do not mention the matters which can wait. Not because the matter is pending, don't mention.
we have had an interim order in this, my lords. They have started, status quo has been given, still the construction has been taken place on land, my lords.
So what order has to be passed now?
A police protection might be granted for implementing of the interim order, my lords.
Yes, no urgency for that. Yes.
My lords, the application has been rejected by the thing is, it is of direction matter, and day to day it has been taken up. Today it is for cross, and 2 more stages.
When is the writ petition filed?
It is a fresh matter, Your Honor.
It will come if you file. It will come.
But then it's a lower court. It's a direction matter, and after 2 stages,
No, even if the direction matter, without you filing the writ petition, it won't come before the court.
No, the trial would have it's a.
No. I'm saying when is the writ petition filed?
This 2 months back, it's a fresh matter. But the including application has been rejected by the lower court, and since it's a direction matter.
From the last 2 months, what's happening?
Complaints and other things.
You have no urgency for 2 months, and now it has to be listed. We will see. Yes. No.
We are suggesting that 95 is issued for partition and separate petition in
Before telling all the facts, I want to know first when the writ petition is filed.
The Honorable Court has dismissed it for non-prosecution dated 15/3/2024.
15?
3/2024.
No urgency for that. Yes, next. Let it be. Yes. Look at it.
The petition is filed in July. The wife in her affidavit of assertion liability suppressed the fact that she was unmarried. You summoned the college records.
Is it a part-heard matter?
No,
Then
it's not a part of matter. There is areas of maintenance. The reason is to suppress the fact that she obtained an interim maintenance. She was employed at that time. So both the records were summoned that she was obtaining a salary of about 33,000. Suppressing the fact she has obtained the interim maintenance. Now an arrest warrant has been issued against the husband who is a law intern. On this, to recall the arrest warrant of the suffice in this case, I have asked for a modification of interim order before this court, but it came up before this court 3 times. There was a change of counsel, it could not be, matter could not be heard. So I'm moving the memo.
to modify the interim order.
Interim order. She has suppressed the fact that she was.
I don't have the roster. I don't have that roster. The interim order of what?
Interim order of interim maintenance.
But that roster is not with me now.
The GMFC.
That's what I'm saying. GMFC, this court is not having the roster. That is, he understands that. Yes, next.
This is a commercial OS which I find. Or yesterday afternoon, I tried to mention this matter.
Yes, tomorrow. Yes, next.
Balaj, the parties disputes between themselves. They are filing a memo all tomorrow. So it may be
Tomorrow.
Well, it's fresh matter for admission.
Fresh matter don't have to mention if you comply with the office objections.
Millards, actually, Millards, before vacation, Millards, the matter has been listed and not reached, Millards. That's why, Millards, the matter is.
We'll see. Yes. Huh? When will we take up the matters with these kind of mentionings? I'm not able to understand. Call the list. Yes. No.
Millards, one matter getting interim order.
Call the list.
Millards, one matter, Millards.
Which number one?
Trial court is taking up day to day, Millards.
Being spoken to my lord.
My lord, there is urgency. My lord.
Your lordship, execution court has ordered for break open the door, your lordship.
My lord, there is an urgency.
No, whether there is urgency or not, everybody like morning half an hour with this mentioning process. How come the court can take up the matters? Only I'll give the memos and I'll list all the matters and adjourn the matters. I think that's the best procedure. Take all the memos, list it. If I'm able to do it, I'll do it, or else I'll give a date after a month thereafter. Take all the memos, and list it. Whatever it is, give it to the court officer. All the matters will be listed. I will take up only what I can take up, and remaining matters I'll adjourn.
My lord, it is the final argument, my lord. My lord,
Sorry,
no, sir. For final argument, my lord. Tomorrow, my lord.
Every day, court officer, every day, whatever the memos they give, take all the memos, list the matters, and whatever matters I can take up, I'll take up. Otherwise, it's just waste of time. Don't have to mention anybody, take all the matters.
Your lordship, the execution court has ordered for break open the door, your lordship.
Please, it will come, give it to the court officer, all matters will come. Whatever will reach, will reach.
Leadership's one mentioning. It is
Why is special treatment for you? I'm saying it will come, give it to the court officer.
There is some urgency, that is why, Lord.
Oh, no urgency, all matters will come tomorrow.
Because the petitioner is a wage worker. The trial court has rejected the
Come
application.
tomorrow, what else you want?
Please.
Tell the registry to list all the matters. Let it be 200, 300. I will complete whatever I can complete, and all other matters I'll give date for another after 4 weeks. Yes.
Page wise adjournment. List number 1, page number 1, serial number 2, 3, page number 2, 4 to 13.
My lord, serial number 10 and 12. Serial number 10 and 12, my lords, I'm for the petitioner. The arguing counsel has some inconvenience, my lord. He just had a baby 2 days back, so I'm seeking for an
Matter
adjournment.
on 6th of July.
Great.
Lords, one submission.
My lord,
Serial number 10, my lords. I undertake to file wakalat, my lords, for respondents.
What is your name?
Abhishek Huddar, my lords.
So and so submits that his instructions to file.
My lord.
Please.
Directed to print the name. Yes.
Page number.
My lord, and serial number 6, I need 2 weeks time because it's a fresh matter. My lord, serial number 6, my lord. My lord, it's a fresh matter and some orders have been passed by the courts below. So I need to amend the petition. So kindly 2 weeks adjournment may be granted.
One way advocates will ask for the memos to register matters. And the other type is this. The fresh matters listed, you ask for 2 weeks. Are you a respondent that the fresh
My lord,
matter?
meanwhile, some
List this matter in the month of August.
it is not
Yes, next.
great.
Page number 3, serial number 14 to 23. Page number 4, serial number 24 to 32. Page number 5, serial number 35, 33, 34. List number 2, page wise adjournments. Page number 6, serial number 21. Page number 7.
Serial number 12, my lord.
24.
Serial number?
12, list 2. 2 weeks time for
No,
compliance
it's a maintainability. We'll decide it today. Yes.
Page number 8, serial number 25 to 26. Page number 9, 27 to 30. Page number 10, serial number 31 to 37. Page number 11, 38 to 42. Page number 12, 43 to 47.
45, serial number 45, madam. Appear for respondent. Kindly have it
For the
tomorrow, madam.
petitioner, my lords. Construction is being carried out there.
Not doing, madam. Kindly tomorrow, madam. Senior is not coming. Personal
I
information.
have it tomorrow.
At the request of land counsel, the respondent, this is matter tomorrow. Yes.
Obliged.
Page number 13, serial number 48 to 53. Page number 14, 54 to 58.
You have an interim order? Then why do you want time? And why you have filed the writ petition? 2 weeks. This is matter in the month of August.
List
Page
number
number,
36.
page number 15.
At the request of all, at the request of land counsel, the petitioner. Yes,
At all part-time matters.
you don't have to call that.
List
Call the
number
list.
1, for orders matter, serial number 1.
Your lordship, list 2, my lord, serial number 23, my lord.
Yes. what do you-
I'm aware of the petitioner, my lords. I seek for a week's time, my lords.
Have you informed the?
My
Yes,
lords,
my
I,
lords.
my lords, I appear for the respond number 8. I have filed for vacating stay, my lords. If a date is to be granted, let it be next week. This matter was already taken up and we had argued it once before the previous bench, my lords. There is
This
some
matter-
urgency on my side.
This matter on 16th, at the request of land counsel, the petitioner, it is made clear that no further adjournments will be granted.
Please, my lord. My lord,
Obliged,
serial number
ma'am.
30.
Order earlier granted is extended.
My lord, serial number 39 as well, my lords.
Who appears to the respondent in that?
My lords, we have informed them, my lords.
At the request of land counsel for the, you have an interim order?
No, my lords, taken up
This
next
matter
week.
in the month of August, at the request of land counsel for the.
My lords, next
petitioner.
week, my
Yes, sir,
lords.
not possible, all matters next week. At the request of land counsel, the petition, it is stated that it's already informed to the council for the respondent. Yes.
Number 1, for orders matter, serial number 1.
Respondent.
Okay.
I'm for the petition. Kindly pass over the matter, madam. Senior in held up in court hall 2, my lord. Half an hour.
We are the landlords. They have not paid a rent of nearly 75 lakhs, which includes the GST. I am being exposed to action by the GST department for his non-payment.
We are ready to argue to the matter. Kindly pass over.
Ask for,
230.
ask for whenever
Please.
it's called.
Serial
Yes.
number 2, preliminary hearing, Kalpana, PV.
No representation. List is matter for discussion tomorrow. Yes.
Serial number 3. Serial number 3, R.V. Sadashivappa.
Yes.
My lord, the writ petition is by the plaintiff in the trial court. A suit for injunction is filed and a interim order was also sought. It was granted. Subsequently, it was vacated. So miscellaneous appeal was filed. There also interim order was granted. Now it is vacated. In the sense, appeal is dismissed, therefore consequently dismissed. Against which, my lord, the present writ petition is filed. The subject matter is a site. According to me, it is my site. I got it under registered partition deed and all that. He claims altogether a different site, as the courts observe. If that being so, the court ought to have allowed the appeal or continued the injunction order. I just take my lord's kind attention to certain observations made by the trial court and then to the appellate court. Kindly see in page 23.
Yes.
Twelve, 23. 23, my lord tried paragraph 15, almost at the bottom. Kindly see the case on hand. The defendant already in possession of the suit property. There is no question of disposition of the plaintiff. This is what they observe. Then the same learned judge observes on page 25, even a trespasser cannot be evicted without the due process of law. We are not seeking for his eviction, but we are only seeking for injunction because it is my site. I am in possession of that. Then
Where do you read, where do you get that? What you have read just?
Huh?
Page 25, last
page 25, my lord, last two lines. Referring to a decision here, in the decision reported in year 1975 Supreme Court so, wherein the
Para
Honorable
17, you please read.
Para 17, my lord, page 25. So observing that IA1 filed by the plaintiff under order 39 rule 1 and 2
No, the court says at para 17.
hereby rejected.
Plaintiff has failed to prove the prima facie case in his favor. In such an event, the question of considering balance of convenience so and so will not arise.
My
If prima facie shown to the court, the defendant is constructing the house in the portion of the suit property and he is in possession of the said property. In such an event, balance of convenience also tilts in favor of the defendants herein. Yes.
When the two sides are different.
Where is that observation?
Yes, that, my lord, I'll point out from the order itself.
Where?
Of course, documents are there which are all produced before the court. Here we have not
In
produced
this
them.
order where it is
Yes.
discussed.
Sites are different.
I take my lord's attention to page 32, paragraph 7, where the point for consideration was taken and it is answered in negative, as my lord could see it. But
Yes.
may I take my lord's attention to page 38, paragraph 17.
Yes. Let's read.
Therefore, at this juncture,
Para 16.
forbid
Let's read from para 16.
Read from para 16. Read
16.
from para 16.
Only to point out that the two sides are different.
No,
I'm
to
taking.
understand
No, I don't
the
mind
facts.
reading it. That's a different matter.
To
but
understand the
yes.
facts better.
These being the case and rival case, the SAILD dated 19/9/2005 shows that the father of the plaintiff has purchased 15 guntas of land in survey number 148 of Yerohalli, and his name was mutated in Panchayat records, and he was paying tax for the year 2009-10. The RTC also shows Sri Krishnappa was owner of 7.4 guntas in survey number 148 out of 3 acres 21 guntas. The copy of the gift deed dated 16/4/24 shows that the mother of the plaintiff, Srimati Shivakumari, has gifted the suit property to him through registered instrument. Therefore, the name is mutated in the BBMP records. BBMP Khata, tax, etc. receipt respect to property ID number so and so, house number so and so, he has paid the tax for the period of 23, 24, etc. Then paragraph 17. It is worth here to note that when he was acquired a right over the said property in the year 2024, how it is possible for entering his name previously to the said year and payment of tax under doubtful circumstance. No doubt, the plaintiff has also filed a police complaint and FIR was registered against the defendants herein. But that does not mean that there was interference. The endorsement given by the Deputy Commissioner dated 10/7/24 shows that no record was found regarding conversion order of survey number 148 of Aravalli village. Therefore, at this juncture, formation of site number 5 is under doubtful circumstance. That apart, the defendants have claimed the possession.
When counsel for the petitioner submits that, the court has given a finding that the property which the petitioner is claiming and the petitioner is the owner and the other property are not one and the same, and they are two different properties. In that case, the court ought not to have rejected the claim of the petitioner, petitioner plaintiff. It is submitted that both the courts have granted injunction, interim injunction later that was vacated. Even in the appeal also, petitioner was having an interim order. Later the same came to be vacated. Considering this particular observation by the appellate court, there shall be an order of status quo. The petitioner is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 30th of July. If the memo is not filed, the stay granted by this court stands vacated. No, just say memo has to be filed by 1st of July. If the stay is not, if the memo is not filed, stay granted by this court stands vacated. Yes, next.
Please.
Case number 4, Rajeshwara PN.
Petition is arising out of FDP proceedings, my lord. We are for respondent number 3 in the FDP proceedings, and respondent number 5 died on 8/9/2018, my lords. The respondent number 6 to 9, after a delay of 2,183 days, filed LR application and with other applications for setting aside abatement and for limitation under section 5, my lords. We have serious dispute against the relationship between the respondent number 6 to 9 and what they are claiming that their father is respondent number 5, my lords. And the honorable trial court, after hearing the applications at annexure M, my lords, page number 182, my lord, see last 7 lines, my lord. Heard the learned counsel for the applicant and the learned counsel for the respondent number 3 on IA number 31 to 33. It is forthcoming in the statement of objections at para number 3 that the respondent number 3 is disputing the identity as well as the relationship of the applicants with the deceased respondent number 5, Sadananda Ande. Hence, in my opinion, an inquiry is required to be done with regard to arriving at such facts. Hence, inquiry on IA number 31 to IA number 33 and to hear on IA number 34, call on 10/2025, my lords. After this, my lords, the presiding officer was transferred. The judge was changed, my lords. And without overlooking this order, my lords, this was also not challenged by the respondent number 6 to 9. Overlooking this order, the honorable trial court has allowed their LR application by condoning the delay of 2,183 days.
Order?
At annexure A, my lord.
11/9/2025.
Yes, my lord.
Where is the other order?
Annexure A, my lords, page number 20. We have filed detailed objections to the same, and as per order 22 rule 5, my lords, the provision says that if there is any dispute regarding who the legal representative of a party is,
What is this order? What was considered for the final present petition?
the reasons start from page number 30, my lords.
Yes.
Also page number 31.
He's coming up for the first time.
Yes, my lord.
You are appearing in this.
Lord, my name has not been shown. I filed the wakalat.
Yes.
And the copy has not been served on me. And because, my lord, any order is passed, I will be the affected person. On my application, my applications are allowed. We are the LRs for the deceased defendant number
No,
5.
This matter has come up only yesterday.
From yesterday in the morning, they had taken a
Passover,
Passover and then it is
could
listed
not be
today.
reached.
They have
But,
not served papers on them.
They have not served any copy to me.
You should have served so that we would have disposed it of today itself. Because when an order is already passed, the court should have conducted an inquiry on that. As if like no order is passed, court proceeds and allows the application. How can it be?
Lord, we have no objection so far as holding inquiry is concerned. We have, as a matter of fact, we have produced the documents also.
That what we will set
The
aside
the
this
learned
order.
judge allowed the
Set
application.
aside this order and ask the court to conduct the thorough inquiry on that. Then allow your applications.
Please.
Please.
Yes. Agreed with the order passed in FTP number 56 of in I number 31 to 33 in FTP number 56 of 2001 dated 23rd March 2026. The petitioner, the respondent number 3 in the FTP proceedings is before this court. During the pendency of the FDP, who died?
Respondent number 5 in the FDP proceedings.
Huh?
Respondent number 5 in the
Defendant
FDP
number 5.
proceedings. Defendant number 5 in the suit.
Respondent number 5 in the FDP proceedings, who is defendant number 5, died. And with the delay, the application is filed. Applications are filed to condone the delay, to set aside in filing the application, to set
By
aside
the LRs themselves.
to set aside the abatement and to bring the LRs on record. For that, the petitioner herein has raised serious objection. Then an order came to be passed on 11/9/2025, wherein the court has observed that it is forthcoming in the statement of objections at para number 3, that the respondent number 3 is disputing the identity as well as the relationship of the applicants with the deceased respondent number 5. Hence, in the opinion of the court, an inquiry required to be done with regard to arriving at such facts. Hence, inquiry on I number 31 to I number 31 to 33 and to hear on I number 34. The matter was adjourned to 30/10/2025. By order impugned, the court has, without conducting any inquiry, by order impugned, the court had allowed IA number 31 to 33 and abatement is set aside by condoning the delay. Consequently, the applicants are permitted to come on record as legal heirs of respondent number 5. When counsel appearing for the petitioner submits that when already an order was passed, considering the objections raised by the petitioner with regard to the relationship of the parties, and by order dated 11/9/2025, the court has observed that an inquiry is required, and for that the matter is adjourned, and by change of the presiding officer, without even considering the order dated without considering the earlier order, and as if no order is passed, the court had simply allowed the IAs 31 to 33. It is submitted that the respondents herein have not questioned the said order, and without that, the court ought not to have passed the impugned order without an inquiry, and the same needs to be set aside. Shall I record that you have no objection for the inquiry, or on merits I shall appear?
On merits, because
Then counsel appearing for the respondent submits that
the order is
respondent 6 to
justified.
9.
I support the order. I am for the contesting
you are
parties.
6 to 9.
6 to 9.
Those are the contesting respondents.
Yes, please, please.
For others, notice is not necessary. Give a memo.
Notice is not necessary, my lords.
Have you given a memo?
Will
Give a
furnish
memo,
yes,
memo
ma'am.
no. Then counsel for the petitioner, no, a memo is already filed seeking dispensation of notice to R1 to R6. Land counsel appearing for respondent 6 to 9 submits the court in the order impugned had considered the applications and rightly allowed the application, and there are no prejudice is caused to the petitioner and no interference is called for with the well-considered order passed by the trial court. Next, having heard the counsels on either side, there is a material on record. When an application is filed to bring the enlarged on record, to condone the delay and to set aside the amendment, and when the petitioners herein have raised objections, the court by order dated 11/9/2025 has passed an order that an inquiry needs to be conducted and accordingly adjourn the matter. But surprisingly, without even considering or without any reference to the earlier order, the impugned order is passed, wherein the court has allowed these applications without an inquiry. Such an order cannot be sustained, and the same needs to be set aside. Accordingly, the order dated 23rd March 2026 is set aside, and the matter is remanded back to the trial court for fresh consideration. Accordingly, this court is passing the following order. The writ petition is allowed by setting aside the order dated so and so, passed by so and so in so and so. Entire description should come, and the matter is remanded back to the trial court, to the executing, to the court. The court shall consider shall conduct an inquiry as per the order dated 11/9/2025. All the contentions are left open.
It's below the
Order
cost
make a-
title. We have written a note that respondent number 1 to 5 and respondent number 10 may be dispensed with as there is no relief sought.
It is, instead of saying that a memo is already filed, I think it is stated in the cost title itself that respondents 1 to 5 and
10, my lords. Respondent number 10.
respondent number 10 are not necessary parties for adjudication of the present dispute. Hence, the notice to the respondents is dispensed.
An order may kindly be passed for expeditious disposal because this is of 2001 FDP.
The court shall,
25 years matter is pending.
that point in the operative portion, the court shall expeditiously dispose of the FDP.
Grateful, my lords.
Number 5. Govind Rajati.
I appear for petition, my lord. This case, the one deceased Ranganayaka was the owner of the property.
So what is the IA?
IA order 39/2, which was filed by before the trial court by the plaintiff. He filed a suit for declaration and for permanent injunction. His declaration was for declaring that he was the owner, and also he claims the relief of cancelling the registered gift will, my lord, dated 5/11/2018, and other reliefs. And he sought for the temporary injunction order. His temporary injunction order,
What is
the
the
application
injunction
for
he's
grant was rejected by the trial.
Injunction he sought.
Injunction for restraining different from interfering with the peaceful possession and enjoyment of the good property. And in that application was, of course, written statement was filed, objection was also filed. And the trial court has rejected the application. In MA 19, filed before the learned district judge, it was allowed only on the ground, though the earlier suit, which was filed by deceased testator, that is Ranganaika, in Boyes 30/2015, it was decreed
No,
against the father of the plaintiff himself.
please come to the trial court's order first.
Trial one, page number 86, my lord. In page number 86, para 26 of the judgment order. But the trial court, even though considered that the index of lands RTC extract copy of the plaintiff in Boyes 30/2015 and the other documents relied by the plaintiff reflects the subject matter, survey number 170/1B is none other than the present suit property, and the said property is very same property in
MA, I'm saying
Boyes.
not MA. We'll go to the IA before the trial court. Where is that order?
Page number 43, madam.
Yes.
IA.
Small order, we read from the reasoning part.
Application.
Para number 7.
Para number
7, page number 52.
Page number 52, madam. Ali, therein, the learned judge has held in point number 1, this is suit for declaration of right and consequential relief of permitting injunction. The plaintiff projected in this case that they are the absolute owner in the possession, and it is the evidence. It is the defendant who is interfering with their possession and enjoyment of suitable property. According to the plaintiff, the suit property was in possession of their father, and the revenue record continued in the name of the deceased Ranganaika, alias Ranganaika, and the alleged will dated 5/12/2015 is concocted and in order to establish primacy case, the counsel for the plaintiff relied upon G3 and with respect to their family, and the register will said to have been executed by the father of the plaintiff in favor of the plaintiff, in which he bequeathed the suit property along with the other properties in favor of the plaintiff, in which item number 1 is shown to be the suit property of the present suit as shown in the plaintiff. Further, they relied upon the index of land and the RDC extract with respect to suit property and the copy of the plaintiff in OS 30/2015, which reflects Ranganaika, alias Ranganaika, brought the suit against the father of the plaintiff, and RDC also reflects the suit decreed in favor of the plaintiff. This plaintiff is Ranganaika is nothing but the testator who has executed will in favor of the present petition, my lord. Copy of the judgment also reflects that the subject matter of the suit in survey number 170/1B, which is none other than the suit property in the present suit. Further, the copy of the order sheet RA 16 for 2018 also reflects the same has been abated in view of the death of the respondent. Further, they relied upon the appeal memorandum in the above said RA 16/2017 copy of the register will dated 5/11/2018 said to have been executed by Ranganaika, alias Ranganaika, in favor of the defendant CD, and photocopies have been produced. Therefore, from going through the above said document, it made clear that the OS 130/2016 had been filed against the father of the plaintiff. Is also been declared Ranganaika, alias Ranganaika, is the absolute owner in possession of the suit property, which is against the interest of the father of the plaintiff. The manual RTC extracts for the year 1981, 91, 95, 99, 2000, 2002, 1995, 1979, 1985, produced along with the register sale dated 13/6/97, which reflects the Ranganaika, alias Ranganaika, has purchased the suit property and also relied upon the sale deed dated 18/6/1955 and 26/11/19.
I have seen this. Now we will go to the order in MA.
In the MA page number 86, madam.
Yes.
And only of course, the same has been reflected in the orders. That is page number, page number 86. But the trial court, even though considered that index of land, RTC extract, and the copy of the plaintiff OS 30/217, the other documents relied upon by the plaintiff reflects that the subject matter of one, that is survey number 170 for 1B is none other than the present food property, and the said property is the very same property in OS 30/2015, and the trial court failed to grant temporary injunction order to the plaintiff on the ground that there is a dispute with respect to the title of the property is concerned in and OS 30/2017 has already been decreed against the interest of the plaintiff's father, but the trial court has failed to take into consideration of the said food was not contested by the defendant either by Karnataka PW and adducing defendant's evidence. And of course, he has preferred an appeal also in RA 16.
We'll hear him. Yes. Now, what is the suit for?
Suit is for declaration, my lords.
Declaration, and you're seeking injunction.
Please.
Just because you have filed the earlier suits, that would not be the reason for the court to grant injunction.
No, I did not file, my lord. They had filed an earlier.
Whoever has filed, whatever is the suit, on that basis, how are you entitled for an injunction?
I am not. What had happened, my lords? They had filed a suit earlier. Subsequently, it was not contested. It came to be decreed. My father files an appeal against challenging that order. The plaintiff therein, the appellant therein passes away. So the appeal came to be abated. Subsequently, they file another suit in 2020. They do not get any interim order in that. And what happens is in 2024, they start interfering in my position. I subsequently file this suit. And then I file this, and then since I'm unsuccessful in getting an interim order, I file an MA and I get an interim order, my lords. And here, what has happened here, my lords, it is with respect to the propositors are the same. And the title they are claiming, what this defendant is, the appellant is claiming on is a will, concorded will. They claim that is registered. They don't show how they are related to that person who bequeathed the property to them. There is no relationship at all.
That will eventually be decided.
That will have to be considered, my lord. Yes. So I am in possession. So let them not interfere.
How did you show that you are in possession of the property? What is the material to show?
My lords, in fact,
there is nothing. If you look at the trial appellate court's finding, please come to that. The only reason why the court grants you injunction is this. Come to this paragraph at page number 30, but the trial court.
30, my lords.
Yes, page 30.
Please.
That is 87.
Please, my lords.
Internal page 30 of the order.
Please. For the trial court has failed to take into consideration that said suit was not contested by the defendant either by cross-examination.
No, you are the one who is seeking injunction.
Please, my lords.
The burden is not on the defendant to prove his case.
Please, my
First,
lords.
you have to prove your case.
Please, my lords.
What is the prima facie case?
My lord, I produced my documents, photos, and also shown my taxpayer
Where
receipts.
is the finding by the appellate court with regard to all this? Where is the trial? The trial court has given a reason finding how you are not entitled for injunction. And the appellate
trial court has
grants
not considered.
No. Forget about trial court's case. Appellate court grants injunction without even you satisfying the three ingredients.
My lord, I've produced additional documents. My lord, your lordship may please look at.
That is not, where is it reflected in the order? Where did the court consider? And where did the court say these are all the reasons why you are entitled for injunction?
My lord, your lordship may please look at page number 28, my lords, internal page number 28. Page number 85, that is. In page 85, previous page.
Yes.
Lord, I'll read from third line from top. If it is so, the present suit filed by the plaintiff for declaration permanent injunction requires a full-fledged trial by both the parties. The plaintiff is claiming right and title in respect to the suit property on the basis of an unregistered will dated so and so. And the defendant is claiming right and possession in respect to the property and by virtue of a registered will so and so. But the defendant has not mentioned a relationship with Ranganayaka, but the plaintiff is none other than the son of Narsanayaka.
Oh, whether you are entitled for your declaration of title or not will be decided.
Decided by full-fledged. A mini trial cannot be conducted.
As far as you're seeking injunction.
Please, my lords.
First of all, you have to prima facie show your possession.
Please, my lords.
That is not done.
My lords. My lords, and in fact, if
in fact, there is some reasoning in the order of the trial court. Absolutely no reasoning in the appellate court's order.
Let it be remanded back to the appellate court. Let them reconsider this.
There is already a decree, my lord, in OS 30.
Decrees.
It runs against the plaintiff's, deceased plaintiff's son
order.
also.
I'll set aside this order.
Yes.
I'll set aside this order and remand the
Yes.
matter to the lower appellate
Trial
court.
court. Yes, ma'am.
Yes. Agreed with the orders passed in MA number 19 of 2025 in OS number. I agreed with the order passed in IA number. Oh, this is the final order. Agreed with the orders passed in MA number 19 of 2025. Dated 18th February 2026. The defendant is before this court. The respondent herein, who is the plaintiff in the suit, has filed a suit for declaration, and that he is the owner of the suit scheduled property and also a consequential relief to set aside the registered will deed dated
5/11/2018 minutes.
5/11/2018. Along with the suit, he has filed IA seeking injunction that came to be dismissed by the trial court by an order he has filed an IA number 1 seeking injunction that came to be dismissed by the court by order dated 3rd April 2025. The plaintiff has carried the same to the district and session judge at Tumkur by filing MA number 19 of 2025. By order impugned, the court had granted injunction as prayed for by the plaintiff. Agreed thereby, the defendant is before this court. When counsel appearing for the defendant submits that the court, without considering the court, without giving any finding with regard to the prima facie case, balance of convenience and irreparable loss, has granted injunction. The only on the ground that in the earlier suit was not contested by the defendants, and what is the relationship between what is the relationship with the testator? How the will is executed in favor of the plaintiff, that relationship is not mentioned. As such, the plaintiff and all these issues will be decided during the course of the trial, and hence the plaintiff is entitled for injunction. It is submitted that the court, without even giving any prima facie finding with regard to the prima facie case and other ingredients, has granted injunction which cannot be sustained, and the same is liable to be set aside. Next paragraph. When counsel appearing for the respondent submits that even before there cannot be a mini trial at the time of granting an interim injunction, the court had rightly considered the relevant facts and rightly held that the plaintiff is entitled for injunction and no interference is called for. And this called for, and the writ petition is liable to be dismissed. Next paragraph. Having heard so and so. This court has gone through the orders passed in the IA in the suit and also the orders passed in the MA. While dismissing the application for interim injunction, the court had the court had considered. Where is this IA order?
IA order is at page number 47.
40?
47, begins at page 47.
The court has observed that going through the documents from both sides, as already discussed, it is clear that the appeal preferred by one Narasappa, son of Bommanna, in RRT.NO.170/2021 before the additional divisional court, Madhugiri, has been disposed and complaint dated 2011-2019 filed by the defendant before the Kallambilla police station which is much prior to the institution of the suit itself, reflects that in the year 2019 itself, the defendant had given police complaint against the plaintiff, which prima facie reflects the defendant is in possession of the suit property and the copy of the Pata book with respect to the suit property, which stands in the name of defendant, coupled with tax receipt with respect to the suit, also shows prima facie possession in favor of the defendant. The court came to the conclusion that the judgment and decree in OS number 30 of 2015, which itself against the interest of the plaintiff, shows that there is no prima facie case in favor of the plaintiff. When the father of the plaintiff, when he already declared as having no manner of right, title, and interest over the suit property, transferring the right to the plaintiff by way of the will deed, does not show any prima facie case. It's a case of the plaintiff that he succeeded to the suit property by way of a registered will executed by his father, which itself found contrary to the findings in the judgment and decree in OS number 30 of 2015, and raises suspicion in execution of the unregistered will dated 17/10/2022 in favor of the plaintiffs by the father of the plaintiff. And hence the court came to the conclusion that there is no prima facie case, and the proceedings of the assistant commissioner of Madhuguri is found against the plaintiff, and acknowledgement issued by the police station in the year 2009, much prior to the dispute. And Patta book and taxpayer receipt reflects prima facie possession in favor of the petition. As such, the plaintiff is not entitled for injunction. Then when it comes to the order passed by the appellate court has not discussed anything with regard to the prima facie case, balance of convenience, and irreparable loss. The court has only observed that the trial court has failed to take into consideration that the suit was not contested by the defendant either by cross-examining PW1 and adducing defendant evidence and producing documentary evidence. But in the present case, the defendant nowhere mentioned the relationship with Ranganayaka to believe that the said Ranganayaka is a relative and she has taken care of Ranganayaka during his last days, and due to love and affection, he has executed the registered will in her name on 5/11/2018. But the plaintiff has clearly mentioned that he is the son of Narsappa and his father has executed the unregistered will in his name, and accordingly the court had granted injunction. This court is not able to appreciate the findings of the appellate court. When the plaintiff has come before the court seeking a particular relief, the burden lies on the plaintiff to prove his case. Even when it comes to the interim injunction as sought for, he has to prima facie prove that he is in possession of the property and the defendant is interfering with his possession. Unless he is injuncted by an order of injunction, it would cause lot of hardship to him, and the balance of convenience, and it would cause irreparable loss. In this case, while allowing the MA, the court has not given any findings. But on contra, the court has fastened the burden on the defendant. Hence, in the considered opinion of the court, this order passed in MA number 19 of 2025, dated 18th February 2026, needs to be set aside, and deems it appropriate to remand the matter. Accordingly, this court is passing the following order. The order passed in MA number 19 of 2025, dated by second edition is so in MA number dated 18th February 2026 is set aside, and the matter is remanded back to the appellate court. Next, the appellate court shall consider the MA in accordance with law as expeditiously. as possible.
Till number 6 adjourned.
All
7.
contentions are left open.
7. Vinita PC.
Lordship, in the JDR has challenged the IA number 6 for the attachment of property order. In fact, he has no intention to defeat the decree. He has already made.
Let's see the order. Come to the order.
Please. Sale, conduct the spot inspection, spot sale. Page number, Lordship could see it. I produced the typed copy also.
No, where is the order?
Order at page number 83. IA number 6 filed.
Read from the reasoning part.
Yes. It is worth to note here that JDR is not disputing the decree passed in OS number 2531/2018. It is only contention of JDR that he has paid rupees 12 lakhs to DHR on different dates. As per order dated 27/11/23, JDR has paid some rupees 5 lakhs in cash to DHR. Thereafter, there is no mention in order sheet that JDR paid amount to DHR. As for memo dated 12/7/24, it is stated by counsel for DHR that remaining amount of 20 lakhs 21,033 yet to be paid by JDR. It is worth to note here that the DHR has produced SR value of property situated in Bazaar Street, Neelasandra. As per said document, value of ground floor in said area is 38,850 per square meter. The decree holder filed valuation report wherein the valuation of property shown as rupees 1,77 lakhs 86,000. It is contention of JDR that property is still standing in the name of his father and there is housing loan against the entire property. To substantiate said fact, which are within exclusive knowledge of JDR, no document placed before court. On the other hand, as per encumbrance certificate from 1/4/2017 to 21, yes. In fact, Your Lordship, the loan is on, the first lien is on with the bank. And in fact, I have not challenged the decree because this is the amount which is for towards the lease amount which has been taken, the 26 lakh. And in fact, in the order sheet, there is a reflecting 12 lakhs is paid because in the order they have mentioned only about 5 lakhs. In fact, in the order sheet, it is very clear that 12 lakhs, 5 lakhs and another 2 lakhs, it is forthcoming in the order sheet, which I have produced along with my order, that type copy also. In fact, now only prayer before this honorable court is that he is ready to pay the decretal amount, whatever it is there pending. The only contention is that with respect to the whatever the interior was done, that up to 5 lakhs, which the decree holder had promised to deduct in that amount. So memo of calculations, I was not given an opportunity to file my memo of calculation.
How much, no, what is the amount you're going to pay now?
Now 20 lakhs I have to pay.
What is that you're ready to pay now?
Now, Your Lordship, 10 lakh, within 15 days, I will clear the entire amount.
The dispute you're saying is with regard to that 5 lakhs of interior.
Yes.
So,
please.
What is the decretal amount is? The amount to be recovered is 20 lakhs, 21,000.
Now, 26 lakh was the decretal amount, Your Lordship. And wherein 12 lakhs I've already deposited. I've given. That is
whatever.
That.
Now, whatever.
Yes.
Now, this sale proclamation is in respect of ground.
20 lakhs, that is.
A recovery of 20 lakhs, 21,033.
Yes. Yes, please.
So, your dispute is with regard to only 5 lakhs.
5 lakhs.
So, pay 15 lakhs now.
I'm ready to clear within 15 days, Your Lordship. The only thing, because the bank lien is there, only to that extent I'm requesting the court to grant and seeking a stay with respect to that. And give me 15 days time, I will clear the entire amount.
No, why did you not place the documents before the court? That is what the court has clearly observed.
I understand, Your Lordship. But in the affidavit, he has clearly mentioned.
Mere mentioning the fact is not sufficient. You have to place a document before the court to show that this is what.
I understand.
I don't know what is the difficulty of the petitioner.
The petitioner was actually, the petitioner, he was ailing, Your Lordship. The documents are there which has been produced. Because he was going through the.
Documents at least here. You have
Pardon, Your Lordship? Pardon, Your Lordship?
You have the documents with you right now.
Regarding the.
Whatever the documents the trial court was mentioning, the executing court.
Income, loan account, I can furnish the details, Your Lordship. The encumbrance where the mortgage, the property, because it is a simple mortgage in the encumbrance certificate, it is not reflecting. But the loan transaction, the entire thing, I can produce it. That's.
Please come. Then counsel for the petitioner submits that. the decree holder has placing on the calculation memo filed by the decree holder, and without even considering the fact that the property is mortgaged to the bank and bank is having lien on the property, the court has passed this order. In fact, the petitioner has not questioned the decree as he is ready to pay the entire amount. It is submitted that now the proclamation is in respect to the ground floor of the property for recovery of a sum of rupees 20,21,033. The petitioner is disputing as far as 5 lakhs amount is concerned, which is spent for the interiors, and the respondent has under the decree holder has undertaken to bear the expenses. All these aspects were not considered by the court, and the property is put to auction on 26. Then it is already done.
No, it is not done. It's 27, there is, because they have not paid the process and all, the sale proclamation was not taken place. Now on 27, Lordship could see at page number 84, memo with document.
And the sale was on 27 for 2026. It is a submission of the land council that the sale has not taken place so far. If
It's fixed on 5/6/2026. It is fixed for 5/6/2026.
It's fixed for 5/6/2021, considering the fact that the petitioner is ready to pay the amount, and it is a case that all the contentions are not considered by the executing court. There shall be stay of all further proceedings pursuant to the order in I number 6 dated
5/6/2026
on the condition that the petitioner shall pay an amount of rupees 15 lakhs by
Lordship, 10 days
by
time.
17th of June, or else the stay granted by this court automatically stands vacated, and stands vacated. Notice to the respondents, petitioner is permitted to take out hand summons and file a memo to that effect by 17th of June. If the memo is filed on 17th, list the matter on 18th. And if the memo is if the memo is not filed, the stay granted by this court stands vacated even on that ground.
Lordship, kindly may differ on a hand delivery. Grateful.
Yes, next.
Number 8, Vicky Gundegowda. 8.
No, it's a plaintiff petition wherein the trial court has refused to grant me ex parte injunction order. The defendant is my neighbor. The litigation is with respect to a setback, my lord. I filed a declaration on injunction suit. The lordship may find the plaint at page 15. The trial court order is at page 15, my lord. My first submission is the trial court has not given me sufficient opportunity to grant me a hearing, my lord. And the second reason is the trial court has not reasoned its order, my lord. If your lordship may kindly put this page 15, the impugned order. The party was present and sought for a passover, but the trial court has refused to pass over the matter and has passed the order, my lord. Case has been advanced. The plaintiff submits hearing on IA number 1 and 2. The advocate was not present at that time. Subsequently, the trial court has issued suit summons and notice on IA number 1 and 2. My plaint is at page 16, my lord, and my plaint is at page 21. I filed a declaration and injunction suit, my lord.
Why it's coming up on 28/7?
Please, my lord, the only grievance is the defendant has expired at the construction, my lord. I produced the photographs in last date of hearing. The construction is damaging my water pipes and sewage pipes, my lord, and it's obstructing my window, my lord. I produced the photographs. My only request is to grant me status quo order till next date of hearing, my lord. I've also given complaint to Gram Panchayat, my lord.
Please come. Counsel for the petitioner submission. The defendant is carrying out unauthorized construction. Because of the same, the petitioner's property is damaged, and when there is an urgency, without considering the same and granting an ad interim injunction. Court has issued notice and the matter is posted to 28/7/2026, and the defendant is going ahead with the construction. Considering the submission, there shall be stay of all further proceedings. Pursuant to there shall be an order of status quo. There shall be an order of status quo. Notice to the respondent and petitioner.
The respondents are residents of Tumkur, my lord. Your lordship may issue emergent notice.
Yes, emergent notice to the respondents. Yes.
Selvanai,
Grateful.
SK Mithun,
No.
But a senior counsel is on VC, is appearing through VC. My lord.
Lords, I am appearing
Yes.
for the Petitions Council, my lords.
Yes.
Lords, there is an award against me for about 26 crores as on the date when the execution is filed. Lords, even before the execution was filed, Lords, can I persuade your Lords, may I kindly have a look at page number 125. An order of the coordinate bench. Lords, at para 11, 132. Just
Yes.
a perusal of the para 11, my lords, a perusal of the undisputed material on record will indicate that the petition has already deposited 1,65,65,000 before the tribunal, which continues to be deposited even till today. Even as per the calculation submitted by the respondent herein, as per the arbitral award, the petition would be liable to pay 22 crores 89 lakhs as on 10/2/24. In this context, the perusal of the salient of 17/2/23 in respect of flat number 1001 will indicate that same was executed for a sum of rupees 4 crores 33 lakhs 80,000 in relation to apartment measuring 2910 square feet. It is also significant to note that flat number 501 and 301 measuring 2910 square feet and 2893 square feet respectively are among the flats offered by the petitioner. In addition to flat number 302 and measuring 3850 square feet and flat number 502 measuring 3863 square feet, which obviously fetch much higher value than 4 crore 33 lakhs referred to supra. Under these circumstances, the cumulative effect of entire material on record would lead to unmistakable conclusion that 4 residential apartments offered by the petitioner in the memo dated so and so coupled with 1 crore 65 already deposited by the petitioner would be sufficient to safeguard the interest of the respondent, even assuming that AS number so and so is ultimately dismissed by the trial court. Consequently, it cannot be said that no prejudice would be caused to the respondent if directions issued to him in respect of 5 residential apartments. Respondent would be entitled to retain the keys in respect of the following apartments.
Yes,
Apartment
I've seen
numbers.
that.
Now, Lordships may kindly see. Now, I have lost this litigation up to the Supreme Court. Page 135 is the execution petition.
Yes. This order
Lord,
is
that-
dated.
Lord, this is an
22nd
order dated 22nd April 24. This was challenged before the Apex Court. Apex Court has dismissed the SLP. So this order has become final. Now, page 135 is the execution petition.
Yes.
Lords, page 137. Lords, the due according to them is about 26 crores 45 lakhs 77,000. Lords, as on today, another 3-4 crores might have been accumulated. It will be about 40 crores, 30 crores to be precise. That is as per their calculation. Because according to us, Lords, we have paid another 3-4 crore rupees, which is not yet adjusted. It's a matter of adjustment, doesn't matter. Now, in this execution petition, they filed an application seeking attachment of, Lords, may kindly take page 138. Properties are mentioned. 14 apartments, they wanted it to be attached. And your lordships will find that there is this square feet is mentioned of the properties. Lords, all these properties put together will cross about 100 crores. These are the properties which they want attachment. Now the application for attachment was opposed. Lords, kindly have a look at the order impugned at page number 14.
Yes.
At page 17, my lords, para 3. This is the objection raised. We said we have no objection for 5 flats to be kept under attachment. we will pay the money. Lordships may kindly see para 3. JDR assisted the application by filing objection. He contended that application is not maintainable. DHR has not approached the court. IA is gross abuse of process of law. JDR is not liable to pay the alleged sum of 30 crores as falsely projected. JDR has already filed an affidavit of undertaking before the court, undertaking not to alienate 5 flats of the total value of 34 crores 75 lakhs 80,000. Security already furnished by JDR is more than sufficient to secure the alleged claim of the JDR. Therefore, no further coercive steps are warranted. DHR and JDR has jointly filed a joint memo dated so-and-so wherein DHR categorically stated that he has no objection to the JDR to sell 10 flats. The Honorable High Court in WP number so-and-so categorically held that 5 flats are sufficient to secure security to secure the claim of the JDR. Accordingly, released 4 flats in favor of JDR. The said order has attained finality and is binding on DHR. As such, the DHR is stopped from seeking attachment of 12 flats, which is wholly illegal, arbitrary, and unsustainable. Total number of super beta area of so and so, and the total market value is approximately 83 crores, which is nearly 3 times the alleged amount. IA is filed only to harass the JDR as statutory right to challenge so and so. But then, if your lordships were to kindly take the reasonings given, Lords, I will skip paragraph number 8 and 9 because the para 8 and 9 they have repeated, Lords, what is the contention of respective parties. Para 10 is the only observation made at page number 22. The records show that the JDR has appeared before the court and has filed objections to execution petition, hence making affidavit stating that the particulars of the assets of the JDR in accordance with the format prescribed in Annexure 1 table is necessary. In facts and circumstances of the present case in hand, making affidavit stating the particulars of assets of JDR in accordance with the format prescribed in Annexure 1 table is very much necessary to adjudicate the matter effectively between the parties. Hence, by considering no prejudice will be caused if affidavit stating the particulars of the assets of JDR in accordance with the format prescribed in Annexure 1 table as paid by the JDR is allowed, even otherwise in order to adjudicate the matter effectively between the parties, it is necessary to make an affidavit stating the particulars of the assets in accordance with the format prescribed in table 1. If this court issue a warrant of attachment of both movable and immovable properties mentioned in Annexure 1, it will meet the ends of justice. One line order. Notice the earlier part of the order is under order 41, order 21 rule 41. Can I persuade your lords may kindly see order 21 rule 41, where there is a requirement of disclosing what are the properties which are means to satisfy the decree, which I have filed it. One line order, my lords, to say that you attach the entire properties. Lords, I will not, can I persuade your lords for this, my lords, without getting into this merits? Let this 5 apartments, let it be remaining as it is. Upfront, I will give 5 crore rupees. I will deposit before this honorable court that can be withdrawn by the decree holder. Lordships may release only 2 apartments because I have to show the bona fides. I don't want to run away from this because it's an obligation which I will have to discharge. Lords, by the end of 4 weeks, I will deposit another 10 crores. So essentially, 50% of what they are claiming will be satisfied. Subject to the calculation, my lords, because 2 plus 2 will always be 4. Because I have paid some money, they can give adjustments. Within 2 months thereafterwards, if further 2 flats are released, the entire money will be cleared within a period of 2 months. Essentially, what I want to say is, before your lordship's roster is completed, my lords, in this, I will ensure that this decree is cleared.
No, what is the, when was the award passed?
Lords, the award is passed in the year
6/7/23.
6 July 2023.
6 July 23.
2023 July,
there
please.
was an Lords, after that there was a appeal filed. In the appeal, my lords, the order which I have now referred to, my lords, in the arbitration suit, the learned single judge's order which I now refer to was passed. During the pendency of the arbitration suit was dismissed and now the matter is confirmed by the Supreme Court. Absolutely no difficulty that I have to pay the money because I was litigating up to the Supreme Court. This is what has happened. Lords, the decretal amount is including the interest. So whatever I have to pay, my lords, the larger the delay, more burden on me. That we have advised him. So I'll have to close it at the earliest. I am not saying anything, my lords. This order of attachment cannot be sustained because under order 21 rule 41, the jurisdiction of which is invoked by filing the application by the DHR, it says that I'll have to give the details of the property sufficient to satisfy the decree, which I have given by means of an affidavit. It is an affidavit which I have to file. This stands reiterated by the fact that there is already an order of the coordinate bench which says that almost about 34 crores is the value of the 5 apartments which is offered as a security to ensure that this decree is closed. Two, which is confirmed by the Supreme Court.
But how long the
Milords,
decree will be, the decree,
I'm
they will wait
Milords,
for
now
satisfying the decree.
I'm
But
fully,
see, yours,
Milords, no, absolutely no difficulty. This could not have happened because of the proceedings which we pursued up to the Supreme Court. Now we have lost the matter up to the Supreme Court. We have to pay this money. Greater the delay, more detrimental to me because there is an interest which I am required to pay. Now, may I just also pursue your lordships by kindly have a look at page number 156. This is the sale deed executed by the developer. Milords, 1 year back. Now the market value is further increased. 1 year back by the developer at page 156.
we'll ask the council. Yes.
Milords, at the moment, Milords, total 19 flats have fallen to the share of the landowner. I am the developer.
How many flats?
Total 19 flats have fallen to the share of the landowner. And 19 flats have fallen to my share as well. 50-50 it was, please. Milords, I am the developer. Milords, today, 7 of the flats have already been sold by them and 50 crores has been realized by them. Not a rupee has been deposited. It is under those circumstances, Milords, 15th of November 2024, execution came to be filed. Now, Milords, the impugned order has been passed more than 2 months ago. And now they have come before this honorable court, Milords, challenging the order of the executing court. At the stage where, Milords, the executing court is taking up the matter on Monday to value the assets for the purpose of recovery. At this stage, Milords, if at least 50% of the amount is deposited, Milords, some bona fides would be shown by them, because for the last 3 years, I have been suffering, Milords, with the decree in hand, not able to recover even a pie. Every time they come before this honorable court, Milords, only to give an apartment as a security, but not allowing me to realize my money. And Milords, for the last 3 years, it's been dragged on only on these grounds, Milords. I have given security, that is sufficient enough. Milords, where is the money? You have been liquidating the assets. You've been liquidating the assets. You have 50 crores with you. Not a rupee has been deposited, please, Milords. And this money, Milords, the decree is nothing but my security deposit, which I had given to them at the time of contract, please, Milords, while entering into the joint development agreement. If a developer is given money and he is unable to recover, Milords, even after having a decree for the last 3 years, Milords, under these circumstances, I would say it will be very premature for this honorable court even to, at this stage, decide any of this, Milords, when the executing court is dealing with the matter to realize the money, please, Milords. In fact, I have to file my objections with all on merits, Milords. This was just filed during the vacation, in the middle of the vacation. I could not get all the sale deeds. I've applied for them. If I may be given time, I will be filing my objections. At this stage, Milords, 50% may be deposited. 31.5 crores I have to realize, Milords. At least 50% of that may be deposited. Thereafter, please, Milords, the matter will be taken up.
Yes, Mr. Senior Counsel.
Milords, I have already stated, Milords, I am going to file an affidavit in this regard. They have waited for 3 years is not a correct fact, because we were before the Supreme Court all these days. Now the litigation is opened up before the executing court. We are bound to. Milords, we'll file an affidavit. We'll file an affidavit saying that as in terms of what my learned friend has suggested, absolutely no difficulty. I will upfront deposit 5 crores. Upon depositing 5 crores, your lordships may permit me to sell 2 apartments. I undertake to deposit another 10 crores on or before 2nd of July 2026, within 4 weeks. Essentially, within a period of 4 weeks, 50% would be deposited and it would be withdrawn. Or if your lordships directs that I should pay it directly to them, absolutely no difficulty, Milords, I'll pay it to them. This is a money which I have to pay it to them. It's an obligation under the decree. I am bound by the orders. Remaining, Milords, the moment I comply with this requirement of paying this 50% or 15 crores as on 2nd of July, your lordships may permit the release of 2 more apartments within 2 months. Within the period of 2 months, I will ensure that the entire decree is closed. I have advised my party, we have the buyers, and I will ensure, Milords, that this is closed. If I commit a default, lordships may say that I am not entitled to raise objections in the execution proceedings. With that rider, I will file an affidavit. Milords, because I can understand, Milords, that the decree holder's pain starts only after the decree is obtained.
Milords.
No.
I'm not here to bargain, Milords.
Not about bargaining.
Ultimately,
you want to realize
Milords.
Whatever is about amount. That's for that you have filed the execution.
Sure, Milords.
No, they cannot come before the court by filing these kind of affidavits and again going away from that. That will have its own costs and consequences.
Please, my lord.
So even if the matter goes to the executing court and all assessing everything, it takes its own time.
Certainly, my lord.
So let them come up with an affidavit. Tomorrow, don't precipitate that matter more. Let them come up with an affidavit by day after tomorrow or one by Monday.
Please, my lord.
Lords,
We'll
may I have
pass
this
a
matter day
proper-
after tomorrow. Lords, I'll file the affidavit.
My
Lords, I am
lords,
assuring my
my only
learned friends,
concern is,
Lords. I am assuring my
my only
learned friends
concern
that
is,
subject to the
we cannot
calculation.
today, after the order of this honorable court, 7 flats they have sold. 50 crores has been realized. Today they cannot come and say, I do not have money, give me only 5 crores and all of that. Please, my lord. I am saying 15 crores, let them deposit to show their bona fides, please, my lord. 50% of it at least be deposited.
At least
I'm
pay
doing
10,
that.
10. No. Pay 10 crores.
Please, my lord.
And remaining,
My
whatever
lords,
you say, like
We will
within
give a
the.
month's time thereafter, please, my lord.
My lords, I just wanted to bring this to your lordship's notice. This was a property held by the members of a family. My lord, this project went on for 12 years. At the end of 12 years, my lord, this happened. Whatever security deposit which had been taken had been spent. Two, my lords, what happened? We had several obligations in the family. It's a very large family, my lords. The landowner's family is a large family. So there were many obligations which we had to
Only
fulfill
one
and we have
landowner
done
who
it.
has come
My
and
lords,
it's all
I
now
just
at this
wanted to say
stage,
this.
reasons for that.
Lords, we had there are
Lords, I
multiple
gave
things.
15
Lords, not
crores.
as though that lords, it is something like I don't want to sell the apartments at a song and thereafterwards make good the
Anyhow,
payment. I am aware of it.
Come up with your affidavit, we'll see.
Lords,
Day
may
after
have this
tomorrow.
matter day
Please,
after tomorrow,
lords,
my lords.
I had given 25 crores as security deposit, 10 crores to be retained by them, 15 to be repayable. That apart, 50 crores they have realized, 75 crores they have already reaped out of this property. Today coming and saying, I
Lords,
do not
what
have even
I wanted
10
to
crores,
say this,
even
lords,
I do
what
not
they
have
have
10
reaped
crores is
out of
also
the
something
property is
unbelievable, please, my lords.
Better late than ever.
Please,
Let
my
this
lords.
for a
matter
delay
day
of
after tomorrow by the senior council submits that they are ready to clear the entire award amount, and in this regard, they'll come up with an affidavit. Let's just matter day after tomorrow. Basing
so
on
grateful.
looking at the affidavit,
Please,
further
Malad.
orders will undertake, and in advance, the same shall be served on the council, appearing for the respondent.
Please, my lord.
So grateful.
Till number 10 adjourned, 11.
I represent the petitioner in this case, my lord. The respondent number.
Sorry. Your Lordship, kindly seek passover. Senior is held up in court all above.
Password. Yes, next.
Till number 12. 12 adjourned. Till number 10 and 12 are same. 9. 10 and 12.
Yes,
Same.
and 13.
Till number 13.
Appearing for petitioner, my lord, kindly pass over, my lord. Senior is held up in another court.
If every matter has to be passed over, what if again in the afternoon, it's a burden on the court. Please understand. Yes, pass over.
Till number 14. 14. Nitin AM.
No representation for dismissal. 15.
May kindly be passed over, my lord. Senior is held up in another court.
From tomorrow, I'm not going to pass over any matter. I'll adjourn. If anybody asks for a pass over, let's pass over. Not every matter. Half of the list pass over.
Till number 15.
Petitioner.
St. John's Court.
Plaintiff's writ petition. Plaintiff is the daughter. Is a suit for partition. Plaintiff is a daughter. 1 Rule 10 application has been allowed, my lords, wherein daughter's husband, the son-in-law, has been impleaded as a proper party, my lords. My lords, the reasoning is at page 28.
20?
28, my lords, of the writ petition. Para 9. What essentially, my lords, the trial court has done is that it has observed that the title of the property is not to the subject list. It's a different property and a different suit can be filed to that effect. Despite that, my lords, simply because there is a count.
They have passed an order yesterday.
Yes, please, my lords. There was, my lords, what has happened is para number 10 was showed, my lords. In fact,
Please come to the order. Let's see now.
please. 1 Rule 10 application was filed. Only on the ground, my lords, was that a property.
Where is the order and where is which paragraph is relevant?
Please. Order is at pen 24. And the reasoning starts, my lords, at page number 27. In fact, para number 10 was read, my lords. 9 was supposed to be read because this is mutually.
9 also.
Please. In the present case, the plaintiff is seeking partition of the property bearing 488 HAL second stage Indiranagar Bengaluru alleged to be joint family property. The defendant number 1 has filed a counterclaim with regard to the different property allegedly acquired in the name of the defendant number 3 based on the family arrangement. The title to that property is not subject matter of the original plaint. Therefore, any adjudication regarding the same.
Counterclaim is allowed.
Millets,
Counterclaim is allowed.
it's on record, Millets.
That's what the court has to eventually consider the counterclaim also.
Please, Malats, that is what the mutually destructive reasoning here, Malats.
No,
What
no.
has happened is counterclaim, Malats, the court itself
What I
says that.
remember yesterday is now whatever the property which they claims that it is a joint family property by way of this counterclaim schedule property, whoever is the owner, in whose name that property is transferred, they wanted him to be a party to the proceedings. Is it correct or not?
Please, Malats, my only submission.
No, is it correct or not?
Their contention is that out of the joint family.
The fact you have to at least say, is it a fact or not?
It is not, that is slightly incorrect, Malats. What has happened
It's not
is,
about correct or incorrect. Isn't it the case of the defendant?
defendant Malats states that husband's property was purchased out of the proceeds of the joint family property.
So no, it is part of it is a counterclaim scheduled property.
Yes.
Court has to decide that is a scheduled property, suit scheduled property, and on whose name that property is there. Is he not supposed to be on record?
Malats, one submission on the judgment of the apex court. What the proposition is that the impleading unrelated persons would enlarge the scope of the litigation. And please. Ink page number 2, Malats.
Not an unrelated person. According to them, that is a joint family property. Whether it is a joint family property or not has to be decided by the court. And his presence is very much necessary because the property stands in his name.
Malats, that is what, Malats. This is the trial court on one hand holds that a separate suit has to be filed. But this is the trial court's finding.
That finding now, as far that we can't go into that, as far as Order 1 Rule 10 is concerned, and as long as that counterclaim is there and which has to be decided by the court, he is a necessary part.
Which is why, Malats, the citations may kindly be seen, Malats, for a moment.
Yes.
Page number 2, class item G, Malats.
Page number?
2, ink page number 2, class item G, these are notes. May I read it, Malats? It is an admitted position that respondent number 1 and 4 to 11 did not seek their addition in the suit on the strength of the contract in respect of which the suit of specific.
That page number?
Ink page number 2, Malats. Ink page number 2, class item G.
I'm not able to find. Yes, G.
Class item G. It is an admitted position that the respondent number 1 and 4 to 11 did not seek their addition in the suit on the strength of the contract in respect of which the suits of specific performance of the contract for sale has been filed. Admittedly, they based their claim on independent title and possession of the contracted property.
You can't rely on this judgment, which is arising out of specific performance suit.
Suit nature may be different,
What specific performance suit altogether stands on a different footing. That analogy you can't apply to a partition suit where a particular property is claimed to be the joint family property and the property in whose name it stands has to be a party. The petitioner, please come. Already the order is dictated. Only this, the petitioner has relied on a judgment passed by the apex court in Kasturi versus E.M. Perumal and others, reported in 2005, 6 SCC 733. And he relies on, which paragraph is this?
This is para number 11 minutes.
And relies on paragraph number 11. Extract para number 11. Next, in the discussion part, you add the judgment that is relied on by the petitioner is not applicable to the facts and circumstances of this case. The judgment which is relying on is in the said suit. It is in the facts of the said case. The suit is filed for specific performance, and in those circumstances, in considering the same, the honorable apex court
Make one small
passed an
submission.
order, and that is not applicable to the facts of this case.
There is no reasoning, Malaj. It only the paragraph starts with however, since there is a counterclaim. There has to be a reason to that effect, Malaj.
Yes.
Please, I'm grateful.
Number 15. Jairaj.
Lord, if I'm permitted, my lord, that previous matter, item number 14, in the appeal court, it is listed on 8th. If it could be listed on 9th, my lord, it's passed over. Serial number 14, one matter prior to this. In the appeal court, it is listed on 8th. So if that matter could be taken up on 9th, it would not have been.
What has happened now to that?
It is, our appeal is being heard, my lord. In fact, there was an interlocutor.
No, what happened to this case?
It is
14.
passed over. Afternoon, there is another matter.
Is this matter after 2 weeks?
Correct.
Yes.
For the
17,
serial number 16.
17.
16, what happened?
16 is now. They made a mention on serial number 14.
Hmm.
Serial number 16, my lords, I represent the petitioner.
Yes.
Sued for bare injunction where an application was appended seeking an ex parte order to restrain the defendant who is in, my lords, disturbing my possession. My lords, land was granted. This is a granted land way back in the year 1967. My father-in-law's name is entered in the RTC from the year 1967. 2004, my husband's name is also entered. Those are the part of the records where along with the plaint. Now, when I made a submission insofar as my IA is concerned, the Honorable Trial Court straight away issues only an notice on the application saying that it is an agricultural land, therefore I cannot interfere. Your Lordships may kindly see the impugned order at page number 29. Nevertheless, the Honorable Court says that I have not made out grounds. Page number 29. The plaintiff has filed this suit against the defendant.
What is that you have stated in taking undue advantage of the same, become aggressive and
Correct.
likely to continue his illegal and high-handed activities?
In my affidavit, my lords, I have stated that it was a granted land and simultaneously RTCs are entered in my father-in-law's name, thereafter my husband's name. I am in possession. RTC reflects to the extent of 0.37 guntas. On the version of executing a fraudulent sale deed only in the year 2011, now the possession, my lords, is disturbed.
Para 3, Srinivas Rao is the defendant.
Srinivas Rao, where the land was granted.
No, you say.
Correct. Land was granted in the name of Srinivas Rao in the year 1959. His name was never entered in the RTCs. Nevertheless, to an extent of 3 acres, 37 guntas of the very same survey number, my father-in-law's name is entered.
What is the relation between the Srinivas Rao and the defendant?
There is no relation.
And what is how he is asserting title to the property?
Defendant is ascertaining his title on the fraudulent sale deed executed by the petitioner in his favor disputed.
Declaration you sought and seeking cancellation of this document.
No, my lords, I am only seeking insofar as my possession is concerned as on today. I am seeking not
For bare injunction.
Bare injunction not to interfere with my possession simply because it is a granted land. Simultaneously, I have also made an application before the Tahsildar by virtue of my unauthorized occupation, grant the same in my favor. On the basis of RTCs already having been entered in my name, which your lordships will get at page number 37.
No, according to the defendant, you have sold the property in the year 2011.
Correct.
Then,
according to him, that is his contention.
how can there be a bare injunction, no injunction restraining them?
No, my lords, I'm not disputing insofar as the declaration towards my title there was. I was in possession. And
So how do you show your possession?
by virtue of RTCs.
And what about the sale deed that is executed?
Sale deed is also, my lords, annexed. Sale deed is also annexed. I have not sought a declaration for the sole reason that I am not disputing. It is an agricultural land. I cannot also claim a declaration to that extent.
Yes, please come to the order.
Your lordships may kindly see the impugned order.
Yes, the court was right in issuing the emergent notice.
No, I'm only saying this, my lords. There is unnecessary.
No unnecessary. Yes,
No.
please come.
If your lordships may pass an order where the matter is listed now on 2nd of July, he's entered his appearance, on which date the learned judge may consider my application on merits.
the petition is before this court, whereby the court, instead of granting ad interim injunction in favor of the petitioner, issue a emergent notice on I number 1 to the defendant, which is returnable by 2/6/2026 it is.
That was yesterday. Now they have filed their wakalat yesterday.
2/6/2026. Then counsel for the petitioner submits that the petitioner is in possession of the property right from,
Sorry, Milord.
they're in possession of the property right from
1967.
1967, and the defendant is asserting his title to the property basing on a alleged sale deed
2nd May 2011.
is executed by the petitioner dated 2nd May 2011. It is submitted that that is not, it is a forged document. It is a forged document. The other revenue records show the position of the petitioner, and the court ought to have granted injunction without granting the same notice as issued. In the meantime, if the defendant is successful in dispossessing the petitioner, it would cause a lot of hardship. Next paragraph. Having heard the counsel for the petitioner, peruse the material on record. Considering the dispute between the parties, where according to the petitioner is the owner of the property, and according to the defendant, the plaintiff himself has executed a sale deed in the year 2011, and this is pertaining to agricultural land. In these, considering this, the court has rightly issued a notice without granting an ad interim injunction, as the court felt that the court has to hear the other side. It is submitted by the learned counsel for the petitioner. Is now the matter is coming up on
2nd July.
On 2nd July 2026. In that view of the matter, this court is not inclined to grant, inclined to pass any orders, pass any orders. Accordingly, this court is passing the following order. This court is not inclined to pass, grant any order in favor of the petitioner at this juncture. Accordingly, this court is passing the following order. The red petition is disposed of, directing the trial court to consider the IA number 1 filed with the petitioner on 2/7/2026 when the matter is listed before the court.
Grateful.
Cell number 17, Prasanna Via.
Only emergent notice was issued by the first appellate court in an appeal filed by the petitioners not challenging the rejection of their application for injunction.
When is it? When the notice?
The notice was issued. Now, the matter is set down for appearance of the response today, and kindly direct the first appellate court to decide the next date of hearing.
Petitioner is agreed with the petitioner, the appellate court on IA filed with the petitioner seeking injunction has issued notice and directed the matter to be listed on.
Yesterday it was listed. Now, today.
2026. On that, the petitioner has come before this court as the wakalat is filed by the defendant.
Today, the appearance of the parties.
Today, the matter is posted for the appearance of the parties. This court is not inclined to go into the merits of the matter. Accordingly, the court is passing the following order. The red petition is disposed of, directing the trial court.
First appellate court.
First appellate court to decide the IA.
Please.
Or the MA.
IA, IA in MA number 11/2026.
IA in MA number 11 of
2026.
2026 as expeditiously as possible.
Earlier, MA number 1. Now it is renumbered as 11.
In all these matters and the other matter also, the court is not proposing to issue notice to the respondent as no adverse order surplus. Yes.
Cell number 18, Vishnu Kumar.
Petitioners, my lord, this is defendant's petition challenging the order passed by the trial court dismissing the application filed by the petitioners here in under Order 7 Rule 11 on the ground that the suit filed by the bank, that is respondent number 1 is time barred. Secondly, the dispute amongst the bank and the defendants does not fall within the purview of the definition commercial dispute. Thirdly, the jurisdiction vests with the debt recovery tribunal. And fourthly, there is non-compliance of mandatory requirement as prescribed under Section 12A of the Commercial Courts Act. Anyhow, after coming to know about subsequent circular passed by the government enhancing the pecuniary jurisdiction, I did not press the ground that the jurisdictions falls within the purview of or before the debt recovery tribunal. However, I proceeded on the other 3 grounds. So far as limitation is concerned, the Honorable Trial Court reached the conclusion, since it's a matter of question of facts and this thing, it requires full-fledged fight. Now, so far as the 2 grounds I asked, one is the bank admitted in its pleadings, also in the evidence, that the loan has been granted to the defendants for agricultural purposes. Even the document speaks, it is for agricultural purposes. When such being the case, it does not fall within the purview of the definition, Section 2 of that is commercial disputes. That is the main ground as before the trial court.
What was the finding of the court? Please come to that.
And mainly that is non-compliance of Section 12A. I take your lordship to the impugned order, which your lordship would find at annexure F relevant at page 18, my lord. Mary, that is 18 is so far as limitation. Then 19. One more serious contention urged by the learned counsel for a defendant is that plaintiff has not complied Section 12A of Commercial Courts Act, which is mandatory in nature, and therefore plaintiff is liable to be rejected. No doubt the decisions upon which he placed reliance would also support his argument. As such, in the absence of any urgent relief sought by, this is an admitted fact, the defendant number, the respondent number 1 bank did not sought any interim relief in the suit. He cannot directly file the suit before the provisions of Commercial Courts Act unless he has exhausted the process of mediation. It is true that in this case, Section 12A is not complied by the plaintiff. But the fact which is required to be appreciated is that earlier this suit has been filed before the senior civil judge Chikbalapura, White OS number 378 of 2009, under the provisions of CPC. As could be seen from the order dated 22/11/2022, senior civil judge court has returned the plaint by opining that the case on hand, it comes under the purview of commercial dispute as defined under Section 2C of Commercial Courts Act. From this, it is ample clear that the suit is not filed under the provisions of Commercial Courts Act without complying with Section 12A, rather identified and transferred under Section 15 of the. This is where the trial court went wrong. While passing order returning the plaint, for the moment, request your lordship to kindly turn to the order sheet in OS number 378 of 2009, which your lordship would find at annexure B. What is that?
They will issue notice. Notice to the respondent.
I sought for stay.
Notice to the respondent.
It's
I'll give a
before
short
commercial
date.
court.
I'll give a short date. That's why I'll give you a short date.
Today.
Within 1 week.
Please.
The notice to the respondents. Petition
So far as
for which
the
petition is permitted to take court handsomely. The counsel appearing for the respondent before the court.
May I make a request, your lordship? Respondents 2 to 4 are concerned. It may be dispensed with.
File a memo.
Fine.
File
I will place
dispensation of notice to respondents 2 to 4. Memo is taken.
They
on
are
record and
family
dismissed,
members of the petition.
Dispensed with the risk of appellant. Notice to respondent number 1. The petition is permitted to take out hand summons and file a memo on the counsel appearing for the first respondent before the court.
I may be simultaneous.
File a memo to that effect by 10th of June. If the memo is filed by 10th, list the matter on
May
11th.
make one other request. I may be permitted to take notice on the counsel who is appearing
That's what I
before the
said.
trial court. Answer, please. Ma'am.
Yes,
Number
next.
19. Narendra Babu.
Please, Your Lordship.
Yes.
Lord, plaintiff's writ petition challenging the order passed by the learned trial judge, my Lord, refusing to grant an order ex parte injunction in a suit for specific performance and for permanent
And
injunction.
when the matter is coming up,
Now it is posted on 9th, my Lord. Now notice is issued, my Lord. What happens is there is a registered agreement in my favor.
this order must be much prior to 9th.
It was ordered on, my Lord, on 13/5. Your Lordships will 15/5.
Is going to have the entered appearance?
My Lord, now what happens is, my Lord, it is posted on 9. The learned judge has virtually written, he has written at this juncture, there is no prima facie, he has written like that.
Let's
Page,
see that. Where is
page 25. Man. Kindly see, my Lord, para 4, page 25. Man. Para 4. Plaintiffs have instituted the suit for specific performance of agreement of sale dated 30/11/2018 and for permanent injunction for costs and other relief. Inter alia, the plaintiffs have filed IA number 2 under Order 39, Rule 1 and 2, read with Section 151 CPC, seeking an ex parte order of temporary injunction, restraining the defendant from alienating or transferring the suit.
say, as far as I'll say, this is unwarranted. And on 9/6/2026, expeditiously to decide the application.
But only difficulty is, my Lord, there is a registered agreement. I have paid 10 lakhs. But in the meanwhile, they are trying to avoid service of summons, my Lord, in the suit.
No, if,
So in the meanwhile, my Lord, some interim protection, either status quo or
summons or not served, whatever it is, your application that day shall be decided by the court. That's what I'll say.
but till then, my Lord, some protection, my Lord, for this reason.
Right from April, without any protection, the
No, 15/5, my Lord, 15/5.
That's what I'm saying. That is 15/5. We are now when we have now 9/5 is on Tuesday.
15 days are over, my Lord. If only a limited, my Lord,
Too many
limited
orders,
protection, my Lord, apprehension is.
Ask them to, I'll ask the court to decide it on 9/6.
May I make one alternate prayer, my Lord? The parties may be directed to maintain status quo till it is considered by the learned trial.
So how can I dispose it of now?
Because
without,
as per the GPA, both are registered documents. I have been put in possession as per the content.
What will happen now with status quo notice to the parties by the time they come, unnecessarily the matter will be pending.
Therefore,
before
my
the
Lord,
High Court. So I'll ask them to decide it on 9/6.
Now what they are, not there all along their attitude is, they are, my Lord, avoiding the service of summons. So if it takes a long time, my Lord, if they alienate in the meanwhile, the very purpose becomes, my Lord, it's an unharmful order, my Lord. Therefore, I pray that.
I will say the court to decide it on 9/6/2026. The writ petition is filed.
On the next date, my Lord, the learned trial.
Petition is filed. Seeking the not writ petition. The petitions are agreed by the order dated 15/2026, whereby the court has refused to grant interim injunction at that juncture and directed the notice to the defendants. Then a senior counsel appearing with the petition submits that, considering the fact that there is a registered lease, the agreement in favor of the petitioner, and they have paid substantial amounts, the court ought to have considered the application that is filed, the IA that's filed by the plaintiff seeking injunction. If the orders are not passed, and if you said not to alienate is the order.
Please.
If the defendants alienate the property, that would cause a lot of hardship to the plaintiff. That aspect was not considered by the trial court, and now the matter is now summons or issued to the defendant, returnable by 9/6/2026. Considering the fact that, and the senior counsel submits that there may be a protection till the parties enter appearance before the trial court. Next paragraph. Considering the fact that the matter is coming up on 9/6/2026, this court is not inclined to grant any interim order and keep the matter pending before this court. Hence, this court deems it appropriate to pass the following order. The writ petition is disposed of, directing the trial court to consider the IA number 2 filed by the petitioner. Expeditiously.
Next, at least next date.
The within shall consider the IA that's filed with the petitioner expeditiously before 12th of June. Even 1 or 2 days if they have to adjourn it, but before 12th of June, I said. 9th, the matter is coming.
9th, it is coming, my lord, on the next date, my lord, without being influenced by the observations.
What observation? These observations.
My lord, the learned judge says, my lord, plaintiffs have not made prima facie.
Shall be decided on the next date of hearing, that is on 9/6/2026. Without, he should not be influenced by his own observation.
Otherwise, my lord.
Notwithstanding the fact that it is observed in the earlier order that at this juncture, the petitioner has not made out any prima facie case. The court shall pass order considering the submission of the parties in accordance with law. Same in this also. No notice is ordered because no adverse orders are passed.
Obliged.
Cell number 20, Mohan Chandra P. 20, Mohan Chandra.
Pass over, my God.
Pass over.
Cell number 21, Yadunandan.
Please, my lord. Plaintiff's petition against my lord order passed on application under 39 Rule 1 and 2, confirmed by the lower appellate court in miscellaneous appeal. Lord, previously, my lord, there was a round of litigation wherein my lord, I secured.
Come to the impugned order. First, come to the impugned order.
Please, my lord.
What is the order in the MA? Where is it?
The trial court, my lord, at page 42. A moment. Page 42, my lord. The relevant portion, my lord, 56 onwards. 54 onwards. My lord. Para 21. Is the case of the plaintiff that land measuring 3 acres 23 guntas of land in survey number 89/2 belonged to his grandfather Timmegoda. His grandfather, under the registered settlement deed dated 23/5/1958, had given right to his grandmother Sakamma to enjoy the above said property, and after her death, the mother and father of plaintiff had absolute right with respect to 3 acres 23 guntas of land. It is the further case during the lifetime of his parents, children of Bolarigoda and children of Chinna Venkategoda created fraudulent document with which, with respect to aforementioned extent of land, therefore grandmother and parents of plaintiff had filed a suit for declaration against children of Bolarigoda and Timmegoda bearing OS number 1236 of 2006. The said suit came to be decreed on 1/12/2012. Later, parents of plaintiff and grandmother of the plaintiff had filed RRT appeal. The assistant commissioner and the said appeals came to be allowed on 23/4/2011. Later, Kata with respect to land in survey number 89/2 was transferred to the name of grandmother of plaintiff named Sakamma. It is the case of the plaintiff that children of Olarigoda Chinna Venkategoda, being aggrieved by the judgment so and so, filed an RFA before the Honorable High Court of Karnataka, and in the said RFA, High Court had directed both parties to maintain status quo with respect to revenue entry found regarding survey number 89/2. However, children of Chinna Venkategoda and Timmegoda, by violating the status quo order of the Honorable High Court of Karnataka, created fraudulent documents, and with the help of defendant number 6, they're trying to construct house over the aforesaid extent of land. Vijayanagara police had directed children of Bolarigoda and Timmegoda not to meddle with the said properties. Whereas it is the contention of defendants that 3 acre 23 guntas of land in survey number 89/2 is not an absolute property of the plaintiff. On 25/11/1990, Sakamma, children of Timmegoda, namely Bolarigoda, Chinna Venkategoda and Timmegoda, had entered into Panchayat Palu Parikat, where 3 acres 23 guntas of land was divided between them. Out of the said extent, first son was allotted 6 guntas of land, second son was allotted 1 acre 8 guntas of land, and Sakama allotted 2 acre 9 guntas of land. Based on the said Panchayat Palu Parikat, Kata and RTC was changed into their name. As per the said Panchayat Palu Parikat, 1 acre 8 guntas of land had fallen to share of Venkategowda. These are the very contentions in the previous suit also. That came to be decreed in my favor. They again come up.
Defendant is not a party to the suit.
Please, my lord.
Defendants are not the parties to the suit.
The present suit.
Earlier suit defendants are not, these defendants are not the parties.
They were, their parents were parties. They died subsequently, the defendants.
Okay. But the defendant number 1 and 3
Defendant number 1 and 2 are subsequent purchasers.
are not the parties to the suit.
Please.
Yes.
They are not the parties. Then, my lord, the learned judge, my lord, observes that I produced all the documents, including that of the previous suit, where the very same contentions were taken in the written statement.
Come to paragraph number 29.
29.
Yes.
Defendant number 1 is the purchaser of site number 29 measuring 30-40, which alleged to have been fallen into the share of children of Chinna Venkategowda. The plaintiff contends that the suit scheduled property falls within 3 acres 23 guntas of land. The photographs which are produced before this court would manifestly make it clear that 3 acres 23 guntas of land is no longer an agricultural land, because various purchasers have already constructed a house and living in the said house along with their family members. Admittedly, first defendant, who is the purchaser from third defendant under the registered sale deed, has obtained 11B Kata and form number 3 from the concerned local authority, and he has also obtained loan from private finance corporation. The house of defendant number 1 has already come up to RCC level, and defendant number 1 has invested huge money and collected construction materials which are lying over the suit scheduled property. Under circumstances, if court would, without looking into all these materials, grants temporary injunction as sought for in I number 2, then the defendant number 1 would be put to great hardship and loss which cannot be compensated in any manner. The other contention is that Venkategowda and Bolari Gowda, by creating fraudulent document, have formed various sites and sold the sites to various purchasers, etc., are not the points to be considered at this initial stage, because it certainly requires full-fledged trial to ascertain the rights of the plaintiff and defendant number 3. The
What is the
question,
injunction you sought?
please, my lord.
What is the injunction you sought?
Lord, I filed 2 IS, one not to put up construction and not to alienate. Common order came to be passed in both trial court, and again I filed 2 appeals not to put up construction and not to alienate. Thereafter, clubbed and common order came to be passed. Lord, in the trial court as well as in the first appellate court, had the benefit of interim order. The temporary injunction was granted.
At best, pending this petition, we can grant you an order of not to alienate, but not to make any construction.
Lord, the submission that I want to make is, my lord, what they say agricultural land is converted into, all that is correct, but the survey number they claim is not so, because in the written statement,
But we have to see that as of
they don't state any survey number
per
in their objection as well as written statement.
that other side, notice go.
Lord, if they enter possession, my lord, then I'll have,
No, what is there to show that you are in possession of the property?
Lord,
Except that the judgments,
except, my lord.
the judgment that is in OS number in the pending appeal.
My lord, AC court rules in my favor. I have all revenue entries are in my favor.
Contrary, you say that contrary to the order of the High Court, where the status quo is granted, certain alienations are made. Whatever it is, now somebody is in possession of the property. We are not in execution of the decree of in the earlier litigation.
The suit for mandatory injunction, my lord. I've sought for suit for mandatory injunction. Now, my lord, once I'm declared the owner, revenue entries stand in my name. Now, his land is in 89/3, which is adjacent to my land.
We'll see when once the respondent comes.
Lord, let status
quo will not grant. That's what I said. At best, not to alienate. No other order. If you don't want that also, I'll ask notice to the respondent's petition is permitted to take out hand summons on the counsel appearing for the trial court. Shall file a memo to that effect.
status quo be not to alienate.
Then counsel appearing for the petitioner subjects that in the earlier suit filed for declaration was decreed, and against it an appeal is filed, which is pending adjudication for this court, and there is an order of status quo. In spite of that, the properties are sold, and now the third property parties are putting up construction. Is it your case?
Please.
Putting up construction in the said property. the courts without considering the case of the petitioner and without considering the material that is placed has failed to grant injunction not to make construction or not to alienate the property. Considering the submission of the land council and the fact that the right of the plaintiff with regard to the property is declared in the earlier suit, there should be a direction to the respondents not to alienate the property pending disposal of this, not to alienate the property till the next date of hearing. Same hand summons on the council and a memo shall be filed by 30th of June or else the stay granted with this court's transfer date.
Till number
But liberty
22.
may be, same matter, my lord, it may be connected.
List along with so and so. Yes. Same parties.
Same, two applications.
This also same hand summons.
Lord, liberty may be reserved to my lord, argue on interim prayer in the next date, in respect of not to put up construction, my lord.
So that will be
Consideration of
grand.
interim
Why
prayer.
should there be, what is this liberty to file vacate
No, my lord,
petition,
now that
liberty-
there is already an interim order,
Oh, they have not come. Why can't, no, when you argue, we'll hear it when the other side comes.
no, my lord, the court will be of the view that already interim order is granted, so it may not be heard. For consideration of interim
At this juncture, when that interim order not to alienate is granted before that consented, at this juncture, the other relief of not to make further construction, this court will not consider, and the same will be considered. It's not inclined to consider, and the same will be considered once the respondent enter appearance. Yes. Yes, next.
Number 23, Raghavendra K.
Defendant's writ petition. The defendant during the evidence has produced, earlier it was produced along with the written statement
IA.
only.
What is the IA?
IA has not filed, man.
Hmm.
There is no IA.
Then what is, why you are before the
Document purported to mark, but it was rejected by the trial court.
That's what, where is that order dated?
Order is at page number 35.
Yes.
35.
Let's read the order.
Perused the documents placed by defendant number 1, that is the petitioner before the Honorable Court. Unregistered release deed written on white paper. On perusal of the said document, it discloses that it is a release deed dated so and so. Admittedly, the said document is unregistered document. The learned counsel for defendants during the course of the marking, the document has submitted that though it is unregistered document, it can be marked for collateral purpose, and he is ready to pay duty and penalty on the said document. On the other hand, the learned counsel for plaintiff opposed the
It is an
same.
unregistered, unstamped document.
Yes.
Yes.
The Honorable Supreme Court held that even though the document is unregistered, as per section 49 of the Registration Act, for collateral purpose, it can be marked.
What is the main purpose and what is the collateral purpose?
Main purpose is, my lord, if I try to establish the title, that is the main purpose. Here I am the defendant. I am taking the defense that how this property is.
It is by that it will not become main purpose and collateral. For what purpose you are relying on that document and what is the collateral purpose?
I am relying on this document, my lord. My mother, grandmother has executed this deed in my favor, release deed.
And by virtue of that you have
I am in possession.
of the property.
Yes, ma'am.
That is the purpose for which
That is
you
the
want-
purpose, yes, ma'am.
And what is the collateral purpose?
Collateral purpose means the document which is purported to produce to show that it has no evidentiary value. Without evidentiary value, it can be document. So court will not
Yes.
weigh it as a evidentiary document, only to show that how this document is connected with this property. For that purpose, collateral purpose.
Yes.
Honorable Supreme Court held that for the collateral purpose, even though it is unregistered and unstamped, it can be marked.
Pass on.
before the trial court, the appellant seeking permission to place on record.
Agreement of sale dated 1 month.
Yes, my lord. But this Honorable Court, the Honorable Supreme Court has relied upon the judgment of Honorable Supreme Court judgment. Kindly see page para 10, my lord. Para 10, internal page 5.
Yes.
Kala Devi's case is relied upon. As per this Kala Devi case, kindly see the underlined sentence is there. When an unregistered sale deed is tendered in evidence, not as a evidence of a completed sale, but as proof of an oral agreement of sale, the deed can be received in evidence, making an endorsement that it is received only as evidence of an oral agreement of sale under the provisions of section 49. Therefore, it ought to have been marked for the collateral purpose. Because I am the defendant, I am not the plaintiff. If I am a plaintiff, I may try to establish the title. Here, that is not the case. Therefore, I sought for interim stay, my lord.
Dismissed, order will follow. Yes, please.
Till number 24. Till number 24.
Yes.
It's defendant number 1's writ petition. Suit for declaration possession. An application was filed by the defendant petitioner to recast the issues. Lordship find that application at annexure E, page 63. The two issues were sought to be recasted. Plus, among which, my lords, second issue is whether the suit is barred by law of limitations. 63 annexure E, my lord. The application to recast the issues. The additional issues are, my lord, Lords, A, I will not much press, my lord. B, my lords, I will press, my lord, because of the limitation.
The suit is barred by law of limitation.
Please, my lord. Because the first sale is of their 1956. My lords, thereafter, there was a partition. 2014, my lord, the subsequent sale deed.
What happened?
Lords,
What happened?
my lords, that application was rejected only on the ground that, my lord,
Yes.
there is
What are the earlier issues that were framed?
Lords, earlier issues, lordships find at annexure E, annex D, my lord, page 62. My lord.
Page
62, my lord.
62.
Please, my lord.
Do the plaintiffs prove that they are absolute owners of the scheduled property? Sale deed dated is null and void. And do the plaintiffs are entitled for release sought in the plaint? And now you wanted these two.
Please.
Not two, only two or only these two issues?
These
Yes,
two issues.
Come to the order.
Let's the order, my lords. Let's the order says, my lord, that the defense with respect to the limitation has not been taken specifically. Annexure A, page 12 is the order.
Basing on the pleadings of the parties, issues are framed.
Please, lords, I raised the issue that the suit is barred by limitation. Lord. The first paragraph of my written statement.
Come to the order.
Lords, the order, lordship find at page 12, annexure A. Relevant, my lord, the reasons at page 20, my lord, 20. Plus 7 lines from the bottom, my lords. It started 7 lines, but herein since the defend number 1 has, my lords. Bottom 7 lines. Not taken specific defense, my lord. I taken the specific defense, my lord. That suit is barred by limitation.
Come to your written statement.
In this written statement, lordship find at annexure C, my lord, translated copy at page 42. First paragraph, my lords, and first and third paragraph I took. Page 42, my lords. The first defendant humbly submit before this honorable court. The suit filed by the plaintiff is not maintained in the eyes of law, and the suit against the defendants has been filed without any cause of action, and the same has not been filed in accordance with the provisions of Limitation Act. The present suit is liable to dismiss. Third paragraph, the first defendant humbly submit before this honorable court. Suit filed by the plaintiff is not maintained as the suit filed is for a declaration and possession, and the plaintiff has never been in possession of the suit. Hence, the provisions of Limitation Act has been violated. Hence, the suit is liable to be dismissed. Defendant number second defendant also took a specific contention. Annexure C1, translated copy, lords, is found at page 53.
Counsel for the petition. submits that when they file an application for recasting of the, or it is for framing the additional issue. The court has dismissed the same on the ground that there is no specific pleading with regard to that, and counsel has drawn the attention to the written statement and stated that there is a specific pleading in that regard. Considering the same, they shall be stay of all further proceedings pursuant to the impugned order dated so and so, passed by so and so, till the next date of hearing. Same summons, the memo shall be filed by 30th. Don't give a date of hearing.
Then number 25, Chokareddy.
Per petitioner, the plaintiff not the suit for specific performance. Let the on 2/6/2015, malad the written statement filed by the defendant. But issues were framed, malad. The evidence was commenced, but the documents were marked. Then they filed their the amendment application after lapse of 7 years from date of the written statement filed. That is the intention of their amendment application. They, in order to bring the judgment passed by their the court, that is the injunction suit filed against me for not to interference in the specific performance suit. That was in the agreement of sale that the portion was not delivered to the plaintiff, but suit was decreed. That the judgment in order to bring the amendment in the 6/17. That is only the facts. Judgment can be produced in their course of the evidence only.
No, what will happen now if this is allowed?
That amendment application was allowed by the court.
No, what will happen? What is the prejudice cost to you?
Well, that is.
When you say even that can be placed before the court in its during the course of evidence.
Yes, ma'am.
So what is the prejudice now?
Prejudice, well, the intention of their amendment, any the new facts, any their events in subsequent.
Not part of the pleadings, you can't deduce any evidence.
Well, that is the judicial, malad, the order.
Yes, it is. This is not, this is the, no prejudice is caused, like it is between, the suit is between both of you.
Yes, that is injunction suit, malad.
I don't know whether there is an evidentiary value to that or not, whether the court will not consider or not, no prejudice to you at all.
In malad, that is one para, I have no objection. Other repeated facts, the 4 paras has been inserted. Kindly see the application, malad. The repeated facts in the written statements.
No, let's go to the
Malad,
order. No, no, let's
IA number 6, malad.
Let's go to the order itself, where there will be a discussion on this.
Malad, that facts, malad, the judgment, it can be, malad, the amendment, I have no objection. Other, malad, the written statement facts has been repeated in 4 paras. That is page number, malad, 20 annexure B.
Where is that?
IA, malad.
Page number?
Page number 20, IA number 6. That is amendment application 6/17 filed by the respondents. But para number 6A, that is the repeated facts. And para number, malad, the 7A, that is the repeated facts. Para number the 12A in page number 21, that is the judgment in OS and RA. And 12B in the written statement filed by their respondents. Kindly see page number 53. Very same the narrations in para number 5 and para number 6, malad. And OS number.
So let's read the affidavit. I state that the amendment now sought or subsequent events and also a few typographical errors.
Malad, the affidavit for para number 4, malad, I have no objection. Remaining paras, malad, the 4 paras, malad, he want to insert. That is in their written statement, malad, the para number 6.
What he says is that is only what he wanted to amend, and there is a typographical error that he wants to correct. Come to the order of the court, how the court has discussed it.
In para number 9, malad, the reason, page number 17. In the present case, On the hand, it is a contention of the defendant that proposed amendment is only typographical error and subsequent events. On perusal of proposed amendment, it appears that defendant intended to bring the facts by introducing the new paras in respect of the subsequent events. OS number 1516/2012 and RA number 123/2020 said regular appeal came to be disposed on 5/8/2022. On perusal of their records, written statement filed by the defendant in quite earlier to the disposal of the RA. It is under the circumstances, it could not be
So
possible.
all this, Ari, you are also a party to those proceedings. Whatever they are pleading, basing on the findings of the court, you are also party to that. And that is admittedly, that is a subsequent incident happening and which requires to be on record.
Malad, para number 4 in amendment 12A, Malad, that is narrated OS number and RA number that was disposed. I have no objection. Remaining paras, Malad, the proposed 6A and 7A and 12B are repeated in the written statements. Again, the Malad.
The prejudice by that, what is a new case that is introduced by the defendant?
Malad, in order to insert this, the OS and the RA judgment, remaining paras, Malad, the repeated facts, Malad, the trial court has not looked into these facts already, Malad, in the written statement 2015 itself.
So, if this is the, if this amendment is allowed, there is no change in their earlier. So what will happen?
Malad, their indicates, Malad, I agree, but the repeated facts in the written statement in 3 paras.
New facts. There is no prejudice to you at all.
That is a paras, Malad, the 6A, 7A, Malad, that already in the written statement.
That is what
How they are already, Malad, court can, Malad, allowed in part of their the application. Remaining the 4 paras, kindly see their written statement, Malad. The para number 6, that OS number, all these things has been there stated in the written statement 2015 itself.
Yes, dismissed. Order will follow. Yes, 26.
So number 26. Prasad K. Prasad.
No representation.
I appear for the petitioner's counsel, my lord. The main matter, there were 2 writ petitions filed, my lord. The main matter is not posted. FR 16160 of 26. Both were filed together. Somehow only one is posted.
That is still in FR stage. That means objections are not complied with.
We will attend to it, my lord. Your lordship may kindly have it on Thursday or Friday or even next week, Monday.
You have written a number?
WPF
Please.
161.
List along with so and so on 11th of June, provided the office objections are cleared and the writ petition is numbered.
Please, you repeat once again the number.
16160
26.
Yes, next.
of 26.
Yes, sir.
As item 27, I
27.
beg to assist on behalf of the petitioner in this matter, my lords. I am the plaintiff before the trial court. 2011 was an agreement that was executed in my favor. 2012, I filed a suit for specific performance of that agreement. My lords, the person who had subscribed his signature, who was, my lords, the owner of the property in 2012 itself, would file his written statement with only bare denial that he has not, my lords, agreed to sell this property. During the pendency of the suit, my lords, he would breathe his last. Various legal heirs claiming themselves to be legal heirs, my lords, would mark their presence in the case, my lords, as the legal heirs of the original defendant. Because after a lapse of several years, most of my lords, after a lapse of more than 15 years now, an application is filed, my lords.
He died 15 years back.
He died, my lords, in 2013 itself. 2013 itself. 2012 was the suit. 2012 itself, he would file a written statement containing only bare denial. I have produced it, my lords, along with my written statement, along with the writ petition paper book. He would only deny, my lords, the execution of the agreement. Except for denial, my lords, he does not say anything. Only says the sale consideration could not have been such because the market value is appreciated now. Except, my lords, the standard form of denial of that would be there, my lords, in a written statement. After, my lords, his death, his legal heirs, my lords, would immediately come on record. Now, after a lapse of more than 10 years, now in 2026, my lords, an application is filed saying that they would now like to, my lords, examine 2 witnesses
One person who was a GPA holder on behalf of the sister of the original defendant. The second person who was allegedly a lessee in the property which is now agreed to be sold in my favor.
For what purpose?
They don't mention it. That is my challenge before this court. Have a look at, my lords, the impugned order. Your lordships have consistently held, my lords, under order 16, the compass is, my lords, threefold. The purpose, necessity, and relevance. My lords, I don't want to trouble your lordships on the judgment. I have carried 3 judgments in my favor. The trial court would barely say, does not even advert, my lords, to the facts of the case. Does not even advert to what is the relevance, what is the purpose, what is the necessity of examining these witnesses. The compass of adjudication in my list is only whether the existence or the bona fides of the execution, nothing beyond that in a suit for specific performance.
They're denying the execution of the document.
Now, my lord, these documents wholly unrelated.
No, no.
Please,
They're
my lord.
denying the execution of the document.
The original defendant only bare denial. Now, these legal errors, my lords, of the original defendant say,
For the purpose of proving that they require this.
that is not their say at all, my lords. Their say is, have a look at, my lords, the operative portion, let's 154, my lords, of my paper book. I'll just take a lordships, my lords, only to the operative portion of the impugned order and thereafter to their application. In fact, in their application, they don't even mention which of these defendants are even filing this application, my lords. I am making the submission, my lords, they may only be procedural lapses, only to indicate, my lords, the malafides of these defendants, the legal errors of the original defendant. Page number 154, if I may trouble your lordships with. My lords gets it. Please. Reasoning. The plaintiffs have filed the suit against defendants. Only if there was, my lords, only a single defendant. For specific performance, the agreement so and so. In the present application, it is stated that the proposed witnesses are material witnesses to prove the contentions of the defendant, to show the falsity and the contention of the plaintiff. Though the Honorable High Court, with due respect to the order of the Honorable High Court, is proceed to dispose within.
Where is that IA?
Please, my lords. The IA lordships will find at page number 242. IA is not supported by an affidavit also. A memorandum of facts by the counsel is filed. Without even describing, my lords, what is the necessity of even leading these witnesses. And their intention is very, very clear from the reading of this application. They, my lord, don't want me to enjoy the fruits of this litigation, which has been pending for the last more than 15 years. Page number 242, lordships will find the application. Raj gets it, my lord.
I'm looking at 243.
243, please. 243, my lord, is a memorandum of facts. How many defendants involved? More than?
Who is this Lazarus Lobo?
Lazarus Lobo, my lords, was the sister of the original defendant.
He says even before entering into an agreement of sale, it was leased to her, leased out.
No, it was not leased to her at all, my lords.
It's a case.
No, now, my lords, that is not the case of the original defendant, my lord. Lordships are aware, nobody could be more loyal than the king. It is not, my lords, I'll just explain, my lords, to your lordships. Just 3 sentences.
Said so that
Please.
they have not stated anything. Why they want to examine this witness?
Please.
But they said so.
No, my lords, this is not the say. Your lordships are aware, my lords. Now they'll have to state their defense. My lords, their application could not be in divergence to what, my lords, the original defendant has stated in the written statement. No pleadings to this effect, my lords. The original defendant does not say anything about this.
Please. The petition is agreed with order passed in I number 32, whereby the court has issued witness summons to the witnesses as shown in I number 32. It is submitted that without there being any pleadings, such an application is filed, and there is no nexus between the pleadings and the present application. This aspect was not considered by the court, considering the same. Now, if the suit is stayed.
No, I'm only requesting. It is my suit. I'm only requesting for the stay of the operation of the impugned order.
The stay of operation of the order in I number 32 dated 6/2/2026. Till the next date of hearing, same. The hand summons to the respondents and shall file a memo to the defect by 30th. If the memo is not filed, the stay granted by this court stands again.
Still number 28.
Lordships may permit me to serve a copy on the council appeal.
Answer.
I'm so deeply obliged.
Admission serial number 28. Puneet C.
Yes.
Malad, suit for declaration please, filed by the plaintiffs. Malad, the case of the Malad, the plaintiffs would be that please Malad, that their father purchased the scheduled property way back in the year Malad 24/12/1965. At para number 5, please Malad, they can take a contention that their father had approached the revenue authorities to seek Malad the revenue entries. And please Malad, pursuant to which the revenue entries have been not been mutated by the authorities concerned. And that please Malad, the continuation of a name of the grandfather of the defendant herein would only be a mere stray legal entry is what the contention of the Malad, the plaintiff would be. And as far as the cause of action is concerned, please Malad, they clearly admit that immediately after the registered sale deed, Malad, they approached the authorities is concerned. So Malad, the right to sue, please Malad, for the plaintiff was accrued in the year 1965 itself. So in so far as the declaration is concerned, please Malad, which is governed by Article 58, Malad, 3 years would be the limitation is concerned. From 1965 to till date, please Malad, to 2016, please Malad, there's a lapse of more than please Malad 4 decades is concerned. And Malad, as far as the knowledge is,
It is a question of fact and law.
Malad, question of fact, please Malad, one judgment, please Malad, very recent judgment of the Supreme Court, please Malad, to the point. May
Think that
2025 SEC. Malad, only 2 paras,
what will
please.
happen to the other judgments?
Please Malad.
What will happen to the other judgments?
Malad, this Malad, the para 20, which I would like to point out, only 2 paras.
Yes.
The use of the words when the right to sue first accrues as mentioned in article so and so is very relevant and important. It categorically provides that the limitation of 3 years has to be counted from the date when the right to sue accrues. And para 28, please, Malad. The other contention of the plaintiff, the acquired knowledge of the will and so in the first week of 2014, but that was not a complete knowledge as probably he could read the same subsequently. In dealing with the submission, the appellate court distinguished between the having knowledge and full knowledge to hold.
Here, that is arising out of a second appeal or a first appeal.
Please.
This before the, now we are not on the point of what is the limitation and which article will apply. We are on the
Malad,
point-
here is also please,
we are
Malad,
on the point when can that be decided at the threshold?
Malad, that judgment is also relates to the 7 Rule 11 application, please, Malad. It is not the judgment rendered on the merits is concerned.
No, it's there against that a first appeal is filed, I think. In the first, it is allowed, I suppose, in this.
Yes, please. 7 Rule 11 application is allowed by the Supreme Court.
First appeal is filed against the order passed in the regular appeal.
No. In 7 Rule 11 application, please, Malad. That judgment.
But after that, a first appeal is filed.
Please, Malad. Appeal is being filed and against which, please,
And in
Malad,
the
where
appeal-
there was a
in the-
distinction.
In the appeal, the court has dealt with all that.
Malad, in the appeal, Malad, the High Court, please, Malad, in that particular judgment.
I tell you, like there are so many judgments of the Supreme Court to the contrary.
Malad, my
Whether
own.
they were referred to in this case, they are not referred.
Malad, it's a 2025.
That's true. Whether the earlier judgments which are straight on the point, whether that issue, whether the law of issue of limitation is a mixed question of fact and law, whether it can be decided at the stage of order 7 Rule 11, those judgments are considered by this court or not. I mean, by passing this judgment,
Malad, my submission would be, please, Malad, is that
there should be some consistency in the orders. Now we have to consistently pass orders. Unnecessarily, no, the courts will be, they'll be confused what to follow, what not to follow.
But Malad, in the present case is concerned, please, Malad, 1965, Malad, the sale deed. They say that, please, Malad, they approaches the authorities is concerned. Right to sue, please, Malad, in the 1965 itself.
Apart from that,
Malad, if
but
that
this is the cause of
particular,
action.
Malad, if that particular averments were not in the plaintiff is concerned, please, Malad, certainly I am out of the court. But the plaintiff, please, Malad, has specifically pleaded in the plaint at para number 5. They have specifically pleaded in the para number 5 of the plaint is concerned.
Apart from that, he must have said something else also.
Malad,
How the
yes.
cause of action is accrued.
Malad, cause of action, please, Malad, these states, Malad, in the year 2000.
Stated that the cause of action arose on 27/2/2016. The cause of action is continuous one, and for the purpose of the suit on the subsequent dates, the defendant right to interfere with the peaceful position of the plaintiff. So these are all several. It's a bundle of facts.
Malad,
We can't take it basing on one statement.
My
Please
lord,
come.
why-
Dismiss, order will follow. Yes, next.
Cell number 29. Yes, Victor Manoharan, for petitioner.
Yeah, for petitioner, my lords.
Yes.
My lords, four defendant, my lords, had filed an application for rejection of plaint. My lords, suit was for specific performance, my lords, against the first defendant, and defendant number 2 to 4 against defendant number 2 to 4, they had sought for permanent injunction. My lords, the trial court, my lords, stating that whether the first defendant died prior to filing of the suit is a matter of trial, and therefore, my lords, had rejected my application, my lords.
What is the application? Let's see.
My lords,
According to you, there is no cause of action.
facts, my lords, plaintiff states that he had entered into an agreement of sale with the first defendant. And before he could
Let's
execute,
read your affidavit at page, at the affidavit at para number 6.
my lords, order, my lords, is at page number 12.
Not order. Your affidavit at page number 35, para number 6 will read.
I submit that the plaintiff had stated in the cause title para when the first defendant entered into an agreement with the plaintiff in respect of the suit schedule on 19/2/2015, and subsequently when the plaintiff demanded to perform his part of
So
contract.
it is your case that the first defendant is no more.
He's no more. No, before filing the suit
So
itself,
that's
he's no more.
what. So only looking at the averments in the plaint, no order can be passed under order 7 rule 11 as what you submit.
Please, my lords.
You have to place the death certificate before the court.
I've produced the certificate.
But the court cannot look into all that, any other material. That's the reason why it is dismissed. Please come.
No, my lords, because my lords, in the plaint also, my lords, in the cause of action para, my lords, he stated it's only against the first defendant. When first defendant is no more, my lords, even LRs cannot be brought on record.
Now, according to the defendant, the second defendant, first defendant is no more.
Please, my lords.
That is not part of the plaint or the document that is filed along with the plaint.
Please.
Now you have to come to record this finding, court has to look at the written statement or the other documents which you have filed to show that first defendant is no more.
Please, my lords.
Can that be, is that permissible in an application under order 7 rule 11?
My lords, when cause of action itself does not survive against the first defendant, my lords.
This is dismissed. Order will follow. Yes, next.
Cell number 30. Bhaskar Y.
Yes.
This is suit between landlord and tenant, my lord. Landlord and tenant. The suit has been decreed by the trial court. In the suit, the respondent has not produced any rent agreement or rent receipt. The petitioner is disputed.
Hand over the vacant portion of the property
Yes.
within 30 days from the date of this order. When is this order?
September, my lord. 15 September 2025.
Notice to the respondents. Petition is permitted to, just issue emergent notice to the respondents. Yes, 31.
31. Rajesh Sarapian.
Order 7 rule 11 application rejected by the trial court, my lords. First plaintiff is a girl. Alienation has taken place before 28 December 2004. So that extent, the honorable trial court agrees with me. So as the second plaintiff being a male, so the court says provisions of amended succession act does not apply. My submission was that, my lords, he was born in 1999. So when the alienation took place in 2004 by his father and his father's brothers and grandfather, he was minor. So he should have challenged the alienation within 3 years after attaining majority. He attained majority in the year 2017. He should have filed it before 2020. He filed the suit in 2024 on the ground of limitation. The court notices the arguments, my lords, but doesn't give the finding.
Come to the order.
Let's kindly come to, my lords, paragraph 12 at page 32.
52.
32 months. Internal page 10 of the order. Para 12.
Para?
12.
Please read.
The defendants further contend that the suit of the plaintiffs is barred by limitation. As per cause title of the plaintiff number 1 is aged 31 years and plaintiff number 2 is aged about 25 years. The plaintiffs in para number 8 and 9 of the plaint, they have categorically pleaded that they have demanded partition on 27/2/2024. Since the defendants have refused to effect the partition, they have secured the documents and thereafter they came to know about the alienation made by their grandfather as well as defendant number 9. Under such circumstances, the limitation will stand from the date of knowledge. Opportunity should be given to the plaintiffs to substantiate their plea that they have to know about the sale deeds during the year February 2024. Under such circumstances, the question of limitation is a mixed question of law and fact. And
According to them, they know about these sale deeds in the year 20 on.
The question of knowledge doesn't arise. Under Article 109 of the Limitation Act, my lords, it's 12 years from the day the alienee takes possession. Sale deed is of the year 2004, my lords. So under the sale deed.
No, if he is a minor, once he attains a majority, from that day 3 years.
He has attained majority in 2020. 2017. He attains majority in 2017. He should have filed within 3 years.
But still the court is correct in holding that it's a question of fact and law.
Lords, my submission is, my lords, his date given in the cause title, 25 years, cannot be changed, my lords, by any stretch of imagination. Alienation has taken place in the year 2004. The suit is filed in 2025 or 2024, after 20 years, my lords. So he has attained majority in 2017. So he will have the limitation period only for 3 years, my lords.
Notice to the respondents, petition is permitted to take out hand summons. If on the council so and so, if the memo is filed on 1st of June, July, this matter on 2nd of July.
Stay of further proceedings.
25 CR.
Because his other daughters have filed 2 suits, my lords, though all those were dismissed. This is the third round of litigation, my lords.
We'll hear on 2nd of July. If the memo is filed on 1st, it will come on 2nd.
Great.
Yes, 32.
I am appear for the petitioner.
One submission. 11, 12 and 14, my lords, dispense period. Notice may be dispensed.
What is that?
Selling defense along with me.
Who?
11, 12 and 14, my lords.
7. Filed a memo.
Noted in the cause title itself.
It is as noted in the cause title. The notice to respondents 7, 12 and
11, 12 and 13.
11.
11, 12, 13.
11, 12, 13 dispensed with for the other respondents and summons. Yes. 32.
32, I am appear for the petitioner, my lord. The respondent has filed the application, section 92 of the CPC, before the district court for seeking permission to suit against the trust and association. The section 92 says that the 3 criteria is very important. The suit is maintainable. First is cancellation of the sale deed, cancellation of the trust deed, or removing the trustees. Next, third is property. Here, the respondents is Ganesha. Previously, they are the trustees, and the trustees formation by the association. When they are the presidents of the association, they are forming the trust unnecessarily. That's properties belongs to the association. The lease deed was executed by the association president in favor of the trustee subordinates. They are associations member.
Anyhow, this order is dated 29th April 2026. We'll issue notice. It's just nothing will happen. It's not a case.
Already the notice was received by the respondent. They also gave it file the. I have produced the acknowledgement here with the advocate not present before, but in the vacation, that is 30th. He has received the copy. I have produced.
What is the name of the advocate?
Lower court advocate, and as well as appear before the High Court in WP.
What is the name?
Name, my lord, that is Anand. That is Anand, advocate.
Submitted that the matter came up in the vacation court. The trial court advocate has appeared before this court, and they have knowledge of the pendency of.
And also I am informed that advocate also yesterday.
What is the name? Write
Yeah,
on the
Anand,
paper.
Anand, madam.
Print the name of
Anand,
so
that is
and
name,
so.
Anand,
List this
advocate.
matter on 17 June.
Bill
Yes,
number
yes.
33.
That is day after tomorrow, madam. That's
That-
4 or
13th.
5th it is, yes.
What is the date I said? 17 June.
17th,
17 June.
stay the proceedings.
Nothing will happen. Court has,
Yes,
that,
ma'am,
co-
yes,
that
yes.
court
Much
is a
obliged,
busy court.
much
It
obliged.
has got so much of
Much
work.
obliged,
Yes.
much obliged.
Siddhartha DK.
The petitioner in this case.
Yes.
And there's some facts that I would like to award to the impugned order is at page number 16, Mala. The entire facts is captured in the order. I'll just read it, my lord. There's a suit for specific performance. It was decreed in terms of a compromise. The respondent was required to pay a balance amount of about 25 lakhs and I was required to execute
Where is
this.
the operative portion of the order?
My lord, operative portion is at page 36, my lord.
Oh, agreement is resigned. Hmm.
No, my lord, I am agreed only by a portion. It is my application. The contract is decided on based on my application. No difficulty about that. But the problem is where the refund is ordered, my lord, interest cannot be levied in a case where it is section 28. In a section 28 application, 12% interest is ordered, my lord. The default is on the part of the agreement holder who refused to come forward to pay the amount. When the default is on the part of the agreement holder who refused to pay, if interest is levied, that too from the date of the decree, which is for about 8 years, then the entire purpose of the rescinding of contract is frustrated because on an amount of 34 lakhs, he will be entitled to an interest of 32 lakhs. A person who is in the wrong cannot benefit out of his own wrong. So only on the aspect that the interest could not have been levied, if my lords may kindly see page number 35, the reasoning also is absolutely there is no reasoning, my lord. If para 21, if I may read. The plaintiff did not explain why he did not deposit the remaining sale consideration amount within the stipulated period. The plaintiff only deposit the balance consideration only because of the direction of High Court of Karnataka, not on the basis of compromise petition. Already 8 years over from the date of the compromise petition, certainly the value of the petition scheduled property is high. Hence, application filed by defendant deserves to be allowed. The agreement of sale dated 27/12/2013 stands rescinded in exercise of powers under section 28 of Specific Relief Act. Then, my lord, however, the defendant herein is directed to refund the amount of 34 lakhs with interest at the rate of 12% per annum. There is absolutely no reasoning on why interest has to be levied. And in this context, if I may read section 28, my lord, where it contemplates the order, section 28 of the Specific Relief Act.
Counsel for the petitioner submits that after a lapse of 7 years from the date of the compromise decree, when the plaintiff has when the plaintiff agreement holder has failed to pay the amount, then an application is filed by the petitioner under section 29 of the Specific Relief Act to resign the contract. That came to be allowed by order dated
My lord, 1/4/2026.
by order dated 1/4/2026. It is submitted that he is agreed as far as granting 12% interest on the amount of rupees 34 lakhs. On the amount of rupees 34 lakhs, it is submitted that the plaintiff in the suit, there is a respondent herein, is not entitled for any interest on the said amount, as because of his default, this order came to be passed, considering the submission of the council. The operation of the order as far as levy of interest at 12% is concerned is state. Notice to the respondents. Nothing is pending now before the trial court. Or
No,
it
my
will
lord,
take.
the execution is
No,
closed in terms of this order.
No, emergent notice.
Please, grateful.
Bill number 34.
This, I have
Is it-
filed wakalat in the morning for the respondent.
I am appearing for petition.
You are ready to argue?
Yes, madam.
Yes.
The copy.
Appearing for petition. Already saw soft copy to the.
That is wrong. The soft copy is
I'll
completely
take
wrong.
it up tomorrow, serve papers on them.
No,
No, we are ready to argue.
Yes.
A suit for ejectment and win profit. suit for ejectment and mean profit filed by the respondent. Respondent is a owner of the social property. Respondent GP holder, alleged GP holder is filed a suit for ejectment and mean profit. The trial court passed a judgment decree on 26 2026, my lord.
On 26?
26/3.
26 March 2026.
26.
Ejectment is ordered.
Ejectment is ordered. Mean profit is dismissed, rejected. Page number 25, my lord. In page number 25, order suit of the plaintiff is hereby decreed with cost.
It says the plaintiff attacks the vacant portion depending on the leave for mean profits. So this has to be decided. No, there is no urgency for this. We can hear it.
The tenant is already paid up to date rent, my lord. Hence, kindly impugned judgment and decree kindly be stayed. Impugned judgment and decree kindly be stayed. Already paid up to date rent, my lord, to the owner. Owner is resided at Dubai.
Oh, you're the tenant.
A tenant.
I am thinking you're agreed with the owner being agreed with the rejection of this mean profits.
Lord, this is the case where your lordship kindly appreciate. Kindly go to para 18 of the judgment, my lord. Just only one sentence I will read.
Yes.
Para 18. Coming to the aspect of rent, plaintiff contended that the defendant is not regular in payment of rent. The same is not denied by first defendant by contesting the case, while the second defendant contended that he is regular in payment of rent. The property has produced several rent receipts in his evidence. Those receipts are disputed by the plaintiff, stating that they are created. But the fact remains that though according to the plaintiff, regular rent is not paid, in this suit he has not sought for so and so on. My lord, from August 2021, he has not paid the rents. He is squatting on my property without paying the rent, and the respondent family totally depending upon the income of the rent.
What is the monthly then?
14,000. He is occupying the first floor accommodation, residential unit. Now he is squatting on the property. And in the cross-examination, he said that
the court only has passed an order for rejectment.
that is, your lordship kindly see para 19. The order of the learned trial judge is wrong on the point, with all due respect, that the plaintiff has sought for mean profit. The said relief cannot be granted only if it is unlawful possession. My lord, the moment I issue the notice under 106, my lord, your lordship, there is a judgment of the Supreme Court where it says.
You have to question this order.
My lord.
You have to question this order. You are also agreed by this.
Yes. No, we have not filed. We are filing the review petition before the trial court to review that by citing the judgment of the Supreme Court.
Yes.
My only point, my lord, your lordship is well aware. This time and again, the Supreme Court says that the tenant cannot be permitted to squat on the property without paying the rent. Let them deposit the rents. Your lordship kindly see the memo of calculation.
Then what is the finding of the court with regard to payment of rents?
The payment of the rent, the court said that I have not asked for the arrears of rent. And main profit cannot be disputed because he is a tenant. And moreover, your lordship kindly appreciate that he is not the tenant. His wife is the tenant, and he has not produced any authorization letter. Order 3, Rule 2, there is a bar. He cannot represent. Even he is not holding any power of attorney for that. He filed the affidavit to avoid any unnecessary delay. The trial court has allowed that application, Order 1, Rule 10. Strictly speaking, under Order 3, Rule 2, he has no locus standi to contest the matter.
In page number 46, my lord.
Solely.
The rent receipt, the tenant has paid up to rent to October 2024. This document is exhibit before lower court.
Up to 2024. From
24 October 2024.
Then 24 to 26, what will happen?
My advance is there, 2 lakh rupees.
Monthly rent is how much?
14,000.
So per year, how much it is?
Per year is
1,68,000. 1,68,000.
1,68,000.
That is for one year.
1
That
year.
is 25.
25.
What will happen to 26?
26 is total is 19 months rent, my lord, 2,66,000. My amount is there, 2 lakh rupees.
All that was adjusted. I have stated before the trial court that the rent,
But unfortunately, we can't go into all those aspects because that aspect was not at all dealt with by the court.
yes.
And
Yes,
this GPA holder, alleged GPA holder is filed the eviction suit. There is no locus standi to file.
What is wrong with this order? Why should we stay the same? Only thing is, if you want some time, we'll grant some time.
I will pay regular rent and stay the.
No, forever you say that you can't say that you can't compel the owner to give that property on rent to you.
Kindly grant the stay, interim order, my lord. Kindly stay the impugned judgment and I will try to settlement the case.
You will try to?
Settlement, compromise to the respondent, whether the property.
No, first you do it, then we will see.
No, otherwise you will file execution petition, the CRP is infectious.
He will file. If you don't pay the rent and happily
Rent already
enjoy the
paid up to date, already exhibit is there in lower court. He is only asking in profit and.
Then in that case, you should show the court what is wrong with this order. Then we'll consider. Just like that, I'll not stay.
This order is only eviction. I am regular pay the rent to the.
That's why I'll not go to that aspect. It's only on eviction. Why this order is bad? What is wrong with this order? What is not considered?
Finding is.
Come prepared. I'll hear the matter. Either if there is a scope for compromise, you can settle the matter, or else I'll hear on the merits. Or if you want some time to vacate the premises, that can be considered, but not just a stay. Or there is any scope for settlement, mediation, can it be referred?
no, my only demand before the court, my request is if he pays the rents, because the family is totally depending upon the rents. That is my only grievance. I have no.
According to you, how much amount is?
That is 8 lakhs 12,000. Your lordship kindly see.
Kindly refer the matter mediation.
No.
But I'll not grant stay. If you pay the money, then there is no other mediation is required. They're ready.
And pay the rent. I will pay.
Again,
66,000 due amount. 66,000 is due amount, my lord. As per my.
Not required. This is matter on 10th of June. Whatever, get instructions from your client. It is submitted that Mr. Mohammed Nasiruddin has filed his wakalat. His is directed to reflect his name in the cause list. Yes, next.
List number 2, serial number 1. Orders. Shaker.
Memo of withdrawal has been.
Do that. A memo is filed stating that the matter is amicably settled outside the court. The petitioner wants to withdraw the writ. Memo is taken out and discussed.
Serial number 2. Serial number 2.
Letter for extension of time.
Lords. Lords, may I make submission? List number 2. Serial number 2 in the list number 2. MFA 4846.
This is for letter is addressed.
Yes, my lords. My humble submission is, this honorable court has granted for 6 months. They did not complete. Again, they sought for permission, 4 months granted. For third time, 4 weeks granted. And they are not hearing the application for which the court has to hear the order, hear the application.
Mandated has not been.
Kindly order for the short possible time, my lords.
Just seeking another 4 months.
No, my lords. The application pending is not at all heard. If that is heard, the case would be disposed of. The application need to be heard on merits. And we have given our written argument also.
34/20/26 is addressed. The extension of
Just
time.
2 weeks is more sufficient, my lords.
Dispose of P and SC number 555 of 2005. 2005. The learned judge has sought for 4 months' time. Land counsel appearing to the petition submits that though the time is extended on 3 occasions, still the matter is not disposed of. Considering the submission of the land counsel and the letter that is addressed by the learned judge, another 3 months' time is granted for disposal of the case, and the learned judge shall ensure that no further requests are made, and in a time-bound manner, the case shall be disposed of.
Still number 3,
Great, my lords.
Vasant, inside fence.
For the respondents, this is a ex parte
So far as
stay.
the-
We've sought to vacate it. This is a 25-year-old partition suit. You have picked brothers and sisters.
Let him argue them.
My lord, may I begin by
What about
pointing out-
notices? Notices are
Notice,
complete?
my lord, may kindly see R2. He is, the address that we have
No,
given
not
is,
address, no, it's a pending matter.
my lord,
They must be represented by advocates before the trial court.
my lord,
Why are you not taking notice or
my
hand summons
lord,
on
may I
them?
point out the address which we have given is the same address which they have given.
No, take hand summons on the council.
Very well.
The matter is pending.
Lord,
In
except
respect of
for-
note R2, R6, R8, R9, 10.
May
The
I,
petition is permitted to take out
Lord.
hand summons on the council
may I just,
appearing for the trial. Yes?
R8 and 9, my lord, neither the envelope nor the acknowledgement has come.
No,
May
we-
be
we
held
have been
sufficient
for
there in
that,
the
like,
US.
Order shall be taken on the council appearing before the trial court, and memo to that effect shall be filed by 18th of June, or else the stay granted by this court shall stand vacated. Yes, on the date it will come. If the memo is filed on that day, immediate next day list this matter.
Still number
My lord,
4.
the stay may please
The order
be,
earlier granted is extended. Yes,
Great.
4.
Still number 4.
Yes.
My lord, I appear for the respondent, my lord.
Respondent number 4, please, Lordship. In this matter, Lordship,
For petitioner, my lord, senior is in VC.
We appear for the petitioner.
My lord, I appear for the respondent, my lord. An
Who
order
appear for-
appointing a commissioner for partition.
1 minute. Huh?
Saravana sir is appearing in through.
Where is he?
It's held up in some.
Sarvana is for petitioner.
Some technical difficulty was apparent through virtually, mothers.
Passover?
yes, it may be pass over, please, Lordship.
What about notices to R5?
No, notice is not required, please, Lordship. The matter, final decree proceedings, the petitioner, 1 to 3, kind to be pass over.
Passover. Yes, 5.
Still number 5. Devanna Ballare. Petitioner, my lord.
For respondents case, my lord.
Okay, petitioner, my lord. Next.
Office objections. Why you have not complied with?
My lord, only one
Office
office
objection
obje-
shall be complied with in 2 days, or else the writ petition shall stand dismissed on that ground. Yes, next.
Still number 6.
Serial number 6, my lords, appear for the petitioner. Court commissioner has filed his report, my lords. Received it yesterday. Be taken up anytime next week.
Ashif, I am the court commissioner in this matter, my lord. I verified the spot on 2/5/2000.
No, let him come up with objections to that, then we will hear you.
Much obliged.
Learned counsel for the petitioner submits that they have received the court, they have been served the copy of the report by the court commissioner. He wants to file his objections. When?
Lords, anytime next week, my lords.
Let's this matter on 22nd of June.
My lords, there's an interim arrangement that none of the parties should.
Interim arrangement as per the earlier order shall continue till the next date of hearing.
Grateful, my lords.
Yes, 7.
Still number 7. Janardana G.
Your Lordship, the
Janardana G.
writ petition needs to be converted in a MFA. This is an appealable order, but
Office
since
has
it comes
raised
under.
the objection with regard to maintainability, as a writ petition is not maintainable. Learned counsel with the petitioner submits that he may permitted to convert this writ petition into MFA accordingly. The petition is permitted to convert this writ petition into a MFA within a period of 1 week from today. The for all statistical purposes, the writ petition is disposed of.
Cell number 8.
I appear for the first respondent, my lord. My lord, actually, I had filed a caveat in this matter, but on the last date, it was not put up. My name was not added in the cost list, and interim order was passed. I filed my objections and vacation for stay application.
Lords,
Lord,
yesterday.
I'm
Served on
served,
you.
my lord.
Yes,
Papers are
yesterday,
served.
Milords, the papers are served and they are bulky. It may be called on 22nd, Milords, we'll go on with the matter.
My lord, one submission, my lord, if I may be permitted. My lord, one,
No, when you can argue and have an interim order, you can as well argue it now. We'll hear,
Please,
nothing else to be.
my livelihood is gone because of the
Tomorrow
order.
could be called, Milords. There is a ceremony today in senior's house.
Tomorrow.
Obliged, my lord.
Till then, Milords, interim.
Tomorrow at the list this matter tomorrow at the request of friend counsel the petitioner. Interim order already granted. Order granted. Earlier is extended till then.
Cell number 9.
Lord, may be kindly posted in hearing on IA, if the direction is fine. In orders, it has come.
Service is
Wherever it
awaited.
is, it will reach. Yes.
Obliged, my lord. Obliged.
Cell number 9. Mallikarjun or Medivar.
We'll see after lunch. And don't call the passos, continue with the list.
My lord, may I make a request, my lord?
No request now.
ಎಲ್ಲ ಹೋಗಿದ್ದೇವೆ ಏನ್ ಮೆಮೊ ಹೇಳಿ ಮೆಮೋಸ್ ಎಲ್ಲ ಕಳಿಸಿದೀವಲ್ಲ
ಅಲ್ಲಿ ಅವರು ಕೋರ್ಟಿನ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬರೋದಾದ್ರೆ ಬೇಗ ಸ್ಕ್ರೂಟಿನಿ ಮಾಡ್ತಾರೆ.
ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಹೇಳ್ತೀರಾ ಎಷ್ಟು ಮೆಮೋಗೆ ಹೇಳ್ತೀರಾ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ 150 ಮೆಮೋ ಕೊಟ್ಟಿದ್ದೀವಿ ಯಾವ ಕೇಳಿ ಹೇಳಿ ಹಂಗೆಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ ಇದ್ರೆ ನೀವು ಹೋಗಿ ಅವ್ರಿಗೆ ಹೇಳಿ ನಾಳೆ ಅರ್ಜೆಂಟ್ ಇದೆ ಅದಕ್ಕೆ ಮೂವ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅಂತ ಹೇಳಿ
ಹೇಳ್ದೆ ಅವರು ಕೋರ್ಟಿಂದಾನೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬರ್ತಾರೆ.
ಮೇಡಮ್
ಇಂಪಾರ್ಟೆಂಟ್ ಮೆಮೋ ಮೂವ್ ಮಾಡಾದ್ಮೇಲೆ ಯಾವ ಸ್ಕ್ರೂಟ್ನಿ ಆಗಿದ್ದ
ಮೇಡಮ್
ಹೇಳಿ ಏನು ಸರ್ ಹೇಳಿ
ಮೇಡಮ್
ಸರ್
ಪಾಸ್ ಅವರ್ ಮಧ್ಯಾಹ್ನ 2:30ಗೆ ಮೇಡಮ್.
ಸರ್ ಪಾಸ್ ಅವರ್ ಎಲ್ಲ
Second list, seal number 3 ಏನಾಯ್ತು ಸರ್?
ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ ಸರ್.
ಆಫ್ಟರ್ ಕಂಪ್ಲೀಷನ್ ಆಫ್ ಲಿಸ್ಟ್ ಮೇಡಮ್ ಪಾಸ್
ಆಫ್ಟರ್
ಅವರ್
ಕಂಪ್ಲೀಷನ್ ಆಫ್ ಲಿಸ್ಟ್
ರೀಚ್ ಆಗಲ್ಲ ಅನ್ಕೊಂಡ್ರೆ ಇದನ್ನು
ಪಾಸ್ ಅವರ್ಸ್ ಆಫ್ಟರ್ ಕಂಪ್ಲೀಷನ್
ಓಕೆ ಮೇಡಮ್
ಕಾಲ್ ಕಂಟಿನ್ಯೂ ದಿ ಲಿಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಎದ್ದೇಳುವಾಗ.
ಪ್ಲೀಸ್.
ಹಾ
give the list.
List number 2.
My lords, item number 27, list 1, my lords. An order is already passed. In that, my lords, had order for issuance of notice to the respondents, my lords. My lords, few of the respondents are placed ex parte before the trial court, my lords, filing a memo for dispensation, my lords.
Take that. That is serial number 20.
List 1, 27, my lords.
27. Already order is passed. A memo is filed seeking dispensation of notice to respondent 1, 2, 3, 4, 5, 6, 7, 8, 12, 13, 14, 16, 18, 23, and 24. Same with dispense with at the risk of appellant. So you shall take out hand summons on, just look at the file, other respondents, and shall file a memo to that effect as it was in the earlier order.
Dead, my lords.
Yes.
List number 2, serial number 9. Mallikarjun.
Atisha shall take out the hand summons on the counsel pending for the respondent before the trial court and shall file a memo to that effect by 23rd of June, or else a writ petition shall stand dismissed without further reference to the court.
Serial number 10. Pavan.
I appear on behalf of the petitioners, Your Ladyship. Your Ladyship, in this present matter, there was a clarification that was warranted regarding office objections, Your Ladyship. There was some confusion. The learned trial court has passed an order only on one of my IAs that I had filed. Your Ladyship had directed for compliance of that office objection.
Unless and until what the registry says is IA2 to be clarified at prayer and same is not forthcoming.
I just wanted to clarify that we'll be pressing only on IA number 1, Your Ladyship. If Your Ladyship may kindly permit me, there is some urgency if I may point out certain things. I'll comply with that office objection during the course of the day. There are certain events that have transpired.
Yes.
If I may.
What is the suit for? Where is the impugned order?
The impugned order, Your Ladyship, will find it at page number 23.
Yes.
24 is the operative where a notice is issued. Hence, issue emergent notice on IA number 1 and suit summons to the defendants. Along with my suit, Your Ladyship, I had filed an IA seeking for an order of temporary injunction.
Oh, when the defendant is making construction contrary to the sanctioned plan, did you brought it to the notice of the BBMP?
We have, Your Ladyship, and
what happened? When did you give a representation?
Where is the suit papers?
That is precisely what the court has observed. When the BBMP can take the action, why do you want an injunction?
Your Ladyship?
The BBMP can take action against them.
Because, Your Ladyship, if I may point out certain photographs.
It's not about photos. Why did you not approach BBMP when it is specific case that contrary to the plan, they're doing something?
Well, because there is no action taken, Your Ladyship, there was imminent
Where
threat.
is
They have
that?
already
Where did
concluded
you say so?
70% of the
Where did you
excavation.
say so? When did you give the complaint? When is the representation to the BBMP? If they are not doing it, if you file a writ petition and seek orders from the court?
They are interfering within my property limits. That is the issue. It is not within their premises that they are doing this. This is within my land.
To your IA.
Yes. Where is the It's at annexure D, page 41, Your Ladyship. They've demolished the boundary wall of my property.
Your case is that due to recent rains and because of the excavation, it fell down.
They've been conducting excavation within the premises of my property, Your Ladyship. That is the.
That is not your case. I'm seeing your petition.
Para 9, if I may point out, Your Ladyship, in the
I
affidavit.
submit that the said excavation is being undertaken in a reckless, negligent and unscientific manner in violation of established engineering practices and statutory requirements, thereby endangering the adjoining properties. Due to unsafe construction activities, particularly during recent rainfall, there has been severe water accumulation, soil erosion and destabilization of the land, directly impacting the plaintiff's layout.
Para 9, if I may point out, Your Ladyship. I submit that water, mud and debris from the defendant's construction site are entering into plaintiff's layout.
Precisely, this is something which can be addressed with the BBMP.
Your Ladyship, the excavation process is
You have
already
said,
at
no,
70%, Your Ladyship. They'll conclude the process, my entire suit will become
This is on
infructuous.
2/5/2026. I'd have gone to the BBMP and even if a writ petition is filed, by this time it would have been addressed.
In respect of availing my remedies before the BBMP, I'll approach the honorable authority, Your Ladyship, to the limited extent of protecting my rights
What is that? What is to be protected? You tell the court.
to stay the excavation.
Why should we stay the excavation?
Because that
They're
construction
entitled-
itself
They're
is,
entitled to excavate and construct because they have a valid permission.
that is within my premises, they don't have a permission.
But you're not saying so anywhere that they're doing in your premises. How could they do? How can they do in your premises? Look at your own affidavit. Show one line that they're doing something in your land.
If I may point out from the pictures, Your Ladyship.
Pictures though, you have to make a foundation for your pleadings.
My lords, if I may point out, this is the boundary wall. The excavation is happening right under it. So it is entering my property and it is entering the plaintiff's layout. That is the issue, Your Ladyship. The water and the entire mud and all of that, that is entering into my premises.
Now what the order the court will pass now? What is that you're expecting the court?
To
I
say,
cannot say stop their construction because they're constructing in their land and because of that excavation and as you said in your petition, because of the rains, erosion of mud and all, you are somehow it is touching your this thing. So what is the order now?
at least an order of status quo till BBMP takes an action, Your Ladyship.
Why should it be? When BBMP can do something, you don't go to them, go to the civil court, file a suit, come to the high court and now say till BBMP takes some action, you stall that.
Because the time taken to act on such complaints is longer. That is the reason we had approached the civil court to exercise our remedies. And there are oddly around 2,000 residents in the entire layout. All of that, their livelihood will also be impacted. That is the only concern. In the meantime, till I approach BBMP, at least till then, if your lordships may kindly protect.
This is not a one step before that. Because we can't stall the construction. If you have pointed out exactly what is, then we could have granted, some order could have been granted. That's why the court has issued notice. When the matter is coming up?
It's on 9th of July, Your Ladyship.
9th of July.
July. And even earlier, Your Ladyship, if you are at annexure G, page number 61, there's already a similar order that has been passed in respect of these very respondents. If I may point out, at page number 63. This is alienation.
This is altogether a different issue.
This is on a different footing.
Please come. Then counsel for the petition submits that. When the respondents are while constructing, in the process of construction, they have started excavating the land. And the petitioner's structure, which is adjacent to the land, is being affected. And in fact, due to the said excavation, the compound wall fell down. And there are about 2,000 people living in the said apartment. It is a grievance that the respondents, without taking any precautions, they're making the construction, endangering the lives of several thousand people. Who are the respondents?
The builder and managing partner of the.
Considering the submission of the land counsel for the petition, the respondent defendants are directed, there shall be direction to the respondent so and so not to make any, not to make, they shall not carry out the construction which will have an impact on the petitioner's building. The second respondent shall take, the respondent defendant shall take all precautions, listless man and precautions. It's a kind of an order which we pass in a writ petition.
Deeply obliged to you.
The petition is permitted to take out hand summons on the issue emergent notice to the respondents.
I may trouble your leadership with hand delivery.
Hand delivery of the order is
Very
permitted.
grateful.
11. Sushant.
Yes, tenability of the writ petition.
I beg to appear for the petition, my lord. My lord, the petitioner herein has challenged the impugned order. My lord.
The registry has raised an objection with regard to maintainability.
My lord, with respect to that maintainability, I would say.
What is this order?
My lord, this order is passed by the Land Trial Court, wherein restraining the petitioners to enter their own ancestral and co-personal report.
No, an injunction is granted.
My lord, there's a bare injunction suit filed by the respondent plaintiff. Respondent plaintiff's husband and the petitioner's late husband are brothers. Their joint family properties, my lord. Despite the pending suit in the same court in a senior division, the court has observed in its impugned order, but the observations are contrary to the impugned order, my lord. My lord, there is a pending.
What is the issue with regard to maintainability? That you have to tell the court first.
My lord, issue with respect to maintainability, there is a there's a statutory appeal available to the petitioner under 43(1)(a), my lord.
Yes.
My lord, but this order, wherein the teeth of Supreme Court judgments and the principles are while.
So appeal, why can't you go before the court and appeal?
My lord, before the statutory appeal, this law cannot be adjudicated, my lord. My lord, the factor wherein the.
Before whom?
My lord, appeal is before the senior division, my lord.
Then why the senior division judge doesn't understand law?
My lord, again, it will put into the test of the three.
No, that is not the, please come. The office has raised an objection with regard to the maintainability. As a petitioner, without preferring an appeal, has come before this court by filing the writ petition.
My lord,
then counsel for the petitioner submits that all these issues cannot be decided by in the appeal. As such, he is constrained to come before this court. He relies on a judgment. What is the judgment, Pastor? He relies on the judgment of the Apex Court and Suryadev Raj versus Ramchandra Roy and others, reported in 2003, 6 SCC, 6/7 February, which.
My lord, at page number, my lord, at para number 38, my lord. 38. 38 clause, 38 subpara 4, my lord.
38?
38, 4,
Entire paragraph 38.
My lord, at internal page number 695 of the judgment.
Paragraph number 4.
Paragraph number 4.
Yes, in paragraph number 38, 4. And relying on this, the petition before this court is maintainable. The submission that is made with the petitioner that these issues cannot be decided by the by the appellate court in the MA, this court is not able to appreciate the said submission, the petitioner has to go before the court and file the appropriate appeal. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy within a period of 1 week from the date of receipt of the copy of the order.
Till number 12,
Obliged.
Pala Gopal Krishna for petitioner.
Yes,
Petitioner, kindly have it on next week, my lord.
Why?
Senior is not in station.
it's on me. Even if senior comes, this maintainability issue will not change.
You will engage
What is the
senior
impugned
counsel.
order?
You will engage senior counsel. Kindly have it on next week, my lord.
What senior counsel will do? What is the maintainability issue that we have to see?
Kindly have it on tomorrow.
This is matter tomorrow. Yes, 13.
Till number 13, Subramanya R.
Yes, I appear on behalf of the petitioner. With respect to the maintainability, I am only seeking a direction with respect to prayer A, my lords. The maintainability is insofar as prayer B is concerned.
What is prayer number A?
Prayer
What
A
is prayer B?
Prayer B is challenging the order passed by the trial court, my lords. Prayer A is to seek direction to the trial court to consider my application for Order 39, Rule 1 and 2. What has happened in the suit? The defendants have filed a counterclaim and they have filed an IA for temporary injunction. And the defendant's temporary injunction application is allowed, restraining me from interfering with the possession. Despite the fact that the defendant has already filed a another suit for injunction against the very same parties. Not considering this aspect, the trial court has restrained the plaintiff itself.
When did you file the IA?
IA was filed on prayer.
When the matter is going to be listed before the trial court?
1st July, my lords.
It's already listed, 1st July.
1st July.
Please come. So what is this order dated 30/4/2026?
That is the injunction order passed by the trial court against the plaintiff, my lords, on the application filed by the defendant seeking temporary injunction in my suit.
And your application for injunction
It's
is also
pending,
pending.
my lords. Notice is issued in that application and it is kept pending for consideration. The trial court observes that once the defendants are heard, we will we'll consider your application and pass appropriate orders. Until now, that application is not considered, my lords.
But the court can hear defendant's application and grant injunction against you.
Please, my lords, that's what has happened at Annexure E1. The order on my IA is at 84, saying that the defendants will be heard and then appropriate orders will be passed.
But the defendant was present by the time notice
Please.
was issued.
Please, my lords. All these contentions were brought before the trial court, and the trial court also goes ahead and holds that since I am claiming possession through a mortgage deed.
This order is dated 7/2/2026.
Please, my lords.
And the other order is?
34/2026.
Then what are you doing from 7/4/2026?
My lords, I'm only seeking a direction to the trial court to consider my application, my lords.
So from that day, what is happening?
On 30th.
It was on 7/1/2026.
Please, my lords.
Directed the matter to be called on 7/2/2026.
Please.
What happened on 7/2/2026?
Thereafter, the matter was heard on the defendant's
Counsel for the
IA.
plaintiff are absent.
The matter was heard on the defendant's IA, my lords.
How can it be? Where is that order?
Page number 88, my lords.
Please come. Petitioner has filed the writ petition with two prayers. Prayer number A is a direction to the seeking the mandamus, directing the court to consider the application that is filed by the petitioner, seeking injunction, temporary injunction within a time frame. And the second prayer is petitioner question the order dated 34/20/26 asked by the court granting injunction on an application filed by the defendant against the plaintiff. The office has raised the issue with regard to maintainability as a petitioner has a right of appeal before the senior division, before the district court. And instead of that, he has come before the court. Then counsel appearing for the petitioner submits that the petitioner is not pressing for the prayer number B. And as far as the writ of mandamus is concerned, there may be a direction to consider the pending IA in a time-bound manner. This court is surprised in the manner the applications are decided. One application which is filed by the plaintiff seeking injunction is kept pending, and an IA that's filed by the defendant seeking injunction was considered and order was passed. This IA came up before the court in the month of January, and an order on the IA passed by the defendant was passed on 34/20/26. Considering the same, this court is passing the following order. There shall be a direction to the so-and-so, to the senior civil judge at JMFC, Channapatna, to consider the IA filed with the plaintiff seeking injunction within a period of 1 month from the date of receipt of the copy of the order. Same, the court is not issuing notice to the defendant as no adverse orders are passed. As far as prayer B is concerned, liberty is given to the petitioner to avail the appropriate remedy. Yes.
May I
Tell
seek
number
one
14.
liberty insofar as the plaintiff being
Yes, so.
restrained?
14, Aditya
bless.
Narayan.
So far as maintainability is concerned, Lords, would your Lordships kindly see the second impugned order at page 26? Lords, an ex parte interim order was granted on 9th February. Before I place that, kindly see, my Lords, at page 26. When I moved, my Lords, the IA for vacating stay. In the teeth of Order 39, Rule 3A, the learned, my Lord, Civil Court passes an order extending the ex parte interim order, my Lords, until further orders. And my Lords, no reasons are assigned as to why, my Lords, that interim application cannot be decided.
Remedy available to you against that.
Lord, so far as this is concerned, my Lords, your Lordships have held that it is maintainable. I appreciate I could have gone in an appeal. But this, my Lords, is a jurisdictional error. Because under Order 39, Rule 3A, my Lords, the application should be disposed of within 30 days. And if it's not possible to dispose of it, my Lords, reasons must be assigned. What the learned civil judge does when I move an IA for extension.
I understand that the order is wrong.
Yes, my Lords. My Lords, possibly I could have filed an appeal, my Lords, but there is a, may I make one submission for, may I make,
We will not entertain.
Lords,
Already
may
the
I make
courts are-
one, kindly notice one subsequent development. I'll make one submission, my Lords, if it appeals to your Lordships, my Lords, Lordships will dispose. Lords, after this on 2nd June, we appeared. Learned civil judge, my Lords, rejects a further request for adjournment, takes the objections to my IA for vacating as nil, but again adjourns to 16th June, the matter before the civil court. Would your Lordships, my Lords, consider directing that the matter be decided on 16th June, my Lords, and dispose of this writ? I won't press any other relief.
Should you come to this court, and why should this court?
Lords, I mean, for 6 months, my Lords, on an ex parte interim order, my Lords, I've been, my Lords, has been
Then you
operating.
should have filed only a mandamus, sought for a mandamus, not.
I see, my
deciding
Lords,
order.
at that stage, my Lords, there was no order, my Lords, taking their objections as nil. There was an operating interim order against me ex parte for 4 months. So I moved a writ. At this stage, my Lords, I'm seeking this limited relief.
The present writ petition is filed, questioning an order to set us, questioning the order dated 9/2/2026 and 34/2026. Asked for third edition senior civil judge, Bangalore Rural, Invoice number 219 of 2026. Office has raised an issue with regard to the maintainability of this writ petition before the court. Then counsel for the petitioner submits that as that he has a right of appeal. But however, he has come before the court that as the court has failed to exercise, has failed to consider the petition filed by the defendant seeking to vacate the injunction that is granted. And now, even after filing the objections.
Please, application for vacating. Application for vacating by me, plaintiff didn't file, and on 2nd June, their objections was taken as nil. But my lords, time is granted for arguments.
So though the court has observed that the objections are not filed with the plaintiff, still the matter is adjourned to
16th of June.
16th?
June, my lords.
On to 16th June. It is submitted that from the last 4 months, the injunction that is granted, there is an injunction against the injunction is operating against the petition hearing, but still the court has not taken up the matter. Next paragraph. They are having other counsel for the petitioner peruse the office objections. Office has rightly raised the objection with regard to the maintainability, and the same is sustained. However, considering the argument of the learned counsel for the petitioner, this court is passing the following order. The writ petition is disposed of, directing the trial court, directing the court to to consider the vacate petition filed by the IA that's filed with the defendant seeking to vacate the injunction that is granted in favor of the plaintiff on the next date of hearing without further adjourning the matter. As far as the prayer with regard to the orders dated 30/4/2026, and then when you are proceeding there is no question of appeal to the appellate court now.
No more. I won't press that.
Yes.
I'm grateful.
Notice is not same.
Please, ma'am. I'm grateful.
Cell number 15, VD Raviraj.
Paper petitioner, my lords, office objection complaint within 2 days.
Within 2 days, office objection shall be complied with, or else the petition shall stand dismissed.
Cell number 16.
Yes, 16.
The trial court, my lords, and for the defendant in this. My lords, I have taken it, I have served it there. I have to get the acknowledgement within a day, my lords, I should get it.
This is matter on 10th.
7. So very grateful.
Yes,
Cell number
17.
17.
Lord, the office objection is regarding maintainability. Lord, I am not a party to the suit. Lord, it is a suit for partition filed in 2011. 2000.
So what is the impugned order?
The impugned order is an order of injunction against the other defendants.
So
through one of the defendants,
who is not a party can come to the High Court, can as well go to the District Court.
my lord, what happens is, I am not under section 96, my lord, I can file an appeal seeking permission. But here I am not a party at all. In the suit, I am not a party.
No, that's what I'm saying. Whatever are the grounds that you are raising here, that you are not a party and an order is passed and you want that order to be vacated, can't you file the same application before the District Court? That's what I'm asking.
My lord, I am filing an impleading application itself in the suit. My difficulty, my lord, is I am a builder. I have a joint development agreement from the 7th defendant who is the purchaser of the property. He claims to have some share in the property, and after coming off it.
Yes, whatever is your impleading application that will be discussed by the court.
My lord, in the meanwhile, what happens, my lord? I am paying around 30 lakhs interest, my lord.
We can't interfere with when you have a remedy. Why should the High Court go into that aspect? That too, this is not a.
My lord, if I were to have been heard before the court, my lord,
You are not a party at all.
he knows, my lord, that I am this thing. He knows I am a joint developer.
You filed an implead petition, and that has to be heard whether you.
My lord, the development has stopped, my lord, for nearly 1 month now because of this order. And by the time I get it vacated there, it is a prima facie this thing, my lord, that I am a.
The court understands the hardship, but you have to go through the procedure.
My lord, every month I am shelling out 30 lakh rupees towards interest, my lord. And this may continue till this order, till the trial court considers my application. First my impleading application, then an application for vacating of the injunction.
No, everything should be done within 2 months. That's what I'll direct the court.
my share, my lord, I may be permitted to continue to. What happens, my lord, this is one portion of the property. I am developing 5 plots neighboring to this.
If you want, you take notice to the respondents. I'll not, same arguments, we'll hear when the other side is there. Even that way also, I can't pass any order. Only
My lord may direct the trial court to consider my application for impleading and for vacating within 2 months from the date it is filed.
Please come.
And permit me also to file an appeal as per law before appropriate court against this order. In the meanwhile, that application can be.
Now, when the court is saying this side is vacate petition, where is the question of filing appeal? You can't have both.
I'll have a remedy also
No, vacate
of
and
seeking
appeal,
a
how
stay
can
of this order till then, my lord. That is.
No, vacate and appeal both will not, either if you want to go
Very
on
well.
file an appeal,
I'll file an application and an application for vacating.
Yes. Please come. The present petition is filed, questioning an order passed by the questioning an order of ad interim injunction dated 3/2/2026, passed with the first edition senior civil judge and JMFC Devanhalli in IN number 5 in OS number 368 of 2011. When counsel appearing for the petitioner submits that petitioner is not a party to the proceedings and he has filed an implead application. By virtue of this injunction, petitioner is sustaining huge losses. As such, he has come before this court questioning the said order. Next, the office has raised an objection with regard to the maintainability as the petitioner has the remedy of appeal before the appellate court, but not before this court. However, when counsel for the petitioner has argued on the merits of the matter and submits that every month he is sustaining losses to a tune of 30 lakhs, and unless the order of the court is suspended, every day counts for the petitioner, and the order may be suspended. It's fine. Having got the counsel for the petitioner, what is the material on record and the objection that is raised by the office. The office has rightly raised objection with regard to the maintainability. The petitioner, whatever relief is seeking before this court, he could have raised the same grounds before the appellate court, where his remedy is. And further, it is the case that his application for his IA for impleadment is pending consideration before the court.
No, it's not pending. I am about to file. It is on 20th.
The fact that the petitioner has not filed any application seeking impleadment before the court, it is submitted that the petitioner will move the court by filing an IA for impleadment and also the vacate petition. Then counsel submits that at least an order, a direction may be granted, direction may be given to the trial court to consider his applications within a time-bound manner. Next para, considering the submissions made by the petitioner and the fact that, and considering the urgency and the necessity that is put forth before this court deems it appropriate to dispose of this writ petition in the following manner. The writ petition disposed of, giving liberty to the petitioner to file an appropriate application for impleadment and also to vacate the impleadment as well as vacate. And the said application shall be considered by the court expeditiously within a period of 2 months from the date of filing of the said IAS. Number 2, this court is not issuing notice to the respondents as no adverse orders are passed, and before considering the application, a reasonable opportunity will be given by the court.
Greatly.
Bagoji Vijay Kumar.
Withdrawal. Where is that yesterday also? He has not come. A memo is filed seeking to withdraw the petition. However, it is stated that with the liberty to file a fresh petition. Yesterday when the matter came up, this court has adjourned the matter as liberty is sought, why they are seeking a liberty. There was no representation yesterday. The matter is posted to today also. There is no representation. The memo is taken on record. However, this court is not inclined to grant any liberty, accordingly dismissed as withdrawn.
Till number 19.
Paper petition.
Yes.
The second petition is not a party before the trial court. The second petition is not a party before the trial court. During the pendency of the proceedings before the second respondent, second petitioner
It's office objection and counsel submission.
regarding the second petition is not a party before the second respondent. And he has executed a release deed in favor of the petitioner. And parties have bifurcated their property to that extent and made the second petitioner as a party to these proceedings.
But how can you make him a party?
Where the land is the same question before the second respondent.
No, it's a KV matter. What is questioned before this court?
I am challenging the order of the second respondent, the drawing up of the electrical poles in the lands of the petitioners.
Where is that?
May kindly look into, I had produced the sketch in
No, where is this order?
Annexure M, page number 26. Only the extracting, there is no reasoning in the order of the second respondent. Whatever the pleadings is there, that has been extracted. Whereas during the pendency of the proceedings before the second respondent, Union of India as well as state government had issued a guidelines. Those guidelines has also not been followed by the second respondent. Drawing up the lines in zigzag is not permissible. Where in this case it has been zigzag lines has been drawn. I kindly look into the photographs which I have been produced. Page number 120.
There is only one respondent before the authorities.
Second respondent.
Deputy Commissioner.
Yes.
Only you are the one petition is there.
Yes. Whereas the brothers, petitioner 1 and 2 are the brothers. There is a division between among them and they had released the executed release deed in favor of the second petitioner. For that, the property has been bifurcated. That land was being questioned before the second respondent.
Yes.
The page number 87, Annexure Z. The guidelines has been issued by Union of India for payment of compensation in respect of drawing up the lines. This circular has been placed before the second respondent. In order, it has been not reflected. Guidelines 1 to 5 and 8.
No, you cannot obstruct laying of the lines.
They cannot
You can only ask for the compensation.
compensation.
Oh.
Where I had seek and compensation. Where in respect the photos which I had been produced, may kindly look in page number 120.
No, this is for who has gone before the commissioner.
First petitioner.
What is the relief they are seeking?
Seeking
You are
for-
only obstructing.
Obstructing for payment of compensation and regarding drawing up of the lines. Where in
Compensation is paid. Huh? First matter. Who appears for them?
Mr. Devraj is there.
Yes, when the name, it is the For which respondent? First respondent. No, first respondent, 1 and 2, AGA takes notice. Third respondent, so Mr. Devdas.
Devraj.
Is directed to take notice.
Where I has an interim order before this some but earlier it had been granted. Till the conclusion of the proceedings before the first respondent, not to draw the lines before the.
No. We can't stall that. We'll ask him. This is matter on 8th.
The connected matter serial number 50.
My lords, I'm appearing for the petitioner, my lords. Am I audible, my lords?
1 minute, yes.
Though the matter is settled between the parties, my lords, with respect to the liquor license, which is part of the settlement, is now in auction, my lords. So I'll request my lords to kindly have it on 8th, my lords. I have to gather information from the department, my lords. 8th, that's Monday.
He's requesting Monday.
Monday, my lords.
Please, my lords.
Yes, matter on Monday.
Please, my lords.
Serial number 21, hearing on IA.
For the petitioners. Lords, the petitioner is a plaintiff in a declaration suit, ma'am. Lord, respondent defendant number 1 has filed an application to impound the agreement to sell, my lord. That application was allowed, and my lord, in the agreement to sell was treated as a conveyance, and my lord, was directed to pay a compensation as per the market value, 5% of the market value. My lord, the court itself, my lord, determined the amount, taking into consideration one of the sale deed, and said, my lord, I should pay the amount of rupees 60 lakhs. Plus, my contention is, my lord, the entire agreement, nowhere it is stated, my lord, that property has been conveyed under the agreement. Nowhere, my lord, that's my current senior has the translated copy, my lord.
Just pass.
The only point is, my lord, whether it has to be paid as a conveyance or not. Read the.
No, first let's read the order.
Please, my lord.
Where is the order impugned?
Plus, annexure A, page 12, my lord.
Yes.
Plus, the reasons lordships find it. Page 31, the bottom, my lords. 3 lines from the bottom. Furthermore, plaintiffs have not explained the proper reasons for execution of the alleged agreement. Krayada Poppanda Kararu Patra dated
Paragraph number 21.
21, my lords, the bottom lines.
Plaintiffs
Observation.
have not explained that.
Please. Plaintiffs have not explained the proper reasons for execution of the alleged Krayada Oppanda Kararu Patra dated 3/5/2016. The plaintiffs and defendant number 2 unequivocally admitted that they are claiming share in the suit scheduled properties. Looking to the contentions of the parties, it is clearly appears that transfer of estate is claiming under the said Krayada Oppanda Kararu Patra. Under such circumstances, the proper stamp duty to be paid on the said document is as per Article 20 of the Stamp Act, as contended by the defendant number 1. As per Article 20 of the Stamp Act, 5% of the value of the property is to be paid as a stamp duty.
It could have been sent to the registrar.
Now they have sent it.
No, what has happened?
Could have determined it.
Please.
Their contention
I'll
laws.
just complete, Malad, because what has transferred, so that now, Malad, based on this order, Malad, registrar has sent a letter. Plus, because the learned judges determined the amount, Malad, the registrar hands are now tied. Malad, directly given me a notice to pay this amount. Malad, it will not attract Article 20.
Now your argument is, are you accepting that this is the Article 20 of the Stamp Act will apply or not?
It will not apply.
So once you, if that is your argument, so we don't have to look at whether who has to do it. First of all, so you have to convince the court on this.
Please, Malad, that's the contention is Article 20 is applicable. I'm saying it is not applicable because the learned court may just treat further, Malad.
Let's see this document.
Translate it, please. Para 3, Malad, may just. The scheduled property having been purchased by Nagaraju, that is defendant number 1, by virtue of the registered sale deed dated registered in the so and so 2/5/2016, 4 lines, having 2 servant numbers measuring 2.4 acres, which is converted undeveloped property from Dhan Singh and their family members and Vimal Singh so and so and their family members. Though the sale deed having been registered in the name of Nagaraju, but I, Nagaraju, and above 3 members have invested money according to the percentage in the purchase of the scheduled property, and we have decided to develop the property and divide into sites, and have agreed that whatever the expenses arising towards the development of the property shall be divided equally among me and three of you. And after development and alienation of the developed sites, I have agreed to share the profit and money in terms of the percentage of investment of the money. If any income tax and etc. arises from the scheduled property, we have agreed to pay it from the profit, and we have received from the scheduled property. And the percentage of the investment is as follows. Nagaraju Mula, different number 133. DY Udayakam, please. So in third line, so after the development and the alienation of the sites, Nagaraju has agreed to share the profit according to our percentage of investment out of the profit. And Nagaraju have agreed that I will not create any problem or litigation. And in case if sites are not sold, after calculating in terms of the above mentioned percentage of the investment of money, I will register the sites in their name or in their nominee suggested by them. In case if I refuse to pay the percentage of the investment and the profit or raise any disputes to get the sites registered in their name, the above mentioned three persons have right to initiate.
To you, what is this? What are the rights that flow from this document?
It's according to me, it's my lords, what has happened. We are four friends. Lords, we all invested in properties purchased in his name. The understanding was that, my lord, we all four persons will contribute equally. Means we contributed. Land was purchased. It was converted, developed. Sites were formed. The understanding is, my lord, after forming sites, it will be sold to the prospective purchaser. My lord, the profit from the purchase will be shared equally as per our investment. My investment is 33%. So after selling the sites, the percentage of profit only we agreed to be shared. What is the profit? In the event sites are not sold, and if the defendant number one turned back and did not give the profit, then I've been given rights to have the share. I can seek the sites which are lying instead of selling. If the sites are lying, it is not
You
so.
have to tell under which what is the nature of it, and it will fall under which article.
No, this will fall under Article E1, my lords.
Let's see.
Please. Article 5, my lords. Article 5 E.
Stamp it. Article
5, my lords. Article 5, in that, my lord,
Karnataka stamp.
Stamp Act. 5E. E says, my lord, if relating to sale of immovable property, wherein part performance of the contract, possession of the property is delivered or is agreed to be delivered before executing the conveyance.
Show me schedule 1.
May I pass on, Lords? I have a
Yes. Yes.
E says, if relating to sale of immobile property, wherein part performance of the contract, one, my lord, says possession of the property is delivered or is agreed to be delivered before executing the conveyance. Notes in the entire document nowhere says possession is delivered or agreed to be delivered. So this will not applicable. Number 2, my lords, bottom, possession of the property is not delivered. So my content Article 5 number 2 will applicable because possession is not delivered and not even whispered in the document. Therefore, my lord, treating Article 20 as a conveyance, my lord, to say that possession is delivered and asking me to pay the stamp duty as per market value will not come.
No, according to you, what will apply?
Means Article 5 2, my lord, the
Article 5 deals with
possession of the property is not delivered.
E2, Lord, your lordship, so had.
E2.
agreement or memorandum of an agreement. Even how will you fall under this?
It's because in any agreement, my lord, if the possession is not agreed, that has to be calculated as per article,
Read it, what it says.
the article.
Yes.
Article 5E says if relating to sale of immovable property, wherein part performance of the contract, number 2, I will read it, my lord, for continuation. Possession of the property is not delivered. In this case, my lord, possession of the property is not delivered, not even whispered, my lord, about the possession. It is only agreed, we'll share the profits after selling the sites. If sites are not sold, you will have a right of the specific performance of the sites which are lying, that's the only understanding, my lord. And possession is delivered, agreed to be delivered before
With regard to the rights of the properties,
Please.
with respect to that immovable property, are not crystallized by way of this agreement.
Well, it was only stated because there is an investment. It was only for a profit sharing investment. So an understanding between all of us because we all jointly invested.
No, come to 20.
It's Article 20. Article 20 is for conveyance.
Yes.
For conveyance as defined by clause D of section 2, not being a transfer charged or exempted under number 52 on the market value of the property which is subject matter of conveyance. So what is conveyance has been defined under section 2C, my lord. Sorry, 2D. 2D.
That means conveyance includes a conveyance on sale.
Please, ma'am.
Every instrument.
Every decree or a final order of the civil court, every order made by the High Court under section so and so, by which property, whether movable or immovable property or any estate is transferred to or vested any other person.
Yes. It's like as your lordships are holding that notes. Now conveyance notes also includes every instrument. This instrument under 2J has been defined as every document. 2J. 2J. I don't have that. I suppose it's 2J. It is defined as every document notes which creates rights. Please note. Now notes, it is not the case of the petitioner here that he has no rights. He is saying I have rights. And that of profit sharing. Before that, he did not read the last line of the agreement, which your lordship's translated copy. The last line says, if I fail to give them what is their due, they have the right to initiate legal proceedings to recover the amount or get the site registered based on the sale agreement. The document itself is titled as sale agreement, and my learned friend's submission that no possession was granted and therefore no right is false. Their very own plaintiff, if your lordships could see, categorical assertion that we are in joint possession is there. Take your lordship, request your lordship to see the plaint. Annexure B, page 36 notes. The petitioner here is a plaintiff notes who says that this is the agreement of sale. We have right, title, and interest, and we are in the possession. And what's based on this very agreement, I have filed the document along with my statement of objections. He enters into further agreement of sale with some other buyers, says that I have a right under this 3/6/2016 agreement. Therefore, I'm selling my share. And he says I am in the possession, therefore I can sell it. He has entered into further agreement, and that is also reflected here, Lords, in fact, in the plate. So therefore, Lords, in my respectful submission, trial court order does not require any interference because it is
the trial court. How can he determine what is the amount to be paid? That is the second limb of the order.
Yes, Lords, because section 33 Lords, and 34 when we read in conjunction, 33 Lords, whenever it is brought to the notice of the court, Lords, it has to impound it. And then, Lords, the procedure 34 follows, Lords. Before then trial court is determined as.
Let the registrar determine what is the amount to be paid applying Article 20.
I request, I have relying on certain judgments passed by your own lordships and also of another division bench of this honorable court, Digambar Vati, which your lordships have relied in a couple of things, where this procedure is not upheld. That once trial court impounds it, it goes ahead under 34 and determines it. And then, if the party does not pay, because here also in trial court has given him so much time, Lords, from 2019 up to 2024. He undertakes to pay, Lords. I have filed order sheet, Lords, along with my objections. He undertakes to pay. He asks for time, Lords. Yes, Lords. Your lordships may kindly take my statement of objections. Annexure R1, page 12 is the order sheet, Lords.
Page
12. The portion I'm relying is at page 17, Lords. In running page 17, Lords. My objections, Lords.
When did you file your objection?
Lords, it was filed on 16th April 2026.
It's not there on record.
Lords, may I pass on notes?
Yes.
Please, go down.
Yes.
Even subsequently, trial court records,
But
Lords.
this is happening from when this is.
Lords, the order was passed in 2019. What happened, Lords? I had also filed an OIA for rejection, which came to be allowed. Then those proceedings were pending. Therefore, this order was
What
kept
is
in
this?
abeyance.
How can
Lords,
the
the
council
earlier
submit?
also, Lords, immediate, the year, my lord, in 2019, when this impugned order was passed, I had filed a writ petition. On the day, my lord, they filed 2 applications to reject the plaint and also impounded document.
No, what do you say about this? CGNH filed a wakalat for plaintiff number 1 by taking no objection from the previous advocate and prays for 15 days time to comply with the order dated 16/10/2019. Considering the fact that new counsel has been engaged, one more opportunity is provided.
My lord, what has happened? My lord, the earlier council was changed. My lord, we had filed a writ petition. And my lord, there was also, my lord, before the Honorable Supreme,
Is also changed.
Lord, this council, my lords, I need to verify. But my lord, before to that, if lords see the order, my lord, they were continuously pressing for
What is
the
the date of
complaints.
the order?
Lords, impugned order, Lords, is
Annexure A, page 12.
On 8/8/2019.
16/10/2019.
When is this writ petition filed?
My lord, my lords, earlier also there was a writ petition was filed. And the suit, my lord, was,
Petition is filed when?
no, this writ is filed on 21/6/2024.
But how unfair it is?
No, my lords, earlier also I had filed a writ petition, my lord.
No, you say on 8/8/2024 that you will pay the money.
No, my lords, the council said, my lord, because they are continuously pressurizing, my lord, to comply the order of dismiss this suit. My lord, writ petition was filed 2 months before it. My lord, the new council, my lord, said we'll look into it and we'll comply we will say, my lord, we'll comply the order. My lords, it was not, we are not undertook, my lord, the new.
Same counsel is appearing even now.
I'll just verify, my lord, because I also.
my client says it's the same person.
I'll just check on this, my lord.
My
Because
client is here.
Please check on this. That's the only thing to be.
Please,
My submission would be irrespective of that, my lords. The trial court order is not.
Let him say.
Please.
I'll check it, my lord.
List is started tomorrow.
Please.
Then counsel for the petitioners will submit before the court. The counsel who is representing the plaintiff when the matter is listed on 8/8/2024. Is it 8/8? Look at it. Give it to her. This is 8/8. Give that. 8/8/2024 is the same counsel representing the petitioners even till now or not?
It's even
Mr. Mark.
subsequently on 4/9/24, same counsel has asked notes.
Listen.
Yes.
Cell number 22. Through Prasanna.
Give this book to her.
Pray for the respondent. My lord, I pray for a very short adjournment.
Huh?
Short adjournment, my lord. Kindly have it tomorrow. Scene is appearing in.
Not tomorrow, it is not possible. Interim order earlier granted is extended. List is matter on 7th of July.
Please.
At the request of one counsel respondent.
Interim order makes
24,
sense, please.
extended.
Please.
Cell number 23, urgent 24. 24. Lokesh Kumar.
Respondent in this matter.
You file the vacate stay.
Application is filed by me in Lords.
No representation on behalf of the petitioner. This is matter for dismissal on 16th June. And what about your case? No, in the other case also that list on 16th June.
The other one is for non-compliance arising.
The in 24.1, or if office objections are not complied by the next date of hearing, the stay granted with the writ petition shall stand dismissed.
May I make one request?
Without further
Lords?
reference to the court. Huh?
May I request for vacating the interim order so that
16th, I'll do that.
any shorter date possible, Lords?
List on 11th,
11. I'm obliged.
yes. No representation. There should be on dismissal on that day.
Cell number 25.
Appear for the petitioner, my lord.
Lord, serial number 25, I'm appearing for the respondent's counsel, Lords.
Yes.
Lord,
My lords, the impugned order is at page 20. It was an application.
Both the counsels appearing online, it is difficult for the court.
Lords,
At least one-
I wanted to submit this, my lords. Can
I have
request-
some difficulty, my lords. I'm not well, that's why I'm online. I'm sorry for that.
Could
So
it be
if you
taken up,
can-
my lords, on day after tomorrow, my lords? Lords, after a direction
Can
was
it be on
given that the
Monday,
matter
sir?
should dispose
Can it
of
be
the
on
because they have dragged it for 2 years.
Monday. Sorry, sir, I have an appointment with the
Very
doctor.
well, very well. No
Monday.
difficulty, no
Look
difficulty,
at
please.
interim order extent. Yes.
Great.
26, case number 26.
Okay, for the petitioner in the first matter, my lords.
Correct, yes.
My lords, in this, my lords, the Supreme Court has also given a direction to the trial court to dispose of in 6 months, my lords. That direction was given in October. It actually has elapsed in April, my lords. In the meanwhile, the trial court has written to the apex court for an extension. But in the meanwhile, in these petitions, there is a stay, my lords, of further proceedings.
Let's see.
My lords, essentially, my lords,
Now we are looking at the first.
2338, my
The
lords.
other two petitions are filed by you.
Yes, yes, my lords.
What are those orders?
My lords, essentially one common order, 6 applications, my lords. So I have challenged 3 of the orders in my petition. They have filed 2 separate petitions challenging 2 of the orders.
So this
I am the plaintiff, my lords.
WP 2338 of 2026 is against IA.
IA 12, which is for amendment of the plaint.
Yes, only 12.
No, three applications, my lords.
12.
12, 15. IA 12 is for amendment of the plaint.
Hmm.
IA 15 is for striking off the defense.
Hmm.
And IA 13, my lords, which they have filed to produce additional documents.
Hmm. No, you're questioning.
IA 14, sorry.
You're questioning IA 12, 15 and 14.
12, 14 and 15.
Hmm. Then what about 26.1, 3193?
3193, my lords,
Yes,
is filed
filed.
by them. I had filed an application for restitution, which is IA number 13.
Hmm.
Rather, they had filed, my lords, an application. Just one moment, my lords.
Then 26.2, IA number
And
WP 3562.
my IA to directing them seeking for security, my lord, that is IA 13. Providing security is IA 13. That is 3562 is IA 13, which was
What about
allowed.
Before.
And the previous one, my lords, is their application for restitution, which was IA number 16.
Yes, come to the order.
Lords, the impugned order is at page 41 onwards.
40.
Reasons, my lords.
What is the suit for?
Suit for
Commercial
money,
suit.
my lords. Money recovery suit. Originally decreed in toto. Commercial appeal also dismissed, which was filed by them. Insofar as the second defendant, my lords, they remained ex parte. They never challenged it. So now Supreme Court has only remanded it back insofar as defendant number 1 is concerned. Basically, my lords, I am a dealer of motorbikes. I take a dealership from them. The respondent number 1 is the master franchisee who's taken it from a foreign entity. And they have the master franchisee for India and they've given it to me. And they're the manufacturer in India. Once they give me the bikes, I have to take spare parts from defendant number 2. So I have paid monies to defendant number 2. They also do not give me the spare parts. So effectively, the suit is decreed against them. I've also now filed execution, which is ongoing in Pune for defendant number 2. Suit is only remanded back for defendant number 1. In the meanwhile, my lords,
Why it is remanded?
the suit is remanded back on the ground, my lords, that they didn't file their written statement during COVID, my
Oh,
lords.
they were ex parte. Oh.
The defendant number 1 was participating,
But he didn't
but they
file
did
it
not
as-
file the written statement. They were contesting the suit for all other purposes. They were carrying on business otherwise. On the ground that they were in Hyderabad and couldn't come to Bangalore during COVID, they claimed and they filed the written statement beyond 120 days. Trial court did not accept it. Suit was decreed. High Court also rejected it on the ground that they were carrying on business otherwise, that they were doing everything else. And even this suit was being contested by them on all fronts. But Supreme Court in any case did not agree, my lords, but the Supreme Court also did not look into that aspect of them doing all the other things. In any case, it was sent back lock, stock and barrel. But during the High Court, my lords, that becomes important. What happens during the High Court proceedings, my lords? Maybe before I go through the impugned order,
We
my
are
lords, I'll
first
just...
looking at this order 6, rule 17.
Yes, Ms. Ma'am. For that, I'll need to give the backstory, which is during the High Court proceedings, what would happen, my lord.
This is, who wants to amend the pleadings?
The plaintiff wants to amend I want to reduce my claim, my lords. Initially, my claim is 178. I want to reduce it to 120. For that, they file objections. I'm reducing my claim. And the trial court dismisses it, my lords. That's the irony of
According
the
to you,
situation.
how come it has come to 1.2
Because they made voluntary and unconditional payments to me, my lords. That's what I want to point
during
out.
the pendency of the suit?
During the pendency of the appeal. In the appeal,
Let's see that IA that's filed by you under orders.
please, my
this,
lords. IA 12
order
is
6
at
rule
page
section.
137.
130?
137.
Mm. Mm. Yes.
Notes 137. I've sought to add 4 paras, my lords. Plaintiff submits that by the order dated 30/10/2021 passed by the Honorable Court in so and so, defendant number 1 was directed to take back 11 unsold BS4 motorcycles which are lying with the plaintiff. In compliance with the said order, defendant number 1 took back the said 11 BS4 motorcycles on 3/1/2022. If I may just pause here a minute.
Where were you reading this?
My lords, this is at page 137 I'm reading.
Yes.
This is my amendment application. In the meanwhile, my lords, BS4 vehicles were banned by Supreme Court, and also based on a government circular, BS4 vehicles were banned. Entire world knew that from 2020 April, BS4 vehicles could not be sold. The company did not manufacture BS6 vehicles till 2021. So during the pendency of the suit, I could not sell certain bikes. I filed an application for them to take back those bikes and return me the money. They took back the bikes. Application was allowed. They took back the bikes, never paid me that money. Now those bikes have been subsequently resold also. That's another part of it. So for the bikes that they took back, it is only right that they give me back the money. So what they would do during the appeal is give me back that money. So that is what I've sought to place on record in 47A and B. Plaintiff submits that. I'm reading
Lakhs on 28/3, 13 lakhs on 22/1.
Correct, my lords. These were payments absolutely unconditional. They do not say subject to outcome. In fact, during the High Court also records, my lords, the division bench records that parties are exploring settlement, that the defendant or the appellant in that case.
Now please come to the order which relates to this
My lords,
amendment.
Impugned order,
Yes,
para number 12,
para 12.
page 55, my lords.
Yes.
The trial court, my lords, culls out my amendment application in toto. Then at para 12, at 11, it culls it out. The above said proposed amendment sought for by the plaintiff has been strongly objected by defendant number 1. So as rightly urged by the other side, the above said amendment fundamentally changes nature of the suit. I am reducing my claim, my lords, in a money recovery suit. Instead of 100 rupees, I'm asking 99 rupees. As discussed supra, as per the observation of the Honorable Apex Court, when the judgment passed by this court dated 15/11/2022 came to be set aside.
What do you say as far as this IA is concerned?
Before that, can I just point out the High Court order, my lords, the order sheet? Because it's recorded there to show that it's unconditional and voluntary. May I just point that out?
No, not required. Yes.
My lords, let him finish it, my lords. Senior is not in town today.
Then what are you doing now?
My lords,
The court is doing. When the senior
My
is
lords,
not
we
in
also have
town,
serious-
we should have asked it
Yes, my lords.
before he starts his argument.
apologies, my lords.
You have an interim order in your favor.
My lords, I had not sought for a stay because it's my own
We
suit.
didn't seek for an
They
interim
sought for a stay and they've got a stay. So I
didn't
have
sought-
filed vacating in their matter and I've sought for early hearing in my matter.
You should have, your senior should have been here when the matter is called.
Apologies,
When they're filed a vacate petition. This is matter on 9th of June, on the day, at the request of Land Council, the respondent. In which matter vacates, at the request of Land Council, the petition in 26.1.
In 2, it is shown wrongly that I filed early hearing, my lords. In 26.2 also I filed vacating.
26.1.
1 and 2.
This is matter finally on 10. No further adjournments will be granted. It's all waste of court's time. Please understand. That's what my request to all the advocates.
Apologies.
Yes.
Then number 27,
Obliged.
A.V. Gangadharappa. For petitioner. Because
Respondents.
Appear for the petition.
Yes.
Before making the submission, I want to give certain factual aspects of the matter.
Yes.
there was a court of the senior civil judge at Chikbalapura, which was earlier part of Kolar district. Kolar district consisted of Chikbalapura and other taluks. And subsequently, Chikbalapura came to be declared as the
We'll take up
district
this matter
headquarters.
some other day.
No.
There is an interim stay, my lord. I filed an
We'll
application.
take up on some other day. It's not possible to hear these matters today.
I filed an perjury application also.
This is matter
Filed their objections.
on
In meantime.
24th of June. Interim order earlier granted is extended.
Short date, my lord.
Before.
Yes,
Till number 28,
Date may be given, my lord. Date may be given.
I said so now. What is the date? 24.
My lord, short date. There's a pending suit.
No, everybody wants a short date. How is it possible? List on 18th. Now see, now today's list is somewhere around 105. How many I will be able to complete by hearing every matter?
There's a stay on the suit property.
Stay in every matter is there. That's the whole problem.
Yes.
Yes.
Obliged.
till number 28, J.S. Venkat Subbarao.
I present petitions. The petitioners before your lordships, my lord, are plaintiffs in a suit for specific performance of an agreement of sale. Lord, under the part performance of the agreement, the original documents of title, my lord, are delivered to my possession, my lord, by the first defendant who was the earlier owner of the property. My lord, the sale deed having not come through, my lord, I have sued him, my lord, for specific performance. Subsequently, my lord, the property has changed hands, my lord, son has stepped into the shoes, and my lord, some property developer has come into force. My lord, 39 rules 1 and 2, my lord, they are dealt with, and my lord, the matter is now, my lord, seized by the Honorable Apex Court. Be that as it may, my lord, what happens, my lord, is subsequently, my lord, the defendants, my lord, filed, my lord, a complaint before the jurisdictional police, alleging, my lord, forgery and all those things. My lord, it appears, my lord, though they have not produced, my lord, some set of documents, they also claim to have, my lord, certain originals with them. We do not know what are they, because it is not, my lord, before the court. However, the documents, my lord, which we possess, the originals, including the agreement of sale and other receipts and title documents, were, my lord, we submitted to the custody of the court as on the date when we presented the plea. Well, that remained to be in the custody of the, my lord, court. My lord, thereafter, my lord, the police, my lord, who are investigating into the offence, my lord, said to have forwarded a requisition to the trial court, my lord, requesting for custody of the documents. But on receiving, my lord, such a requisition, my lord, we were not notified, nor a copy was served to us. My lord, the court, my lord, passes orders on that application, doesn't afford an opportunity of hearing to us, my lord, nor, my lord, objections could be filed. So, my lord, it is that order, my lord, and the challenge. My lord, order 13, rule 9, my lord, prescribe a certain procedure. How, my lord, the documents will have to be, my lord, given to the custody of, my lord, a third party who is not a party to the proceedings. Number one. Number two, my lord, having regard to the facts and circumstances of the case, my lord, there is a direction issued by, my lord, the learned single judge of this honorable court on an MFA that, my lord, matters will have to be expedited. And, my lord, kindly appreciate it's an unregistered agreement of sale. My lord, if it, my lord, lands in the, my lord, hands of the police, lord, there is every chance, my lord, the document would take a different turn. That's our apprehension. So therefore, my lord, court ought to have heard us, my lord, at least before, my lord, passing.
No, if the court has, if an opportunity is given to you, but ultimately the document in the, for the purpose of investigation has to be handed over to them.
No, not necessarily, my lord. There could have been, it could have been postponed. It is not that, my lord, it has to be, my lord, delivered.
No,
Let
but
court is the custodial agents.
Suit for specific performance, it will go on for years together. Till such time the criminal prosecution cannot wait.
Correct. My lord, nevertheless, my lord, the statute provides, my lord, certain safeguards to be taken, number one. Number two, my lord, court could have recorded evidence, marked these documents, and then, my lord, it could have been, my lord, kindly appreciate it's an unregistered agreement of sale and certain receipts are there. We also claim, my lord, it's the originals that were handed over to us. They also claim another set of originals. But such a situation, if the documents were to land in the hands of the police, my lord, a civil nature, my lord, after the suit is filed, my lord, they go before the police, my lord, and lodge a complaint.
So the court has simply given it to the.
Absolutely, has not heard us at all, my lord, on the matter at all. Had it been the fact, my lord, with great respect, I would have, my lord, explained to the court, my lord, what is the circumstance the matter is placed and how, my lord, the safeguards could be taken, my lord, if the documents are handed over to the police. So such an exercise having not been done, my lord, I am before this honorable court, my lord, questioning the order.
Their only objection is no opportunity was given. They were not notified before handing over the to the police. Police is not, state is not made a party to the writ petition. Now, Your Lordship may kindly see, along with this one, I have produced the order sheet of the trial court in the vacating, along with vacating stay application. This order, they are not relevant order, they are not produced, and represented this court that no opportunity was given to them, which is
Yes.
factually incorrect.
Statement of objections.
Vacating stay application, madam.
Dated?
Dated, kindly come to ink page 32.
Your
That is
vacate
12/1/2006
petition
order,
filed-
26 order. Beg your pardon. 10th February 26.
Hmm. In 10th February, there, just objections, statement of objections.
Memorandum of
Yes,
application.
yes, it's there. Page number?
In the ink page number 32, madam.
2.
That is order sheet dated 12/1/26, madam.
Hmm.
On the left side, there is a, in Kannada it is there, Police Inspector J.C. Nagar Police Station, Bangalore Nagar Ivaru, Manavi Patravannu ಸಲ್ಲಿಸಿದ್ದು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ್ದು. That means a requisition was filed by the Police Inspector J.C. Nagar Police Station to the court, and that has been placed on record by the office. On that day, now Your Lordship may kindly see a previous order, I will just skip it, I may put 33, Your Lordship may kindly heard both the sides. Sorry, in 32, last two lines, my lord. Police Inspector by name Chaitanya KM JC Nagar Police Station, who is the investigation officer in crime number 172 of 25. The copy of the requisition given by the Police Inspector of JC Nagar Police Station is brought to the notice of the learned counsel for the plaintiff. Brought to the notice of the learned counsel for the plaintiff. Heard both the sides. IO has mentioned in his requisition that the documents are required for investigation, but details of the documents are not given. IO is directed to specifically give details of the documents required for FSL examination. The learned counsel for the defendant number 2 files so and so. That may not be very relevant. Now, Your Lordship may kindly come to the next day order, 21/1/26, madam. On that day, page 34 bottom, heard both the counsel. Since the criminal case has been registered, it is just and proper to hand over the documents requested for investigation. IO has mentioned some of the original documents filed by the plaintiff in his requisition dated 14/1/26 as they are required for FSL examination. Office is hereby directed to hand over the said documents which are kept in safe custody on proper identification and after taking due acknowledgement and keeping certified copies of the same in the record. Police Inspector is hereby directed to produce the same back before the court, all the original documents immediately after the completion of FSL examination. Vis-a-vis this, now Your Lordship may kindly the writ petition order sheet what they have produced is at page 101. And page 103 and 104 is produced. That's all, last day. And order has been challenged. So, as far as this court is concerned, all the facts are not placed before the court before taking such a
Impugned order is at Annexa A, my lord, that's separately filed. Let him not mislead. Annexa A, my lord,
What
separately.
are all the submissions that you have made? There is an answer in the order that's no he has read.
No, my lord. It is not like that. My lord, I shall clarify. I shall clarify.
I'm sorry for the interruption because I should bring it to the notice of Your Lordship. Now, as my lord, learned friend also submitted, matter is insofar as injunction application is concerned, matter was taken up to Supreme Court. Matter is pending in the Supreme Court. In the Supreme Court, the matter has been referred to mediation, which I have to bring it to Your Lordship notice because when the mediation is referred by in the same matter is referred, no court will not pass any orders. So therefore, after 2 weeks, a date may be fixed in this matter, and after that it may be taken. This is a short point for consideration. And tomorrow is the mediation.
1st of July. Interim order only granted is extended.
Number 29.
Petitioner, my lords. Suit for injunction, my lords.
My lord, one date may be fixed. This is the point.
1st of July.
1st of July.
Yes.
At the time of when I had filed, the trial court had made it a prima facie case, and an ex parte interim order was
This
granted.
non-compliance of office objection.
Office objections, my lord, this was filed during vacation. I need to furnish certified copies. In my respectful opinion, my lords, the matter is day before the trial court on 12th of June, my lords. If the parties they filed their objections to the IA, they told that they'll be filing written statement on 12th also. If it may be disposed of up to maintain status quo until 12th, I am ready to argue before the trial court.
Where is impugned order?
Impugned order is annexure A, my lords. At page 23, my lords. My lords, the gist of the matter is ex parte interim order was granted in my favor. I, along with the suit, plaint, all the documents, annexures, and also the IA 39(1) and 2, I serve it upon them, my lords. There's a typographical error in the compliance affidavit. The OS number is wrongly mentioned. I admit to that. What happens? But that did not prevent them. Apologies. But that did not prevent the defendant, my lords, to come on.
This is the order 23.
Yes, my lords.
Look at it.
Yes, my lords. Case advance called out. SHC advocate files wakalat on behalf of they advance it, my lords. That earlier date was 3rd July. They advance it. They find out about it on e-courts and they advance the matter.
Let me understand what it is.
Defendant has filed application under section 151 CPC praised to vacate the ex parte interim order due to failure of compliance. On perusal of the affidavit and documents, it shows that the compliance notice is issued by the plaintiff on his counsel. On perusal of the said notice, it appears that OS 582 is mentioned instead of 278. And also perusal of the document, plaintiff has not mentioned the case number in the copy of the plaint. Counsel for the plaintiff clears time to file objections. Learned counsel of the plaintiff is present and files application under 151 for extension of TI. Upon discussion, this court.
Yes, whatever the injunction order that is there, let it continue. You go, let the court decide.
On the 12th, it is there, my
The application, my lord. Kindly see the order. The mandatory provisions, my lord, has to be followed, my lord. Court page 136 of the order, your lordship may kindly see for.
Page 130.
Page 136 of the order, my lord, which was previously granted in
That's
the
the impugned order. I mean, the injunction ex parte TI granted in my favor.
1 minute, sir. Page 136, your lordship.
130.
6. The defendant is restraint order came to be passed. Second para, TI is granted till next date of hearing. The plaintiff shall, this is to be noted, shall comply. No, my lord, they did not comply, your lordship. Therefore, we filed application. They did not file any objection to the said IA. On that day when the application was filed by me, even today, they did not file any application. They issued this honorable court. Yesterday it was there. Status quo order producing the status quo order. Yes, my lord, that's the reason.
It is not the case, as I admitted, my lords. It's not the case that I have not complied. It's a typographical error. Even otherwise, my lords, there was a stay granted by this honorable court during the vacation. Yesterday, my lords, we went and produced the copy of the order before passed by this honorable court.
Instead of
what the trial court told was, okay, the matter is pending before the honorable high court, so I'll have it.
Having taken an interim injunction from the court, why you are not complying with the?
My lords, I have complied with it, my lords.
What is not complied then?
Only the OS number is wrongly mentioned. That's all. The order sheet reflects that. Yes, my lords.
No. That's
If
not
my
the
lords
one.
may kindly see there, the annexure page 23, my lords.
Here, case number was also wrongly
that's what it is,
mentioned.
but
Here
he's-
was also wrongly mentioned.
That's all. Those are
And
the only
served
two
the
things.
copy.
The documents have been served upon him.
Deliberately, it was done, your lordship.
Please come.
And para 2 of my objections I have stated so, my lord.
The petitioner has come.
Today, they have not filed any objections.
The petitioner has come before the court. Agreed with her. Agreed with the order of the court dated 2/5/2026, whereby the court has failed to extend the interim injunction that was granted, directed the matter to be listed on 1/6/2026. This petition is filed during the vacation. The court, while passing the order, has observed that on perusal of the notice, it appears that OS number 582 of 2025 and also perusal of the copy of the document, it appears that plaintiff has not mentioned the case number in the copy of the plaint. Counsel, and it is observed that the counsel for the plaintiff placed time to file objections. Counsel for the plaintiff is present and files the application under section 151 CPC for extension of the temporary injunction, which was rejected. Then counsel for the petitioner submits that it is a typographical mistake where the name of the court Name of the court or number of the?
Number and
OS
year.
number, my lords.
Number and the year, your lordship.
Number
Case
and,
number and the year.
number,
Court number
I
also
respect
not
with
mentioned.
submission, my lords.
number of the case.
Court name is also not mentioned. Court also
Case
not mentioned.
and the court name are not properly
Yes.
mentioned. And according to the petition, it is a typographical mistake. It is submitted that the matter is coming up before the court. If the earlier interim injunction order is extended, as the petition is having the benefit of the same, as the same is granted during the vacation by this court, they will, as respondents of the defendants are filing their written statement, the matter can be, the court can consider, the court can go ahead with the parties can go ahead with the matter before the trial court. When counsel appearing for the respondent defendant submits that petitioner intentionally has served a copy which do not disclose the year and the number of the suit and also the name of the
Court and the court hall.
Huh?
Court designated court and the court hall.
Court and the court hall. It
Hall.
is submitted that this has been done only with an intention
Yes.
to cause the intention to cause inconvenience to the defendant so that they will not be able to know where the matter is pending and what is the case. The court has rightly not extended the injunction as there is no compliance of Order 39 Rule 3A and B of the CPC. It is submitted that there are no grounds to interfere with the order passed by the.
The objection is also not filed, your lordship, to the
Lords, I
IA.
have
You have filed
objection.
an
I
IA.
have paid time for
Let him
objection.
say what he wants.
We have filed an IA, your lordship, to that effect. They did not comply with.
What IA you have
IA
filed?
may not to extend the interim order because they have not complied with the
It is
mandatory
submitted that they
provisions
have
of
also
law.
filed an
I have
IA.
once, I have relying
Not to
upon one
extend
judgment,
the
my lord.
That objection was also not filed, your lordship.
And no objections are filed for this.
Even today.
I've sought time. The trial court did not grant time. He told I'll.
Then having heard the counsels on either side, there is a material on record. When the interim injunction is granted and the court has directed the plaintiff to comply with Order 39 Rule 3A and B of CPC, the plaintiff ought to have complied with the same. It is the submission that it is only the court name and the number. It's not properly mentioned. It's a typographical mistake. When a notice is issued to the party without mentioning the court name, case number, and the respective court designated court hall, then the plaintiff cannot expect the defendant to come to the court with to file his written statement and other objections.
May I make one submission, my lords. My lords, even otherwise, my lords, the matter was posted for 3rd of July. Even assuming that I was at fault, it did not deter the defendant from checking the matters on e-court, advancing the matter to the 2nd of May, and then filing an application. It is not that he appeared on a later date or he was placed ex parte, my lords. He advanced it. The order sheet also reflects the same.
Why should he do all that exercise?
My lords, I apologize.
That's what. That is what.
One submission, my
You
lords.
have to hear what is the further order is.
Certainly, my lords.
What did you write?
No correction.
The plaintiff ought to have complied with the provision and ought to have been more careful in serving the documents which do not contain the particular details. But thereafter, the petition has come before this court, and this court has granted an order of injunction.
Status quo, your lordship.
Status quo has been granted. Considering the fact that during the vacation, petitioner is enjoying an order of status quo, at this point of time, this court is not inclined to go into the aspect of whether the petition is entitled for extension of the order or not, considering the fact that the matter is slated before the trial court on
12th of June, my lords.
12th of June 2026. This court is passing the following order. There shall be an order of status quo till further orders are passed by the trial court. The parties are the court shall consider the application what application you have filed?
The holdings have been already erected. That's what they say, your lordship. In the
No,
injunction.
no, anyhow, the status quo order is there.
151 application they filed.
File your IA for vacate that the
No,
court
on that day,
consider.
they have to file objections, my lord. They have not filed objections, your
I
lord.
will file it on
The
12th, my lords.
respondent by the next
For
date
that,
of
before that,
hearing.
let them serve
To
copy.
the
and-
IA
I'll
that's
serve it, my lords. I'll
to
serve
the
it, my
IA that is pending filed by the defendant, the plaintiff shall file his objections.
And they have to file written statement, my lords.
By the date, the respondent shall also file the written statement. The trial court shall consider the same in accordance with law.
Deep regulation, my lords.
Goes on.
This observation will not come in the way, my lord may
Any
say.
of the observations made by the court?
Yes, my lord.
The court has not expressed any opinion
Yes,
on the
sir.
merits of the matter. Hence, none of the expressions shall be construed, none of the observations shall be construed as an expression of this court, and the court shall dispose of the matter in
And
accordance with law.
Independent.
Yes.
Let the 30 M for petitioner.
Yes.
Let the IA filed or permission to file the writ petition. Petitioners are the not parties in the original suit and the FDP proceedings and execution proceedings. But petitioners are the affected parties from the execution court.
IA
Now
number
they,
1026 seeking permission by the advocate. What is the order impugned?
in this case, the petitioners are not parties in the partition suit and the
No,
FDP
that is
proceedings.
correct.
Yes.
What is the order that you are assailing?
But in this survey report and execution court appointed the surveyor to identify the petitioner's property as per the FDP proceedings. But the petitioners they purchased the property 2015 by way of the sites farmed by the one society. It is 30 acres of the land as purchased the society as part of the layout. But the petitioners purchased the sites, the 2000.
No, what I'm trying to understand is, have you?
Now their execution.
You can't approach the executing court?
Right, we are not approaching their execution court. What happened, my lord? The execution court now there proposed to recover the possession with the police help of the petitioner's property. Kindly see the bailiff as.
What I'm saying,
But-
if you are not a party to the proceedings.
Yes.
And by virtue of a decree that is passed, if the executing court is doing something, you have no remedy to file any, you can't file an objector petition before the court.
Now there, the urgency is my lord. The execution court has appointed their surveyor and bailiff has submitted the report. Kindly see the
The
report.
moment you file an application, everything will be settled. Not
Even though that report placed before the execution court, kindly see page number 23. He has submitted the report. There was a.
as you understand,
Malad,
a lot
they-
of inquiry is required to be done by the court. That you
Malad,
cannot expect the high
But
court to do it.
there was a farm the layout, the property of the execution, the FDP schedule and the present schedule cannot be identified. That is the report.
Those are all on the merits of the matter.
But
You have to file an application before the court objecting for such execution.
now the execution order, kindly see what happened. The order is
Whatever is the order, we are not on the merits of the matter. You have a remedy before the trial court. Why do you want to come before the court? And to appreciate what is your right, an inquiry has to be done by the court. That you can't expect this court to do.
last the order in 37 page number. Execution court last they closed the execution case and accepted their reports. And it is a contrary to the bailiff report. Bailiff report is they submitted to the execution
Only
court.
one question you please answer. Can you go before the trial court or not? Then other things we'll appreciate later. You have a remedy. You have a remedy which is an effective remedy before the trial court, before the executing
And
court.
liberty may be granted. I will.
The present petition is filed.
And matter is before the execution court is tomorrow, my lord.
Let it see. An IA is filed seeking permission to file this petition, to file this writ petition. The petitioner, who is a third party, is aggrieved by the survey report dated 16/3/2026 in execution case number 23 of 2023, pending on the file of the first additional senior civil judge and JMFC at Devanhalli. And also petitioner has questioned sought for quashing of the notice, quashing of, it's a A1 is a survey report.
Survey report.
Quashing of the survey report dated 27/2/2026. And also Annexure C is,
C is the execution petition, my lord.
and to quash the execution petition number 23 of 2023. When counsel for the petitioner submits that the petition is the third party and by virtue of the orders impugned, no, they're going to take possession of the petitioner's property. Petitioner or the land counsel for the petitioner has also argued on the merits of the matter. This court has specifically asked the land counsel for the petitioner, when he has a remedy before the executing court, to file a petition objecting the execution when he has come before the court. The petitioner argued on the merits of the matter and how the orders are bad and how it is going to have an impact on the petitioner. Be that as it may, this court is not inclined to consider any of the submissions on the merits of the matter. When it is a case of the petitioner that, under the guise of a judgment and decree passed by the court, a property belonging to a third party is being the third party, the position is being taken, and he has every right to go before the court by filing a petition, and the court would consider the same by conducting the necessary inquiry, and bypassing the said remedy, he cannot come before the court, and this court cannot entertain such a writ petition. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the executing court.
Please.
All IAs stands closed. Yes.
Cell number 31.
Lords, 31, I am for the petition. Can I request your lords may take up this matter also on Monday, my lords? Because
It's Monday.
please.
Cell number 32. 32. Santosh Kumar.
Lord, this matter, my lord, on the last hearing, a coordinate bench, my lord, had directed him to serve copies on me.
No representation. This is matter for dismissal. Any interim order in this?
No interim order.
This is matter for dismissal on 2nd of July.
Please.
Cell number 33.
Yes.
Ganapati CV. 33.
I am appearing for the petitioner, rejecting the application under Order 39 Rule 1 and 2. Initially, injunction was granted by the trial court. Then again, after appearance of the parties, it was rejected. And session court is also confirmed by lordship that order.
Let's look at the order in MA.
Order in MA at page number 45.
I think it's a small order. Let's read from the reasoning part.
Please. What happened, my lordship?
Let's read this order, then you can make your submission.
Enter MA order, my lordship.
Yes, paragraph number 9.
Please, my lordship. May I read, my lordship? For the sake of convenience and in order to avoid repetition, as all the points are interlinked, they are taken together. The main contention of the plaintiff is that he is in possession of the social property since 11 years. Further, it is the contention of the plaintiff appellant is that the father of the defendant number 1 executed an agreement of sale dated 6/6/1988 by receiving the sale consideration amount of 1,375 and handed over the possession of the social property to the plaintiff. Since 6/6/1988, the plaintiff is in possession of the social property and he was preferred his title with respect to the social property by way of adverse possession. Perusal of the records reveal that the plaintiff has not produced original agreement of sale dated 6/6/1988 before the trial court, and the said agreement is an unregistered agreement. Further, it is the contention of the defendants that the plaintiff is not the owner of the social property. It is contended by the defendant that the boundaries mentioned in the social property is not correct, and from the said boundaries, it is difficult to identify the social property. It is further contended that the plaintiff and his children are trying to encroach upon the properties belonging to the defendants. In this regard, the defendants have filed a suit against the plaintiff in OS number 73/23 before the Principal Civil Judge Court, Osnagara, and the said suit is still pending. Further, it is pertinent to note here that the plaintiff has filed instance to declare that he has become the owner of the social property by way of adverse possession. In the IA number 1, the plaintiff has sought to grant the relief of restraining the defendants from obstructing the use of road by the plaintiff situated in the social property. It is pertinent to note here that the description regarding the road in the social property is vague. No photographs or other documents are produced to that there is a road in the social property and the plaintiff is using the same reach his land. Further, it is settled principle of law that an interim relief can be granted only in aid of final relief. Then there is a judgment referred, my lordship.
Yes, I've
And,
seen it. Let's go to the trial court order.
Yes, my lordship. My lordship, kindly see page number 43.
40?
43. Para number 20, 21, 22.
Reason starts at page number 40.
43 is three paragraphs are important.
Let's read from 40. Whether the plaintiff applicant has made a prima facie case. You're seeking injunction restraining them.
Not obstructing them by using of the road situated in the social property. What happened? May I have to read? Page number 40, my lordship.
12, let's read from 12.
Please. It is relevant to point out that the social property is land bearing survey number 49, new 49/1, measuring 11 gunta, situated at M. Guddekoppa village, Kasababali, Hosnagara Taluk. According to the plaintiff, the shared social property is bound on the eastern side by land bearing survey number 57, on the western side by land bearing survey number 47 and 48, on the northern side by land belonging to the defendants, and on southern side by land bearing to survey number 47. The suit property is also mentioned as social property to the present application. The plaintiff has placed reliance on the unregistered agreement dated 6/6/1988 entered into between the plaintiff and Sri Veerbhadra Pagoda as the basis for him to claim adverse possession on the social property. According to the plaintiff, he has delivered title over the suit property by way of adverse possession ever since 6/6/2000. That is 12 years from the date of said unregistered agreement. It is relevant to mention that the plaintiff has not furnished original agreements relied upon by only photocopy of the agreement dated 6/6/1988 are furnished. There is no mention any road existing on the suit property specified in those agreements. The plaintiff has not furnished any document to indicate existence of the road on the suit property. The present suit is filed to declare that the plaintiff is the owner of the suit property by way of adverse possession. Consequently, a decree of injunction is sought restraining the defendant from causing interference in the plaintiff's possession and injunction over the suit property. Even in the prayer of the plaintiff has not sought to declare about the existence of road on the suit property. The relief sought in the IA is to restrain the defendant.
You are seeking an injunction with regard to a road.
Please.
Now, according to you, by virtue of an agreement of sale, you have perfected your title by adverse possession. And that agreement of sale do not mention about, there is nothing about this road mentioned there. And what is the other document to show? That's the only document.
Please.
Basing on that you want. And the main relief is that. And the interim relief, you say that I should be permitted to use the road without there being any document.
Madam, I make one submission.
You have to at least place something on the for the court to show that you have been using that road from a long time.
Madam, I make one submission. What happened after 1998? The intention of purchase property is only that to form the road. This is a private road. We have no document to show that there is a road in the scheduled property. That is our difficulty, my lordship. And what is my submission is, when the application was filed under Article 13 Rule and 2, the honorable courts must consider that whether I am in possession or not. But
how will that now? But your possession is a different aspect. Your road is a. Now you have asked some relief which is unconnected with your main relief.
But what happened? I have filed for declaration. They are also filing suit for injunction against me against the very same social property. After when the matter is their suit is listed for plaintiff evidence, they filed an application to withdraw their suit by saying that we are not in possession. They are not in possession. I am in possession. Therefore, they intend to file a suit for declaration, asking me to hand over the possession of the property. That itself shows that I am in possession, my lordship.
No, when you file a suit for declaration of title,
please,
and basing on adverse possession, if your interim, your IA injunction is not to interfere with your possession, we can understand. Now we say about they should not interfere with you using the road. In that agreement of sale, there are no boundaries. There is no road. Where from the court will grant?
Yes. I should kindly see the page number 59.
This order will follow.
My lordship, instead of my lordship, I will permit it to file fresh application or directly to early disposal of my suit, my lordship, instead of dismissal.
Sure.
Huh?
Suit is of which year?
23, the already listed for plaintiff evidence. You know, our side,
23 suit, there cannot be the.
our side,
Apex court has time and again said that kind of an orders cannot be passed by the court unless and until it warrants special circumstances. Please call the password matters. Stop the
Password
list here.
matters?
I will not take up any other matter after this 33. Yes, call the password matters.
Password matters. List number 1, serial number 1.
My lordships, serial number 34, my lord, for the next matter. There is no stay in the matter, my lordships, but on the last date of hearing, the trial.
I cannot, now I'm making it very clear to the advocates, whatever is your urgency, what I can do, I can do. I can't take up all the matters. Whatever is urgent, everybody has urgency. So I will go in the fashion which I can do, and whatever matters I can dispose of, I can. Yes, one.
My lord, date may be given, the remaining matter date may be given, my lord.
They will be given. Yes, one.
Madam, I appear for the
So
respondent.
what you do is, today I have completed these many matters. Tomorrow's list, the first is the fresh matters. After that, the second list should start from this 34. It should start from 34. Yes. So it will continue. So now they have given 200 slips. Tomorrow add 200. Whatever I can do, I'll do, and the other remaining 200 will that will come on the top of the list next day. That's it. Yeah.
I am for the petitioner. I am for the petitioner in this case, matters. Whereas the
All those matters, in all those matters where, because anyhow they have not reached, the interim order need not be extended. Or look at it, if at all while you're writing, if there are interim orders, extend it till the next day.
Matters, respondent counsel has filed 2 IAS matters. I have not received the copy today, till
And why
today.
did you
Matters,
ask for a Passover in the morning?
morning matters, I took my mother to the hospital.
make a
Matters, my
submission,
colleague
Lord.
was there. Matters, he was the pressure. He was not able to
Statement
submit
is
the same.
factually wrong, Lord. I sent a mail as long as in 2025. The cover which I sent by register post has been refused.
Matters,
And I have produced a, please don't make a statement.
I have not
I have
received the
produced
copy.
documents.
Kindly direct them to serve the copy today itself, my lords. I will.
How can anybody refuse the document?
Please see the
advocate
cover.
can refuse?
Advocate refuses to receive
No,
it.
no, I have not
I have
refused
produced
the
it
copy.
along
my
with
lord.
my IM, Lord. The memo I have filed it.
That is unfair if you have
No, no, I have not refused, my lords. He is telling that, my lords, he is sent through post, my lords.
Lord, I sent my colleague to his office, he refuses to receive it.
Please, my lords, I have not refused, my lords.
I have sent
I have
by
not
mail
at all
also.
received that copy, my lords.
I have sent by mail also. You can take a printout if you want.
Take this, give it to him. He's not making some submission on.
No, no, you have produced
My lords,
the
I have not
document.
refused any copy. Even, my lords, after,
Look at it and then make submission.
my lords, after this, my lords, twice matter listed before the court, my lords. I have requested my.
Counsel.
Not 75 lakhs is the rent due.
It is returned here, my lords. My lords, this is the address written here, my lords.
It's not your
No
address.
mobile number has been written.
Is it your address or not?
Address is correct, my lords.
According to you, who signed it? Somebody signed it.
No, no.
You see the endorsement there.
My lords, this is written, handwritten, my lords. Not even put postal seal, my lords, for refusal. This is handwritten, this thing, my lords.
It's not in my hand.
Handwritten, my lords, postal, this
I
thing.
will
my-
take up this matter tomorrow, you argue.
I am ready, my lords. Let them to serve copies, my lords.
Tomorrow by 2:30.
I will take up, I cannot, you please
No,
see
then
that this is a.
My lords, one request, my lords. One request. Day after tomorrow, my lords. Day after tomorrow, my lords.
We'll take up day after tomorrow.
Please.
Whatever papers you want, you take it from him today.
Kindly direct them
And
to
don't-
serve the
You
copy.
also serve the papers on him.
I have served the papers, my lords.
Give him the papers again, a copy of it today.
I have served long
In
back,
fact,
my
I have
lords.
already
Is this
mailed it to
matter day
him.
after tomorrow, interim order earlier granted is extended, no further time will be granted? Yes, day after tomorrow.
Serial number 11.
I represent the petitioner in this case, my lord.
Yes.
Petitioner in this case, my lord. The respondent number 123 herein had filed a suit for partition and also filed application under order 39 rule 1 and 2 of CPC, my lord, seeking not to put up any further permanent structure over the suit schedule property, my lord. Lord, kindly see the impugned order past.
Where is the order in MA?
MEA, my lord, page 53, my lord, annexure G.
Concurrent finding by both the courts?
No, my lord. Divergent finding, my lord. The trial court has rejected the application on the ground of undertaken given by this petitioner for not to seek any equity of the construction over the suit schedule property, my lord.
Appellate court, what it did?
The appeal court has reversed the findings of the trial court, my lord, by allowing the appeal and not to put up any construction, my lord, without justifying the reason. My lord, already,
What is the case of the plaintiff?
my lord, the plaintiff, the case of the respondent number 1 to 3 are the joint family members. They are seeking a partition over the suit schedule property, my lord. Only one property is there, my lord, in the suit, my lord. The suit is pending, my lord. During the pendency of the suit, my lord, 2024, the respondent number 1 to 3 has filed a suit, my lord. Subsequently, my lord, in the year 2026, January in this year, they have filed an application for not to put up any permanent structure over the suit schedule property.
Who are you?
Your I am from
What is the relationship between you and the plaintiff?
My relationship is admitted, my lord, is my mother-in-law of the claiming who respondent number 1 to 3 are the my mother-in-law sons.
Your brother-in-law?
Lordship can
mother-in-law.
refer to page 15, the family tree, Your Lordship.
Where is that?
Page number 15, Your Lordship.
15?
15, 15, of their numbering.
Please, my lord. G3, page 15, plain, my lord. My lord, Bhagyamma, Narsimurthy, Manjamma are the plaintiffs, my lord, before the trial court. The Indramma is a second defendant who is a daughter of Ramaya. The Ramaya is no more, my lord.
Plaintiff and defendants or children of the siblings?
Please,
Yes.
please. My lord, kindly come to the my lord, trial court finding
In
para.
whose possession this property is?
I am in the possession of the property, my lord. I am in the possession
What is
of the
the
property.
construction that is making now?
My lord, 33 into 57 feet, my lord.
Hmm.
Suit schedule property is more than 1 acre, my lord.
Now, if the suit is pending till the next 10 years, and
Please.
ultimately if they succeed in the suit.
Your Lordship, I'm for the defendant, the plaintiff number 1 to 3. We had filed the IA for stopping the putting of construction at the initial stage when they were starting the digging construction. In their own statement of objection at the beginning of the IA, they have mentioned that they have not trying to put up any construction. But during the process of the IA, the later in the after stages, they're telling that they have constructed till the slab level. Then they're asking for the courts for intervention that there be they'll suffer insufferable loss.
They're not claim equities is what they said.
Sorry, Your Lordship.
They'll not claim equities.
Already,
afterwards they claim the equity, Your Lordship. But the trial court in their initial for equity, it's based on a wrong judgment, which the appellant court has rightly.
Come to that appellate court's judgment why it is wrong.
Yes, Lordship, point is para 13 of the 42, my lord. Page 42 of the trial court order.
Refer to page 68, Your Lordship, where the appellant court has.
Yes, start reading from 68.
Yes, Your Lordship, I'll read it from. The defendant number 2 has relied upon the decision of our Honorable High Court in MFA number 8364 2024 clubbed with MFA number 1261 2025 and argued that the same decision it is held that the construction will not affect the suit. With due respect to their lordship, I have gone through the ruling, but the facts of the said rulings are different from that of the present set of facts. Because in the present case, the suit scheduled property is ancestral and joint family property of the plaintiff and defendant. But in the said decision, the property is the Inam land and the defendant in the said decision was a purchaser. But in the present case, the
Can you come to 15, para 15, that is not relevant.
Yes, Your Lordship.
Please.
Para 15.
Yes, Your Lordship. On perusal of the documents relied by the appellant as well as the respondent number 2, on one thing is clear that the defendant number 2 has clearly admitted in written statement regarding the relationship of the plaintiffs with the defendants, and accordingly, the defendant number 2, Putama filed OS number 8722, but the plaintiff has not filed objection to the memo filed by Putama seeking withdrawal of the suit. But that does not mean the plaintiffs are not having any right over this suit schedule property. At this stage, the court has to see whether the plaintiffs have got any prima facie case for granting temporary injunction and whether the balance of convenience lies in favor of plaintiff and whether the plaintiffs will be put in to irreparable loss and hardship if injunction is withheld. Admittedly, OS 877/2022 was filed by the present defendant number 5, namely Puttama, against the defendant number 1, defendant number 2, defendant number 3, defendant number 4, and the plaintiff 1, 2, 3 of the present case, seeking partition separate possession of 1/3 equal share in the suit schedule property. And in the said suit, it appears that Puttama, the present defendant number 5, has filed memo for withdrawing the said suit, stating that she, along with the defendants, have settled the matter. But the said suit was not disposed on merits to come to the conclusion that the present suit is hit by section 11 of CPC, that is res judicata. However, res judicata is a mixed question of law and fact. At this stage, the court cannot conduct mini trial at the time of disposing application. In the present case, since the defendants have admitted the relationship with the plaintiff and they have also admitted that the suit schedule property is the ancestral and joint family property of the plaintiffs and the defendants have also admitted that defendant number 2 is constructing the building in the suit schedule property. When the suit is pending, the defendant number 2 has no right to put up any construction till disposal of the suit.
No, you are not in possession of the property. I mean, the plaintiff is not in possession of the property.
No, Your Lordship.
Defendant is in possession of the property. Isn't
Your Lordship,
it?
kindly.
Yes.
Lordship, kindly, trial court order, my lord, para 13 of the page 42.
No, without going into the order, as per the admitted facts, who is in possession of the property as on today?
My lord,
Defendant is in
admittedly, the second defendant is possession of the property, my lord. Now
Then if
constructed in
defendant is
defendant number 2, my lord. She constructed
Yes.
in the
Yes, Mr. Counsel. If defendant number 2 is in possession of the property, let him construct. No, he will not claim equities. You are not in possession of the property. If he makes a construction, it's a small extent of land. What is that? What is the prejudice that would be caused to you?
Your Lordship,
No, he'll not be claiming equities.
it's not just about equity, Your Lordship. The construction is only illegal, as they are not, it's agricultural land. They're trying to construct on the agricultural land without any permission. And we are 3 siblings who have 1/3 share. Again, we have to bifurcate that, and it's agricultural land. And if they're going to change the nature, we file the IA for stopping of the construction at the initial stage of digging only, Your Lordship. They, in their own statement of objection, they mentioned that they've not started any digging. But afterwards, they've told that they've built it to the slab level, Your Lordship. And now the construction at that level.
Your Lordship, kindly see the photographs
Come
produced
to
by
the
the.
plane. What is the land? Come to the plane.
It's just 1 acre land, Your Lordship. And again, after that, there's 1/9 share of each plaintiff. So
Construction is
again,
27 into 33 feet, my lord.
How many are the parties?
Sorry, Your Lordship.
How many are the parties? How many are there in the suit? Parties.
Parties.
1/3 share. 1/3 share. 1/3. They are seeking 1/3 share.
Plaintiff and 2 defendants.
Please.
Annaya has 3 children, Your Lordship. And plaintiffs are the defendant of one of the daughters of the
1,
Annaya.
2, 3, 4, 5, 6, 7, total 8.
No, my lord. 1/3 share, my lord. They are seeking only 1/3 share, my lord.
We 3 plaintiffs together get 1/3 share, Your Lordship. Again, we have to
1/3 share.
bifurcate. The building is very difficult for us
No,
to
in
bifurcate.
1 acre land, he is not constructing.
27 into
But
33 feet, my lord, only.
So what is the extent?
27 into 33, my lord. In that effect,
What I'm
they have
saying,
filed a
what is the
affidavit.
extent of it? How many square yards it would be?
27 into 33 feet, my lord.
Entire
for south.
extent of land is 1 acre.
Please, my lord.
So you're
Within
constructing in a part of it.
1,000 square feet below, my lord. Below 1,000 square feet.
I have to seek instruction if my senior.
Let it be, let the construction go on tomorrow.
Not in
This
the
is
main,
fine.
in the meanwhile.
For judgment tomorrow.
Your Lordship, there's already IA stay on the matters. Let the stay be there till the next. The stay is already passed by the lower court, Your Lordship. There's no stay on the IA.
Tomorrow I'm saying you get instructions and pass orders.
Chair number 13.
Tomorrow I'll dispose of this writ petition itself.
Tomorrow,
Get instructions. But I'm making it very clear that let him continue with the construction. If you're entitled, there is a remaining vast extent. It's just a part of it. It is 4,000 square yards. It would be if it is 1 acre. It's only in a part of it is doing it. Yes.
13, PP Sidramaya.
That second defendant's writ petition.
Which one?
This writ petition is filed by the second defendant. That first respondent has filed suit for partition and separate position. Where we have filed the written statement and our defense is already there is a partition there 1972 and property is not available for partition. Secondly, all the family members were not made as party to the proceedings. The first respondent has examined himself as PW1 and he is tendered for cross-examination. At the time of cross-examination of PW1, an application was filed by a GPO holder to prosecute the case through GPO holder, not from the plaintiff. To avoid the admissions of some of the admissions, we have filed an objection stating that GPO holder is not having personal knowledge of the family affairs and that plaintiff has participated in all proceedings even before the police station and also before the revenue authorities. He has personally appeared.
First you tell that.
At page number 59, Mother.
Yes.
Our main contention is he appeared for examination in chief. To avoid the admissions, he has executed the GPA to prosecute the case and he has not produced any document.
This GPA holder, this is allowed.
Allowed.
You are agreed by that.
We have agreed by the same. We have filed this writ petition. Our main defense is he appeared before the court for examination in chief and to avoid the cross-examination, he has executed the GPA, stating that he is suffering from ill health. No documents were produced to show that he is ill health and is not able to lead evidence personally.
Notice to the respondents.
Interim order, my lord.
Petition is permitted to take out hand summons. I'll give a short date. Petition is permitted to take out hand summons.
Yes, please.
Go on and file a memo to the defense by 23rd. If it is filed on 23rd, list the matter on 24th. Yes.
My lord, notice to R2 and R3 may kindly be dispensed.
Give the memo.
I will file memo.
Memo is filed seeking dispensation of notice to R.
R2 and R3.
R2 and R3. Then notice to R1 and
R1. R1 is the
R1
sole
alone.
plaintiff. Yes, please.
R1.
Cell number 20. Mohan Chandra P.
My lord, plaintiff's writ petition. Suit is one for permanent injunction filed by the plaintiff, my lord. Along with the plaintiff has filed a IA under order 13 rule 1 and 2 CPC for temporary injunction not to interfere with the suit schedule power against the defendant. After hearing the trial court issued an emergent notice stating that I have not made out a prima facie case. Your lordship kindly see page number annexure M, page number 77. Plaintiff
Matter is coming up on 9/6. It's coming up on 9/6.
Yes, because the defendant is interfering every day. He is disturbing your position.
Court will decide. 9/6
It is
will
status
not.
quo order may kindly be.
No, not status quo. Please come. The writ petition is filed. Questioning the order of the court. Questioning an order that's passed on 16/5/2026, whereby the court has issued only summons to the defendants without considering the application filed by the petitioner seeking injunction and directed the matter to be listed on 9/6/2026. Then counsel of the petitioner has argued the matter on the submitted on the merits of the matter and how what is the inconvenience that is caused to the plaintiff by the order of the court and not in only issuing summons but not considering the interim application. Considering the fact that the matter is coming up on 9/6/2026, this court is not inclined to go into the merits of the matter. And accordingly, this court is passing the following order. The writ petition is disposed of, directing the trial court to consider the petitioner's application expeditiously. No notice is issued to the
time may fix, my lord. Otherwise, prolong the matter.
unnecessarily if I fix the time limit. If the court wants to do it early, you will be at.
Because they will
expeditiously, I said. Yes, next.
Then list number 2, serial number 4.
Not serial number 4, my lords. My request for tomorrow, my lords.
This matter, please, lordship, writ petition itself is not maintainable.
No. Lords, the appointment of commissioner, there are 27 properties. There are
submissions.
I'll take it up tomorrow.
Tomorrow, please.
Let's start tomorrow.
Please, lordship.
Interim order may be kindly extended still today.
Interim order all granted is extended and all the matters, the remaining list will come tomorrow.
grateful.
And how many memos have come today? No, how many? Wherever the issue. Whichever are ready, you list the matters. And this is the procedure. Every day the matters also are done. From there it should start.
Lordship, item number 59, interim order may kindly be explained.
In every matter, interim order is there. It will be extended and it will come tomorrow.
List number 2, serial number 67, serial number 67, my lord. Maybe it permitted to withdraw the petition, my
Take
lord.
that.
67, my lord. We have become infectious, my lord, permitted to.
Last kindly.
67. List number 2, my lords.
66.
67, 67.
7, a memo is seeking to withdraw the petition, dismissed as withdrawn. Yes.
Please, 61, my lord, may kindly be taken up during next week, no? List 261.
The other side, have you informed?
Other side.
My lord, I pray for my lord, I pray
Is
for
there?
my lord, respondent in this matter. In fact, my lord, they gone before the writ appeal court and writ appeal, my lord, there is a stay in this matter. So, my lord, have it next week, my lord, we'll make our submissions.
61.
61.
61 next week.
My lordship, list to 36, list number 36, including applicants rejected.
So it will come tomorrow.
Eleven ಕೊಡಿ 61 11 ಆಯ್ತು ನೆಕ್ಸ್ಟ್ 11 ಕೊಡಿ 11 ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ಬಿಟ್ಟು ಅದು 16 ಕೇಳ್ತೀರಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೇಳು ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಫ್ರೈಡೆ 12th ಆಗುತ್ತೆ ಫ್ರೈಡೆ ಇಲ್ಲ ಸರ್ ಫ್ರೈಡೆಗೆ ನಾವು ಯಾವುದು ಡೇಟ್ ಕೊಡಲ್ಲ ಇದೊಂದು ನಾಳೆಗಿದೆ ಎಲ್ಲ ನಾಳೆ ಇದನ್ನು ನಾಳೆ ಎಲ್ಲ ನಾಳೆ ರಿಪೀಟ್ ಸರ್ ಯಾವ್ದು ಇಲ್ಲಿ ನಾವು ಮತ್ತೆ ಇನ್ನೂ ಕೇಳಂಗಿಲ್ಲ ಇದು ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ರಿಮೈನಿಂಗ್ wherever the madam is passing the other matters are repeated tomorrow on the top of the list of list number 2.